Hey guys, so we're going to be doing two trials today. We're obviously entering jury instructions for the Nicholas Kassotis trial, which means we're going to be on verdict watch. I don't know how long I think they'll take to deliberate. If we hear them ask to replay some of those police interviews, we could expect that it might take some time, right, to get through those. So we'll see if there's any jury questions. We'll be on verdict watch for that after we listen to instructions. But in the meantime, while we're watching, we're going to watch a Fulton County case. It's a 1998 Thanksgiving murder. It was a cold case for a while. And Symone Hylton is one of the prosecutors. So I thought that'd be interesting to see. Not sure if she's going to do opening statements, but we'll find out. So we're going to do a little, obviously put the Kassotis news first because it's instructions and then obviously a question or verdict. But we'll fill the waiting time with the other trial. So good to see everybody. Yeah, it's a 20-year-old case. There's a little bit of a background story in the description. We'll talk about it after we get through the Kassotis instructions. Good to see everybody. And Dizzy shared an article, so thank you, Dizzy. Dizzy shared an article there on the cold case. It's Christopher Wolfenbarger is the defendant, and it involved the death of his 21-year-old wife, Melissa. Melissa is also the daughter of a convicted serial killer, and I think they initially thought maybe it was related, but her father was in custody at the time of her death, so it couldn't have been him. So very interesting stuff already, right? But hey, you guys, when we get through instructions, I also have I want to give you guys my thoughts on why I think the prosecution has a huge win here and how they, I think, knew they had a great attorney on the other side and tied things together in closing, but barely hinted at it in opening. So I'm excited to share with you guys my thoughts and my props for the prosecution in this case. Let's get into these instructions, though. Oh, maybe I should boost the volume.
Are also on this 01, the USB that the state has used during the course of these proceedings. Located on this are the electronic data that could not have otherwise been given in a physical form. There are also exhibits on here that I have articulated throughout the course of the trial, including the exhibits I used to refresh recollection, search warrants, things of that nature. Counsel and I have reviewed it. There is nothing on this USB other than what was used during trial. Counsel, do you agree to that?
That's correct, Your Honor.
Right. We've also gone through all of the physical evidence, Your Honor, meaning the exhibits and the documents. There are four exhibits that have been removed. They are 1.109, 1.111, 1.110, and 1.117 because they were demonstrative only. Okay. I have talked to counsel about the evidence in terms of the forensic crime laboratory reports, as those could be considered continuing witness. Counsel and his client have communicated. They have determined that it is in their best interest to submit those to the jury and that they do not wish to have them extracted. They wish them to go back.
State agrees?
I don't have an objection, Judge. They're welcome to go back to the jury. Okay. That would include the autopsy, all the reports from the DNA analysts. That would include the reports from the toolmark expert, as well as the other experts in this case, toxicology and so on. And counsel, is that correct?
That is correct.
And that was after talking to your client as well?
That is correct.
All right, very well, then those exhibits will go out to the jury.
Thank you, Your Honor.
The only question we had somewhat, Judge, was physical evidence. There are things like bloodstain cards, things of that nature. Counsel and I have talked about it, the totes themselves. Those things were touched by the crime laboratory and obviously are still potentially not something that they should potentially get without maybe some interaction with the court. So we're going to ask that all of the documentary and physical, like photographs, things of that nature, can go back with them. I don't have an objection or need a note for that. But if they wanted to, for example, see the knives or to see the totes or something of that nature, that they would just need to send a note to the court and ask to see them. Is that correct, Counsel?
Yeah, we're in agreement on that, Your Honor.
All right. Thank you.
Thank you.
Thank you.
All right, anything else before we bring the jury in?
No, Your Honor.
Nothing from the state.
All right, let's bring a jury in.
All right, we'll skip them bringing in. And guys, by the way, there were also two I submit to yous during the state's response to Doug's motion for a directed verdict. So I think our total is 96 total I submit to yous. Just to update the final counter. All right, so there we go.
I'm going to have the court reporter hand you the verdict form that we've put together in this case, just to have a look. Here's one for the state. Yes, sir. All right, everyone, please be seated. Good morning, ladies and gentlemen of the jury. Good morning. And I'm required one last time to ask if you were able to abide by the court's previous instructions regarding access to media. Did we have any problems? No. All right, then I will now read you the law that applies in this case. Ladies and gentlemen of the jury, you are considering the case of the state of Georgia versus Nicholas James Kassotis. And this is Bill of Indictment number 2024 R67 in the Superior Court of Liberty County, Georgia, the February term of court 2024. And the grand jury has indicted the defendant with the following offenses: Count 1, malice murder; Count 2, felony murder; Count 3, aggravated assault; Count 4, concealing the death of another; Count 5, possession of a knife during the commission of a felony; Count 6, possession of tools for the commission of a crime; Count 7, possession of tools for the commission of a crime; Count 8, possession of tools for the commission of a crime; Count 9, possession of tools for the commission of a crime; Count 10, possession of tools for the commission of a crime; Count 11, removal of body parts from scene of death; and Count 12, tampering with evidence. Now, you will recall at the beginning of this trial, in fact, in jury selection, the entire indictment was read to you. I'm not going to do that again, but I want to remind you that your oath requires that as you deliberate and go through each count, that you read the entire language that's inserted in each of those counts. So, ladies and gentlemen, the defendant has entered his plea of not guilty to this indictment, and the indictment and the plea forms the issue that you have to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with the presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering unsettled, or unsatisfied, then that is the doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. I charge you that facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raises a speculation or conjecture of the defendant's guilt, is not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to the case and instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law given in this charge to the facts as you find them to be. Your oath requires that you will decide this case based solely on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses, any exhibits admitted during the course of the trial. Evidence does not include the indictment, the plea of not guilty, and the opening or closing statements made by the attorneys or questions asked by the attorneys. Evidence may be either direct or circumstantial, or it can be both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witnesses' manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average person. The law permits expert witnesses to give their opinions based upon their experience and training. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all other witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of the same witness that was made before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pre-trial statements and testimony when compared to the same witness's testimony at trial. As with all issues of witness credibility, You, the jury, must apply your common sense and reason to decide what testimony you believe and what testimony you may not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. I charge you that a statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. To be voluntary, a statement must be freely and willingly given without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you must also consider to what extent the defendant was informed of his rights, as discussed below. The burden of proof is upon the state to establish that the statement was voluntary. That is, it was freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. Number one, the defendant has the right to remain silent. Number two, if the defendant chooses not to remain silent, anything he says could be used as evidence against the defendant in court. Number three, the defendant had a right to consult a lawyer before any questioning and to have the lawyer present with him at all times during any questioning. And number four, if the defendant did not have money for a lawyer, that a lawyer would have been provided for him to represent him before any questioning and to be present with him during questioning. The burden of proof is upon the state to establish that the constitutional warnings were mentioned and that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of the witness and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find that the defendant was properly informed of these rights and that he understood and gave up those rights, then you would disregard the statement entirely and give it no consideration in reaching your verdict. Ladies and gentlemen, evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparisons is dependent upon many factors. Among the factors are the credibility and accuracy of the witnesses who were involved in the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy, and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparisons in your decision in this case. The defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of act and intention. Intent is an essential element of any crime and must be proven by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but it simply means the intention to commit the act that is prohibited by law. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such an inference or inferences is a matter solely within the discretion of the jury. I charge you that a jury is not authorized to find a person who was merely present at the scene of the crime at the time of its perpetration guilty of consenting in and concurring in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. Members of the jury, the law of our state sets a time limit upon the state in starting prosecution in most criminal offenses. The accused is on trial for the offense of malice murder and felony murder, and under Georgia law, prosecution for these offenses may be commenced at any time. The exact date on which the murder took place is not a material element of the crime of malice murder or felony murder because there is no statute of limitation for those offenses. Prosecution for all other felony offenses included in this indictment must begin within 4 years after the offense has been committed. Prosecution for any misdemeanors included in this indictment must begin within 2 years after the offense has been committed. If you find from the evidence that the indictment in this case was not filed within the required number of years after the offense was committed, it would be your duty to acquit the defendant. Now, ladies and gentlemen, the law provides that criminal actions shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proven in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Liberty County, is a jurisdictional fact and must be proved by the state beyond a reasonable doubt as to each crime alleged in this indictment. Venue must be proven by direct or circumstantial evidence or both. Criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. If it cannot be determined in which county the cause of death was inflicted, Venue is proper and may be proved in the county in which the death occurred. If a dead body is discovered in this state and cannot be readily determined in what county the cause of death was inflicted, venue is proper and may be proved in the county in which the dead body was discovered. Ladies and gentlemen, I will now charge you on the offenses that are alleged in this bill of indictment. Count 1 alleges malice murder. For malice murder, the state must prove the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Ladies and gentlemen, count 2, the defendant is charged with felony murder. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault is a felony, which I will define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. I will now charge you on the elements of aggravated assault. For aggravated assault, the state must prove the defendant assaulted another person with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. An offensive weapon is an object that is likely to cause or actually does cause death or serious bodily injury if used against another person. The presence of an offensive weapon or the appearance of such may be established by circumstantial evidence. The state is not required to admit into evidence the offensive weapon used by the defendant in order for the defendant to be found guilty of the offenses of malice murder, felony murder, or aggravated assault. I will now charge you, ladies and gentlemen, on possession of a knife during the commission of a felony. For possession of a knife during the commission of a felony, the state must prove that the defendant had a knife with a blade at least 3 inches long on his person while committing a felony, which is one of the following: a crime involving another person, concealing death of another, which is a felony, which I will define for you shortly. And I will now define for you the elements of possession of tools for the commission of a crime. For possession of tools for the commission of a crime, the state must prove the defendant possessed a tool or device commonly used to commit the crimes alleged in the indictment and intended to use the tool or other device to commit a crime. With regard to the charge of possession of a knife during the commission of a felony or possession of tools for the commission of a crime, the state must prove that the defendant possessed the knives or other devices at issue in this case. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the knife, tool, or device. Constructive possession means that all times of the alleged offense, the defendant may not have had direct physical control over those knives or devices, but that he did knowingly have both the ability and the intention to exercise control over those objects. Now, ladies and gentlemen, in count 4, the defendant is charged with concealing the death of another. I charge you that the state must prove that the defendant concealed the death of another person, which hindered the discovery of whether that person was unlawfully killed. In count 11 of the indictment, the defendant is charged with removal of body parts from the scene of death. And I charge you that it shall be unlawful for any person to remove from the scene of the death or dismemberment of any person or any human body part thereof. Now, with regard to count 12, where the defendant is charged with tampering with evidence, I charge you that a person commits the offense of tampering with evidence when, with the intent to prevent the apprehension or cause the wrongful apprehension of any person or to obstruct the prosecution or defense of any person, he knowingly destroys, alters, conceals, or disguises physical evidence or makes, devises, prepares, or plants false evidence. Now, ladies and gentlemen, after considering the testimony and evidence presented to you, together with the charge of the court, if you should find and believe beyond a reasonable doubt that the defendant in Liberty County, Georgia, did commit the offenses as alleged in the indictment, you would be authorized to find the defendant guilty of that offense, and in that event, the form of your verdict would be, we, the jury, find the defendant guilty. However, if you do not believe the defendant is guilty of an offense alleged in the indictment, or you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. By no ruling or comment that the court has made during the progress of this trial have I intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the accused defendant. Your verdict should be a true verdict, based upon your opinion of the evidence, according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts of this case objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice for or against either party. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment, and you are prohibited from discussing any potential sentences in this case. One of your first duties in the jury room will be to select one of your members to serve as the foreperson. He or she will preside over the deliberations, and he or she will sign the verdict, to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's point of view. Each of you must decide this case for yourself, but you should do so only after a full discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are
This judge
convinced
hates
that it
noise
is
in his
wrong.
courtroom.
However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors. You are not permitted to conduct any research. You are not allowed to consult any other materials. And I don't believe that you'll have your phone, so I don't think that's an issue. So whatever your verdict is, ladies and gentlemen, it must be unanimous. The verdict must be in writing and signed by your foreperson, dated and returned to be published in open court. Now, ladies and gentlemen, we have prepared a verdict form that you'll be able to use. You will also have the indictment that fully sets forth all 12 counts. So as you go through the body of the indictment, you can read count 1, you can read through the entire language that is set forth in the indictment, and then you'll see that the verdict form says, "We, the jury, in the above title action find the defendant, count 1, malice murder." And there's a block that you can check not guilty or guilty. And it's the same for all 12 counts. So after you have reached a unanimous verdict, and it has been signed and dated on the back page by your foreperson, you would then simply knock on the door, tell the bailiff that you have reached a verdict, although you would not disclose what that verdict is. Then we would bring you back into open court where your verdict will be published according to law. Now, there are going to be a lot of exhibits that will go out with you. These large boxes, the large boxes of physical
The
evidence,
tubs back there.
we're not going to send those out with you at this time. But if you feel that you need to observe or look at those objects, if you would just simply write a note to the bailiff, and we'll be happy to bring you back out so you can take a look at the object that you wish to see. So I'm going to allow you to go back to the jury room at this time, but you will not begin your discussions and deliberations until you receive the indictment, the verdict form, and all of the physical evidence that will be sent with you. So you are excused at this time.
Here we go. Start the clock. Start the clock. So as they go into deliberations, we're going to flip over and watch a bit of this Fulton County case where Symone Hylton's one of the prosecutors. I don't know much about the background except it's a cold case from 1998 around Thanksgiving. The woman's head was found in a trash bag, so she was presumably decapitated, in like a dumpster across the street from where her husband worked. So it's her husband that's on trial.
All right, everyone, please be seated. Let the record reflect the jury's now out. Ms. Bayo, on behalf of the state, are there any objections to the charge of court?
There are no objections to the charge or to the verdict form, Your Honor.
Mr. Weinstein.
The defense also has no objections to the charge or the verdict form.
All right, thank you. So we've already reviewed all the exhibits. They're in proper order. I assume we can go ahead and have them sent out to the jury.
I don't dispute that, Judge. I know normally it's the court's practice to have 2 separate rooms for alternates to not be with the jury. I know we didn't put it on the record. I just want to make sure that that's
Yeah.
very clear.
It is, and I've got their names. Let me get the.
Mr. Weinstein?
Mr. Miller.
I just wanted to make sure.
All right, so, oh, they're back. That was quick.
The 4 alternate jurors.
Oh, now we're gone. Oh my goodness. Well, we'll be a little nosy for a second here and see if they pop back in. And they're muting us because they don't want to say the jury information and identify anybody out loud. So that's why they're muting us right here. Not a big deal. I like watching them though. And Neri's predicting a longer verdict just because the case was confusing even though they think guilty. You know, and this is also the first chance they really get to talk about things. What do you think the first thing they're going to say to each other? Because then they have to get back there. They have to figure out the process they're going to use. They're going to decide, like, hey.
We're just asking that they stick around. I asked Mr. Weinstein.
I
assumed that.
I'm going to let them, always let them stay.
I know, Judge. Thank you. I appreciate that.
All right, then we'll be in recess until we have a verdict.
Thank you, sir.
Or a question. It'll be interesting if they have questions. And I agree.
Yes, sir.
If you
KP.
respond, and this doesn't.
KP says, I bet it's a relief for Doug working with competent and decent prosecutors. I mean, the biggest criticism I have for the prosecutor is, you know, I don't like the yelling thing. I don't like the dramatics. It's just not my style. Maybe in the right moment I do. But, like, yelling at the jury, I don't love that. Like, I just don't love that. And then some of her questions, she would be asking questions and the witnesses would be confused, like, you already asked me that. So, a little rough there. But nothing she did indicated to me that she was trying to be malicious in any way. Although the investigators, which are still part of the state, it does, I agree with Doug's arguments that they looked where they wanted to look and didn't look at much else. In fact, they could have looked a little bit better to find better evidence against Nicholas Kassotis. It's not even that they weren't looking to see if somebody else did it, but they could have found more evidence to show, like, hey, we looked for his car for the 2, 3, 4 days before that covered the entire time range. And the only time his vehicle's there is this time. We looked at 1 or 2 other Jim McIntyres that could have been close enough by to do what Nicholas Kassotis was saying. We asked to look at some of these messages and communications to see if we could trace to somebody who's pretending to be Jim McIntyre, but perhaps actually had a different legal name so we could look for that person. They basically just said, this guy looks like a kook and Jim McIntyre is made up, so we're not going to try to do much to show that he is in fact made up. So, but yeah, at the end of the day, I still think it's enough for the jury to be like, no, it's too, his story is too incredible. So I think that's a lucky turn for the state. Also, you know, just, it's really disappointing to hear these repeated requests. You know, we have several witnesses come up. The witness that did the expert that did the toxicology. She's like, you know, I sent in these requests. We had several other witnesses say, we sent in these requests. And then we had very adamantly and almost annoyed Tracy Sands on day 6 on cross-examination. Well, I made the request. Well, did you follow up? You're the lead on this, so you should be the one making all the follow-ups, if anybody. And he just very passively passed the buck to some other random ether, as if somebody else should have gotten GBI to do the work for him without him doing the follow-ups. And I don't love to hear that, and it just reminds me of other cases where GBI doesn't seem to do they don't seem to do the testing or follow up on things they're supposed to do. So there's that. Also very excited to see future Miss Martin in the building. Guys, let's future Miss Martin 2.0, if you guys are familiar with Potentially Criminal, who I always describe as being an actual lawyer that I learn a ton from. She says, I heard this case was insane. I'll need to go back and watch on replay or Big Sean to cover it. Hope you and everyone in chat are doing well. So right back at you. So good to see you. And yes, this case is insane. Chat, I would love if Potentially Criminal covered this. Because he's going to rip into the state when the state doesn't do what they're supposed to do. I'm sure he'll have great thoughts on Doug's reaction. Like, you guys remember Doug trying to get the judge, like, yes, judge, please ask questions of my client and make sure he actually is sure about his decision to testify. He's a criminal defense attorney, a practicing criminal defense attorney, so it'd be very awesome to see his reactions. Am I covering the Julio Fulio trial? I am not. Although I wouldn't be surprised if that's like widely covered. I imagine Law and Crime Court TV will probably get in there. And are they doing that? Are co-defendants being tried together for that, or is it separate trials? Okay, so, and then the Honorable Josiah, love the name change, says, hope so. One of the trials starts Monday, so it's separate trials, I think, yeah. So, I don't think I'll have the bandwidth to be streaming next week, plus there's a lot I want to cover next week. Tuesday next week, there's 3 different hearings that I'm going to be looking at. Courtney Clenny, the biggest one, because it's like the first time there's forward motion in that case. And maybe we'll get a tentative trial date for Courtney Clenny, finally. That happened. Christian Obumseli was killed in April 2022. And we still don't have a trial date for Courtney Clenny. So, huge shout out to Love Taybiz TV. Does anyone think the jury will get hung on any counts? Or are we calling... Why is the camera shaking? Maybe someone just kicked the camera. Does anyone think the chat. Can you imagine if they come back with a question right now? Does anyone think the jury will get hung on any counts, or are we calling a clean sweep of guilty? I think it's going to be a clean sweep, and I'd written in the chat, I think it would be, if you get a clean sweep, it's going to be, oh, maybe it was inflammatory, people were just doing it for victim sympathy. But if you let them get a win on, like, one tool charge, well, no, they clearly thought about everything piece by piece, and they asked to make a determination on what they wanted to find. So, I don't know. I think it'll be a clean sweep, though. And Taybiz, also big thank you here for gifting 5 memberships. If you guys turned green today, make sure you say thank you to Taybiz. We're going to be hanging out with him later in the evening. I think 6:45 Eastern is the time. I'll correct that in a second if it's wrong. Yeah, 6:45 p.m. today. We talked about it a little bit yesterday. He's going to be looking into a possible preacher or pimp situation in Letcher County, where we've got all these weird layers going on that seem to be coming to light after this Mickey Stein shooting of Judge Mullins. So that is the link to the live. Hit that notification button. And if you guys are looking to get caught up on Julio Fulio, there was a pretrial hearing yesterday. That factual lie. Oh, Bailey's just linked. I'm just going to start saying both names. Michelle says defense lawyers across the U.S. are about to get a recent example recent and decent example as to why their clients should consider not taking the stand. I think, I'm sure Doug gave great advice and guidance to his client, and the client was just adamant that he wanted to get up there and tell his story to his own demise. But I think, in part, I hope this is a lesson to the accused. And when I say the accused, it's not just like, I'm not saying I want people to be able to dismember their partner and get away with it. What I'm saying is, in general, the more you speak to police in these interviews, even if you swear you're innocent, you didn't do the thing that they're telling you you did. So you think you can voluntarily say whatever you need to say to help them out, help them find whoever did the bad thing to somebody that didn't deserve this thing, right? Maybe you think you're being helpful, so you want to talk. It doesn't end well. When do we ever see that ending well? When does that ever end well? And then in court, taking the stand, you already had these interviews played for the jury. So the jury got to hear your voice. The jury got to hear that you're a person. And, you know, my own thoughts, I felt like there was a part that was notable where he did seem to express some sorrow or grief. Whether genuine or not, I don't know. But the chat picked up on it as well. So there was even a moment where there's sadness or remorse expressed from this police interview. And the jury's allowed to look at the demeanor of the defendant through these interviews. And seeing that bit of demeanor could have been humanizing. And they could have left it at that. I understand why in other cases where we want to hear from the defendant, we don't know who they are, we haven't heard from them, they're just sitting there quiet, and it's dehumanizing. But if you have your defense attorney, you know, telling people your name, your story, doing a good job to make you feel like a person, because you are a person, and people get to hear your voice through other evidence, I don't really see the reason for him to take the stand. There was nothing that he needed to get on the record. He did it because he thought his story wasn't being told the way he wants it to be told. So that's gonna backfire. My favorite witness or defendant taking the stand trial is Travis Rudolph. And in part because it was self-defense, I do feel like he needed to get up there, even though, you know, you had the brother that could say, Travis ran up behind me, someone was pointing a gun at me when my brother fired. You can get that on the record. But you had Travis Rudolph get up there saying that he was in fear for his brother's life. And I thought that was extremely helpful. So, and again, Travis Rudolph didn't get up there and say, you know, I went back in the house and Jim told me I need to go out there and follow after my brother down the road. You know, there was no other weird layers in the Travis Rudolph case. Yeah, Elysiu is one of my favorite trials. Brandy Churchwell did an interview with the Travis Rudolph attorneys right after the trial. It was awesome interview. It's probably like deep down in the trenches, but I'm sure if you guys search Brandy Churchwell's channel, you guys could find it. Awesome interview. And I believe they mentioned during that interview, they were taking on a case, a false accusation case where there was like a police law enforcement type convention where they get together and do trainings. And I know you guys love thinking of the gang training conventions that we heard about in the YSL trial. But everyone's on vacation. They're staying at these hotels. Their client ends up like sleeping with someone they meet at the convention. But the woman ends up being married. So she's another officer. She's married. The husband finds out about it and is pressing her about it. So then she comes forward and makes a rape claim. And they're representing the client who's now facing criminal charges for this rape at this convention. And during that interview, they said the state never went and got surveillance footage from the hotel. So this is why, you know, we hear heinous accusations, but then we hear, oh, the government's just going to charge people without looking for the most obvious piece of evidence you would think to go look for. So that was I think the Travis Rudolph attorney team, great attorneys. I didn't see the outcome of the case they mentioned during that interview, but they probably want to check out if you guys are looking for other attorneys, other cases to check in on. Let's see. Where is... Now, Grace had sent over a clip that we're going to watch right before we get into this Fulton County case. Let me pull that up. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . .
I'm tired.
Good morning, Mr. Copeland.
Good morning.
You have permission to approach?
No. She's asking me that, Mr. Copeland, okay? All right. Okay. Councilors, you want to? Yeah.
So the number is not broadcast, and I'm going to move it to 31258.
All right. Oh, y'all still going?
What a time. What a time.
I'm tired.
All right, so let's get caught up. We'll get on over. Oh, hey, wait. Oh my gosh, what's this judge's name? This judge looks familiar. I forget her name. And now it's not showing her face. Yeah, thank you, Grace. That was one of the, like, funniest moments I think people reference often. Woody saying you can't approach the I'm tired. Kraus. Yeah, there. Look at the chat go. The chat knows all the trivia. You all know it. Yes, Brittany. The Ashley Merchant document lawsuit. All right, so this is the defendant.
Okay. Madam Court Reporter, you ready? Yes. Okay. This is going to be day 3 of the trial.
All right, so we're gonna boost the volume because this is super quiet.
Trial of Christopher Wolfenbarger, case number 24 SC 004201. I'll note for the record that we seated our jury yesterday and that they are filtering in ready for a start time of 10 a.m. Mr. Wolfenbarger is present here in the courtroom along with his counsel, Mr. McDermott and Mr. Samuel, and the state's counsel, Mr. Fawcett, are also present. We had some preliminary matters that we needed to address this morning. I had wanted to follow up on audio and photographs that we were still working through in terms of what's going to be offered. Mr. McDermott, had you had a chance to get through those materials?
I have, and I emailed the Fawcett last night.
Okay. Do we have agreement on what's going to be offered?
We do not, Your Honor.
Okay.
I did take out photographs that defense counsel felt as though they were duplicative. I took out photographs that displayed the victim's skull. There's one that displays the location of the skull. There's several others that show different angles of it. I've eliminated those as part of my intent to show the jury the location and corroborate the evidence in the form of testimony. But this is a case where Ms. Wolfenbarger was, her remains were left. We know at least the extremities were out there in the elements for at least a 2 to 3 month period, because you have the skull found in April and you have the extremities found in June. And so that, just by the very nature of that, is going to lead to pictures that are less than pleasant. But there are only 2 photographs of her extremity that were located in the woods on that June date. Obviously, there could be several of those photographs, but there are only 2. The autopsy photographs, we have eliminated several, and the intent of the autopsy photographs is to show some of the tool marks. What we anticipate testimony from our anthropologists as well as our medical examiners say that they observed, they believe, some type of mechanical device, man action, that was used to separate the skull from the neck and the femur bones from the torso. And so all that's relevant evidence, and the markings on that show the jury the marks that will be testified to, as well as corroboration of the testimony. And I would submit to the court Davis versus the state. That is a Supreme Court case, 306 Georgia 140, 2019 case. Specifically deals with defense objections as to the gruesomeness or objectivity, prejudicial effect of crime scene photos and homicide cases.
Yeah, and I mean, and let me save y'all some trouble. I am not of the opinion that just because things are gruesome that they are somehow prejudicial. If they're relevant, then the court will conduct an analysis under the appropriate rule of whether it's overly prejudicial as is required. I think what I was hoping for is more to avoid accumulation, right? And so that what you're presenting is the evidence that's necessary and relevant to your case, and not, let me show you 9 pictures of the same gross thing that we all really don't want to look at when maybe 1 or 2 would suffice. That's really all I'm trying to accomplish here. And if you're going to show 9, I want to make sure there's some particular reason that that's necessary and that I've conducted the analysis I need to ensure that it's not overly prejudicial if that's what you're doing.
Well, if I can split these up. And I'm
Sure.
gonna start with the autopsy photographs.
Okay?
If I'm looking at the autopsy photographs, the intent was to show each different section of the body that was discovered, as well as the tool marks that will be testified to.
Okay.
I do not believe there are any duplicative photographs of any one particular part of the body that was located. I don't believe there are any duplicative photographs of any of the tool marks as it relates to the images I intend to show from the autopsy photographs. As to the crime scene, obviously there are going to be photographs of what the crime scene looked like without the body there, because the body is, being transported, the remains. But it's important for the jury to have a context of where the location of the skull is located. There will be some testimony that they believe that there were dogs that were carrying the skull, or bag they believe the skull was in, from the wooded area where the extremities were located to the street where the skull was found. There's going to be testimony that that same dog had to be shooed away. And I think that as far as where the skull was found, where the sewer is, and the proximity of that to the job, I think is particularly relevant. And I think specifically as it relates to that Davis case, specifically crime scene photographs that are indicative of the location of where items, where relevant items are pertinent. And although they may be prejudicial, I hope everything that I present is, that prejudicial effect is not outweighed. I think that this evidence is relevant, and I think it is necessary for the jury to see some of the photographs. And I mean, I guess ultimately what I'm saying is, I don't have any issues taking direction from the court. I'm a fact finder, so if you independently feel as though a certain portion of the photographs don't need to be played, that's fine. But what I got from the defense, I think, was limited in what they were willing to agree to. I didn't feel like that was representative of the case.
Okay. Thank you, Mr. Fawcett. So, Mr. McDermott, let me ask a couple of questions as you begin your argument. So, I'm assuming for your record, you want to state your objection to all of them. Is that fair?
No.
No. Okay. Well, then, because really what I'm trying to get down to is if we assume that some universe of those photographs are going to come in, then what I'm trying to get to is what are the particular aspects, which particular photographs do you object to and why?
Well, I sent him the list last night. It's my understanding he was going to submit all that to you and
Okay.
go through them one by one. But really what he described is actually what my point was. I'm not objecting to showing a head in the road as it was found. I mean, that's obviously relevant and important to the crime scene. As far as the discovery of the limbs a month later, there are only 2 pictures of that, one limb and one black bag. Well, I take that back. There are a couple of other black bags. I don't object to those. When we get to the autopsy photos, I understand we need to show tool marks because they're going to testify this was assault, and we'll have a discussion about that. But do we need to see this is the left foot? No tool marks involved. Nothing about the crime scene. Nothing about cause of death. Nothing necessary to explain anything the medical examiner did.
So,
And then now the right foot. Well, let's look at the right elbow. Let's look at the left.
right. No, I understand that, Mr. McDermott, but I mean, setting aside that we're talking about body parts instead of one entire body, I mean, it is fairly standard to show for identification purposes, this is the body that was delivered to us, and after we cleaned it up, the condition that it was in. And usually the arguments I'm having are, but please don't show where you took off the front of their face to inspect their brain. And so I guess if that's the typical way that it's presented, then why would, here's the left foot, here's the right foot, here's the right arm, here's the left arm, here's the skull, at least those minimal baseline photographs, why wouldn't they be admissible? Why would they be overly prejudicial or not relevant?
I think the repetition of it, but in addition to that, we have multiple pictures of the bones after the flesh was, as we understand it, steamed and cooked off of it. That's not necessary for them to determine anything. The tool marks were visible without that. Why do we need pictures of the bones laid out in an array? So if we could just limit it to what is absolutely necessary to get it across,
Okay.
I think that would be helpful.
So to that end, forgive me, I'm going to let you continue making your record, but to that end, I think what needs to happen then is, Mr. Fawcett, if you have a list that was provided to you from Mr. McDermott, if you can just email that to me so that I can take this flash drive. Are the exhibits identified by exhibit number on this flash drive, Mr. Fawcett?
Yes, the exhibit numbers are listed on the exhibit.
Okay, so I should be able, what my intention is to go through and look at the ones where Mr. McDermott has asserted an objection where the parties don't agree, and then just go through, and then I can go through them one by one and provide you with rulings on their admissibility.
And let me just add, as far as the flash drive goes, it's one PowerPoint file, and the numbers of the exhibits correspond to the numbers of the slides in PowerPoint.
Thank you. That's very helpful.
I just also want this put on the record that there's I don't know what to call this. This is a printed out list of photographs that was included in the original discovery. I have never been able to find out who created this document, and we have never been provided with these photographs. There are multiple photographs clearly describing the crime scene where the limbs were found. And by my just looking at it, probably about 36 photographs. And I think that would actually be more helpful than the autopsy photos. But I would just love to find out who compiled this list so I could cross-examine it. And I've
Okay.
been asking for that for several days now. Don't get an answer, so
Okay.
put that on the record.
Mr. Fawcett,
Yes.
you're gonna email me the list that you and Mr. McDermott have exchanged?
Yes, Judge, I
Oh.
just did that.
Okay.
You should get that. And I think when we first started at the arraignment for this case, the court referenced how old the case was and how sometimes there may be documents that may not be able to be produced. When we first indicted the case, we went over to the Atlanta Police Department, the annex, to retrieve and physically review the files. Before the case was indicted, I went over to the Atlanta Police Department and reviewed the officer's original file. We did that again a month after the case was indicted, just to ensure that we were complying with the court's discovery request. I believe that was required for the end of that year, I think 2024. And shortly after that, we got requests from the defense. I offered for the defense to come to our office to view our discovery. I think after we had the motion to compel, I advised the court that I had offered them to do that. I made another offer to do that. And I made a third offer in writing, emailed to Mr. McDermott, I think maybe 3 weeks ago. Last week, Mr. McDermott emailed me and asked me what day would be a good day to come over and view our file. And my intent was to make the Atlanta Police Department lead detective's file available, Detective Shepard. My intent was to go back to the annex. I know how important this case is. Go back to the annex and look at it again. Part of doing as much due diligence as I could. I offered Mr. McDermott, I believe Tuesday and Wednesday of last week to come over and view it. When we talked, we discussed the discovery. We didn't discuss that date. I assumed he no longer was interested in that. But I've looked in every file that we've had. I've looked at the annex. I've looked at our digital files multiple times. And every document that we have in physical paper form and digital form has been turned over to the defense. I don't have any other documents.
Okay.
My complaint is not that I don't have enough documents or that these photos are missing. I can understand that that's the case. I just want to know who made this document and can I call them as a witness? And that's not unreasonable. They have access to Mary Beth Optel. They have access to T.R. Miller. They have access to all the investigators who worked on this back in the Calhoun days when this would have been created. And they can surely find out who created the list of photographs and their descriptions so that I could cross-examine them.
Get him.
And yeah, I did inform counsel that there were two investigators that were working on this case. It was Mike Alsip, whose name is in the discovery, whose name is on several.
Hang on, let me back up for a minute. Do you know, is the issue that you don't know who created that document?
I don't know who created that document, but I can say that.
Right,
There were
okay.
two investigators that could have created it.
Sure.
Mike Alsip, who was an investigator for the Fulton County Medical Examiner's Office, and investigator Tina Miller, who is on the witness list and going to be testifying, who was also an investigator. That's an investigative report, and then one of those two investigators made that report.
Okay.
I mean, I guess I can wait till she's on the stand and roll the dice. And
Well, have you had an opportunity? I mean, I assume those individuals were identified to you either specifically as people with information
Yesterday.
or on documents that were in the file in terms of reports that would have been provided through discovery of their involvement in the case.
I mean, they have been on the state's witness list. But
Okay.
as far as their involvement with these documents, I didn't know. I learned that yesterday.
Okay.
I still have time to try to call them between now and then, although I think T.R. Miller's scheduled to testify today. So.
Okay. So I think that if the state has identified that they don't know who created that document, but that it could be either of one or two people, and those people are identified as witnesses, or through their role were identified in terms of their involvement in the case, that they've been identified sufficiently for purposes of discovery, and that to the extent that one of them is going to testify, I don't think it's unreasonable for you to ask to, inquire with them before they take the stand. Hey, is this a document that you created?
Go ahead. those names were mentioned to me yesterday. I was not told, we don't know who did this. You'll have to pick from these people and find out for yourself. I was not told that they didn't know. I was under the impression that they were still going to try to find out for me.
Well, I understood from Mr. Fawcett's answer that he did try to find out, and he hasn't been able to find an answer, that it's got to be one of these two people.
Then there was
But-
some communication yesterday.
Well, Your Honor, I think co-counsel has a suggestion. I'll reach out to the original detective, Calhoun. I'll forward these to him to see if he can assist. He may have the name of a crime scene detective would have created that document.
Okay.
I'll do that.
Thank you. Anything else on the topic of photos for now, Mr. McDermott?
Not those photos.
Okay. Well, there were two sets of photos we were talking about. One was the list of photos that has not been produced to you, that Mr. Fawcett says do not exist as far as he's aware, digitally or in paper. And then there was the second set, which are the ones on this flash drive that I'm going to look at and rule on. I have now received Mr. Fawcett's email regarding the ones they intend to offer that I need to actually look at in terms of your objections. Any other issues on photographs that we need to address?
I'll just say yes because Mr. Fawcett just gave me this morning a stack of new discovery. And, well, about half of this is stuff that's old discovery, and about half of it is new discovery that would have been nice to have even just a week ago. These are cards and letters and photographs written between Norma Patton and allegedly Melissa. And, I mean, it's just dumped on us right before trial, so that's a discovery violation in my opinion. I've heard tale of these cards and letters for ages now.
I believe I heard you during pretrial argument say, where are those cards? Where are those letters, right? So,
Recently? Yeah.
yeah, on Monday during
Okay.
pretrial, when we were talking about statements
Well,
by.
it's nice to have an answer to my question. I agree with you. But it's still a discovery violation. That should have been turned over. If they existed, which they did, that should have been turned over a long time ago.
Okay, and we can talk about that when you're ready to talk about that. But those aren't photographs, and we're not talking about that just now.
Well, there are photographs in there. So.
Okay. But I'm assuming not the graphic ones involved in
Well, I was
Ms.
trying to be clear
Wolfenbarger's
that
death.
It doesn't pertain to the foreground. I'm sorry. That's my fault. And I'm being a bad boy. I just admit that's my fault. You said any other photograph.
Sure.
I made that jump. So.
That's fine. What about the audio of Mr. Wolfenbarger's statement? Have we agreed on the portions that will be played for the jury?
I think we have an agreement to the 80-90% of it. There's a portion we've agreed to start at 15 seconds earlier. I'm agreeable to redact and a part in the middle that counsel has requested. There's a part towards the end where the lead detective is asking a question and he is indicating his theory about where the skull was possibly washed out of because it was sprained the previous day.
The detective is saying that?
The detective is saying
Okay.
that to Mr. Wolfenbarger, and Mr. Wolfenbarger responds the way he does. But I think there's other evidence that the skull was likely dragged out of the wooded area. So the counsel is requested to redact it. I don't think it needs to be redacted. I think of scenarios where officers ask and make all types of statements to defendants to elicit a response or to see if there is a response. I don't view that as any different. If Detective Shepard and Detective Layton are asking Mr. Wolfenbarger a question, even if they are misrepresenting the crime scene. Courts have said that it's not to say that that was the intent of what was happening. Courts have even approved officers lying to defendants or suspects. So I don't think that this is a situation where that was taking place, but certainly, even if the crime scene was not in line with other theories, a question about that to the defendant shouldn't be excluded just because it may not line up with other theories. It still elicits a response from the defendant that I think would be relevant for the jury to consider.
Mr. McDermott?
Yeah, my concern with that particular statement is not that it's just some random theory of the detective. He's not telling a lie. There are some speculation in the early police reports that there may have been a weather event that washed the head out into the road. It clearly was picked up and used by later detectives. For example, Detective Shepard has used that theory when speaking not to Mr. Wolfenbarger, but to other witnesses as explanations for how the head may have gotten there. So clearly this is something that was important to the investigation, and they weren't treating it as a lie to try to get a reaction. And particularly Sergeant Layton's statement in that video is correcting or trying to help Christopher with his understanding at the time. And he says, it is my understanding that there was a strong flood of water that washed this out into the street. So that's how it got there. And he says it in such a way that I'm afraid the jury will take that as evidence that something happened. He says it in such a confident way that it's his understanding I think it will confuse the jury.
Is that individual going to testify?
There are two individuals there. The Detective Layton is not scheduled to testify, but Detective Shepard was there. He's on the video. He introduces himself to Mr. Wolfenbarger and is present throughout the entirety of the interview.
Okay.
So that was my second point I was going to make, is that Sergeant Layton is not on the witness list, and he's not going to be available to testify on that point. So I just don't want the jury to be confused about that. So at the very least, if we don't redact that, if the court would provide some limiting instruction on that point.
I'm not sure what the limiting instruction would be. It seems the reason I asked about whether the witness or some witness could testify about the circumstances of that statement, certainly with knowledge of the investigation, is that seems like a topic for cross-examination. In terms of whether that was accurate or whether you have information indicating that it was accurate. So I am going to the extent there was an objection as to that particular question, I haven't heard anything that would require it to be removed currently. The objection, as I said, is more subject to a subject for cross-examination of a witness that would testify about those conversations. Given that ruling, if we then have sort of a universe of agreed upon audio, if y'all can please reduce that to some secondary exhibit, which will be what's played for the jury, with only those items that either the parties have agreed or I have ruled will be admissible, that can play as continuously. And then, as I said, when we're ready to play that, I will instruct the jury that there may be, jumps in the video. There may be things, it may appear to them that things have been removed or that it's been edited and that's been done at my direction, and that they're not to draw any conclusions from the fact that things have been removed from the video or audio, and they're not to speculate about what might have been removed when it's time for that to be played. What exhibit is that going to be, Mr. Fawcett?
That is going to be, and I do have a list for the court. I just wanted to see what the ruling was. Let's see. That is going to be Exhibit 30.
And so y'all are going to have an Exhibit 30A, which is just the relevant portions that we've agreed on. Is that right?
You can do that, yes, Judge.
Okay, thank you. As I said, what I'm just trying to avoid I'm going to start it and stop it, and then I'm going to start it and stop it, and we just have something that we can agree to play. It is more efficient. Okay, couple of other issues. So I have spent a good bit of time with the forfeiture by wrongdoing issue that was raised by the defense. Specifically, I've already ruled that non-testimonial statements that Ms. Wolfenbarger made to family and friends, that those family and friends can testify about those statements. There is the secondary issue, though, was that there are statements, as I understand it, there are statements made by Melissa Wolfenbarger in court records in service of a TPO application and to police officers as part of, I think, an investigation into that initial event that occurred, I think, on Brookline Avenue, if I'm remembering correctly. And that those are, I think everybody agrees those are testimonial in nature, and therefore they implicate the confrontation clause. And the state's argument is that those statements, that Mr. Wolfenbarger has waived his confrontation rights as to those statements because of his wrongdoing in causing the absence of Ms. Wolfenbarger. So as I understand that provision, it isn't just that the defendant, that the state can demonstrate by a preponderance of the evidence for purposes of the application of this exception, that the state can demonstrate by a preponderance of the evidence that Mr. Wolfenbarger may have caused Ms. Wolfenbarger's absence. It's that they have to demonstrate that second piece, which is that the purpose of the causing the absence was to prevent the testimony. I don't have it up right now, but what I located, I looked at a bunch of case law. The most recent one I saw was from Judge Dillard in the Britton case. And I found that to be particularly educational, because what Judge Dillard does is spends about a paragraph explaining the circumstances of that witness going missing, and that was satisfactory to the Court of Appeals that the defendant may in fact have caused the person's absence. But then importantly, they add a sentence that says there was evidence in the case that the defendant had made a statement to, I think, a cellmate, that the defendant was not worried about that witness testifying. And I think that's the concern I have here, is that we have evidence that the state absolutely can satisfy by a preponderance of the evidence that Mr. Wolfenbarger may in fact have caused Ms. Wolfenbarger's absence. What I'm not sure I have is evidence other than potentially an inference from the circumstances, but that inference has to be reasonable to satisfy the preponderance standard, and I'm not sure I have enough. And so based on what I have heard so far from the state, I don't believe that they've satisfied the burden to demonstrate the forfeiture by wrongdoing standard. And so, as I said, to be clear, I believe they've satisfied and demonstrated by preponderance of the evidence that Mr. Wolfenbarger may have caused Ms. Wolfenbarger's absence, but I've not heard evidence that either establishes or from which the court could draw a reasonable inference that the purpose of that absence, the purpose of his alleged action in causing her absence was to keep her from testifying against him in the domestic violence or TPO matter that was pending at the time. And so that's going to be my ruling. Mr. Fawcett, do you want to make a record regarding that issue, sir?
Not necessarily, Judge. I accept the court's ruling. I do have several exhibits that are certified that are representative of that criminal case, such as the petition. There's a Rule 9 size setting the court date down. There's an order restricting contact, and then there's a request for dismissal by Ms. Wolfenbarger. I would still believe all those documents are relevant, but I would still be asking the court to allow the state to tender those into evidence. I would not be publishing the portions of those documents where Ms. Wolfenbarger's laying out the testimonial statements.
Right. Well, I'll hear from Mr. McDermott, but on its face, I agree with you that the existence of that case is not a matter, it is subject to a different hearsay exception that would allow potentially its admission, and it would seem to be relevant. But we were talking specifically about the statements of Ms. Wolfenbarger to officers and or in those documents. Mr. McDermott, your thoughts on that issue, sir?
Well, we would like to see his proposed redactions.
Sure.
What he wants to do and be able to talk about that perhaps over lunch.
Mm-hmm.
And go from that point.
Okay. I mean, I'm not ruling that they are admissible because no one's asked me specifically, but as I said, at first blush, I tend to agree with you that those would be relevant and potentially admissible under different hearsay exceptions. Anything else that, there was a motion in limine that was filed by the state, I think last night. And I need some help with it because I wasn't quite sure I understood what we're trying to limit. Obviously, we've understood for some time now that the fact that Carl Patton is a convicted murderer, right, was going to come into evidence in some manner, right, that was going to be an issue in this trial. So I'm not exactly sure what you're asking me to allow or to forbid. Can you help me, Mr. Fawcett?
And, so I guess it's laid out in the motion. This is, as of the past week or so, I think it kind of gives me some insight into what possibly could be asked or attempted to elicit during the course of the trial. And as I've laid out, the only reason why Ms. Alyssa Wolfenbarger's father is relevant for this case is because his arrest really jumpstarts the identification of her. And I don't know when she would have been identified, but for the infamous arrest of her father and him saying, "Find my daughter." That's pretty much what we've heard repeatedly by the medical examiners, the lead detectives, and everyone involved. But to take that information and now to attempt to introduce letters from Carl Patton, to what I'm trying to avoid is a relitigation of the case involving the flipper of a killer, because all the particulars of that case simply aren't going to be relevant for the determination of whether or not Christopher Wolfenbarger murdered his wife. So it's one thing to say, well, he was arrested. It may be relevant what he was arrested for, maybe, but outside of that fact, and the fact that that arrest triggered the identification, that's what the detective, Bruce Jordan, was the notifier to the medical examiner's office of that missing woman, Melissa Wolfenbarger. That triggered the retrieval of the dental records from William Brantman. And that was the comparison that made the identification. So outside of that, what other relevant parts of the case would be admissible? I don't believe that the statements of Carl Patton would be admissible. I don't believe that the particulars of the case itself would be admissible. So I don't believe that the defense should be able to ask Norman Patton, well, tell me how many people did he kill? Tell me the circumstances of that. How is that relevant for whether or not Christopher Wolfenbarger killed Melissa Wolfenbarger? It just is not. And I think that in particular is something that could confuse the issues in this case and confuse the jury.
Okay. Mr. McDermott?
We disagree, Your Honor. We think that the only point of relevance being that he helped them identify who she was is just the tip of the iceberg. There's an entire developed body of case law which has been even more developed recently by the Supreme Court regarding evidence of third-party guilt. This is a classic whodunit case. The state has only circumstantial evidence that Christopher led to the death of Melissa. We have substantial evidence that there could have been other people who were involved in her death. And the Supreme Court has recently said the standard for third-party guilt is basically going to be 401, 402, 403. And they have telegraphed that in their most recent opinions, even though it's not the precedent, I'll grant you. They've telegraphed that. They've said the test is going to be, if this evidence makes it likely, tends to make it likely, using the relevance, I got it top of my head, the rule for relevance, more or less likely that he's guilty,
right. Yeah.
then it's relevant. And then it's only a 403 test after that. Well, Carl
But they're
Patton's murders, it's not just he killed 5 people back in the 70s and that was it. It's why he killed people. It's his motives for killing people. It's who he killed, his friends and family. The way he killed them, wrapping them up in bags and dumping them in the river. It's the fact that he drove miles and miles to try to hide bodies. It's the fact that Norma Patton, who's going to be testifying here today, was right there hands-on helping him for 2 of those murders. She helped him. And what I intend to ask her about is only what she testified to in court. It's a certified court record that she helped. She helped plan the murders. She helped watch. She was in her living room. They shot the people. They fell. She helped clean up the blood. She helped carry the bodies out.
So let me stop you for a second and set what I think are going to be 2 signposts here before we get more granular, right? One is the fact that Mr. Patton exists, that he is a convicted murderer, that he, I think, was briefly considered a suspect, although my understanding is obviously the state changed its mind and decided that it wasn't Mr. Patton. But all of those things are relevant, and I think that the state can't limit the relevance of Mr. Patton's existence and his history, right? Like how it's relevant to Melissa Wolfenbarger as a general proposition. Also, certainly, I fully expect that if Ms. Patton, Norma Patton, takes the stand, that there will be a thorough and sifting cross-examination about her involvement as a credibility matter, right? And as a convicted felon or whatever, charges she pled to. All of those things I think are absolutely going to probably come into evidence. As a general proposition. What I'm concerned about is that part you were just talking about in terms of satisfying 403 from a basic relevance perspective, and to avoid getting too far afield of the issues in the case is my general feel is I don't really want to get into relitigating the circumstances of the murders that Mr. Patton committed unless you can show me the specific reason that they would be relevant to this issue. And right now, we're just having a general argument and you're just making a proffer, but that's what I haven't heard.
Well, I would reiterate the points that I just did. They're certainly relevant to how these bodies were disposed. They're relevant to who was killed and potentially why they were killed. There's evidence that Melissa knew about Carl Patton's murders, which is something he kept under tight.
But again, that's the fact of the murders, you're talking about the circumstances.
It's a motive for the murders, and it would be a motive for this murder as well. That's evidence of third-party guilt. It's relevant.
Mr. McDermott, I think we're talking past each other.
Okay, I'm sorry.
I'm not saying that you're right now,
Yeah.
as a baseline guidepost general proposition here, I'm not saying that I expect the defense is not going to talk about the fact that Carl Patton is a convicted murderer. And I'm not saying that you're not going to cross-examine Ms. Patton about her involvement and that sort of thing. I'm also not saying that the fact that he's a convicted murderer might have some relevance to this case and whether Melissa had motive or whether that might have formed some motive for Mr. Patton to be this alternate theory of the crime murderer, right? That's not what I'm saying. What I'm saying is I understand Mr. Fawcett's argument to be, it sounds like you want to go in and let's have a little mini trial about the circumstances of each of those murders. And that's what I'm trying to figure out. Why would anything other than the fact that he committed murder, right? Even the numbers, even the names, but why would the individual circumstances of those offenses, other than potentially some leeway to cross-examine Ms. Patton, Norma Patton, why would that be relevant?
Well, can the court help me out here? Mm-hmm. When you say, oh, I lost my point, I'm sorry.
Sorry.
In the last thing you said. Obviously, we would agree that the fact that he committed murder is relevant. But you're saying, what more than that is relevant? You're asking me what beyond that would be relevant in this case. And I think anything that okay, let me go back to the point. You're saying we don't want to relitigate this case. And you hear me trying to relitigate the Flint River.
Yes.
What part about me reciting the facts that are on court records in a guilty plea hearing, what part of that is relitigation? These are just facts about how those murders happened, what their motives were, who they killed. Those are facts on record, testified to under oath. There's no litigation happening. But those are facts on record that are relevant to the facts that'll come out in this case. And that is directly relevant to third-party guilt.
Okay. So, Mr. Fawcett, as I understand the state's motion, it was an effort to limit the nature and scope of evidence that will come in about Mr. Patton. Is that a fair general characterization?
Absolutely, that's correct.
Okay. So,
And let me just say this, if I may.
Sure.
I sometimes can miss things. but I don't know that we've received the transcripts that are being referred to by counsel.
Well, that's a different issue. Well, and when and if that arises, because I can't deal with all of these issues in a vacuum in the abstract, right? Some of these are going to have to come up in the moment, and that's fine. What I'm trying to do, which I think is the purpose of motions in limine, is to give the parties some general guidance about what's okay and what's not. And I think that Mr. Carl Patton's existence, history, and affect, the fact that he was a potential, even briefly a suspect, the fact that Ms. Patton was allegedly involved in his murders or in cleanup, whatever, right? Those things are fair game. And I think that that to the extent the defense, I think those things are going to be facially relevant and not overly prejudicial. What I am concerned about, though, is confusion of the issues and prejudice that might arise if we go too far into the granular details, absent a clear showing of specific relevance of those details into the details of the killings committed by Carl Patton. And so that's my general guidance to you, understanding that as we start asking questions and get into the back and forth of actual witness presentation, you may satisfy me that it's necessary for you to go into the particulars of one or more of the particular killings by Mr. Patton. But right now, in a vacuum, absent a particular showing, a more particularized showing of relevance, I'm saying stay up here at the 50,000 foot level, and let's not get down into the weeds unless and until there's a showing that it's relevant for your purposes in this case.
So just to be clear, what I've already mentioned about the motives, at least in two of those killings, to keep people silent who are going to talk about these murders, is that 50,000 foot level, or is that down in granular level, or where are we talking about? Because a general motive for killing somebody, it seems to me, would be directly relevant to this case.
So I think you're asking me to conduct a sort of quasi 404B analysis, right? In terms of, I understand Mr. Carl Patton doesn't have any 404B rights in this trial, but
also that's been specifically talked about in the case law.
I understand.
404 does not enter into the analysis at all.
I understand. I guess my point here is I've given you, I think, what are the general broad strokes. And so beyond that, I think you need to conduct your examinations of your witnesses in the way that you believe is necessary, and I will deal with individual objections as they arise. Again, my point is Mr. Patton's crimes, that they happened, that he was convicted for them, that Ms. Patton was involved in them. I think those are all, we're all expecting those are going to be relevant and discussed in this trial. I'm just trying to avoid getting down into the nitty gritty of it unless it's relevant and necessary for you. And if that's the showing that you're going to try and make, then I may agree with you. I'm just not going to do it right now. Okay. Anything else that we need to take up pre-trial?
Last thing, Your Honor. Good morning.
Good morning.
I know that there may be some witnesses that have criminal histories. I believe some may be older than 10 years. It is my understanding that we have not received any notice from the defense if they're going to try to impeach using convictions older than 10 years. And so I just wanted to bring that issue before the courts. I don't know if they exist or not, or if they plan to, but there needed to be notice if that was going to happen. And so wanted to kind of deal with that before a question comes out on the stand and we haven't addressed it, Your Honor.
Mr. McDermott?
Off the top of my head, I can only think of one that might be in that category. And in 1991, and it's not an impeachment issue, it's another third-party guilt. It's actually to explain one of the reasons Melissa ran away from home. And in 1991, her sister had a baby in their house. I don't know if it's unexpected. It certainly could have been unexpected, but she did it in secret. She didn't want to keep the baby or something of that nature, and tried to secretly dispose of that baby in a clothes hamper in their house. And we have the court records from that conviction. I'll finish the story briefly. Melissa is the one who found that baby, and she didn't know what to do with it. She ends up telling people at school, and then the police come. Long story short, Tina ends up getting convicted for concealing the death of another in 1992. I don't even really need to talk about the conviction aspect of it. I just need to talk about the crime and what happened to Melissa. And, you know, it was shortly after that 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 was the final straw for her. She starts running away from home regularly. So I do want to talk about that incident if it's going to be an issue with the conviction or whatever. I'm not bringing it in for impeachment purposes.
Okay. So two things.
All right, before the judge responds here, there's an irony here, right? Why is Hylton? We watched the YSL trial. Trial is taking place in 2024, but we were hearing about things that were like 2012, 2013. And Hylton's like, I just want to make sure the defense isn't going to try to bring in the criminal history to impeach witnesses that might be more than 10 years old. Like, I get why you might want to argue to keep that out generally, but it's just very weird coming from Hylton, the same prosecutor that prosecuted the YSL trial. But okay. And we're also dealing with a cold case. So if somebody had past criminal history that was 10 years old, Wouldn't it be particularly relevant in a case that is 27 years old? But anyway, let's get back to the Hyltoning.
I agree generally with Mr. McDermott's characterization that everything all the circumstances that led up to whatever conviction occurred might be relevant with particular witnesses or whatever. And the fact of the conviction, it sounds like, is not really his target. Although I agree with the state that if you wanted to talk about that conviction, then I think there are some notice obligations. That's number one. Number two, though, is setting aside the notice obligations from a substantive perspective. The purpose of the rule prohibiting convictions older than 10 years is because presumably they're stale. They're not particularly compelling or relevant to the veracity of a witness who's testifying now. But if we're talking about events that occurred more than 20 years ago, right, then the fact that they were convicted of something 22 years ago might be more relevant than it normally would if we're talking about a crime that happened last year and somebody wants to try and impeach or bring in evidence of a prior conviction from 10 or 15 years ago. And so that's my only concern. Ms.
Yeah,
Hylton.
I understand that, and I guess this particular incident, what I think the state is having an issue with is the relevancy of Ms. Tina Patton having a child and Melissa.
So forgive me, Ms. Hylton, for interrupting you. I'm not ruling that information is admissible. What I'm saying is that Mr. McDermott is not, to my ear, indicating that he intends to offer evidence of a conviction of that witness, which means there would be no notice obligation, number one. And number two, the issue about the substance of what he wants to offer, that I'm going to have to deal with that when it comes up. I don't know what the relevance is yet because I don't know why he would offer it. He seems to think that he has some facial basis to make a showing of relevance at the appropriate time.
Thank you, Ron. I definitely understand the notice requirement if that's his understanding. My concern now, hearing what he may offer it for once the witness is on a stand, is that we can't unring the bell once he asks whatever question he asks in a moment for me to object. If he asks, did you kill your baby and leave the baby at home, and then I object, that question is already out and for. So if he's going to use, I want to deal with it maybe in a motion and limine that's not relevant. But I'm not fully understanding all of the facts that he would like to bring in, since I'm just hearing about it now.
Mr. McDermott, why is it that you believe, I assume that you plan to go into that when Tina Patton is on the stand?
I intend to mention it in opening, actually, Your Honor, because one of the key issues running through this trial is Norma Patton's claim that she had a loving relationship with Melissa. And we're going to put up lots of evidence that was not the case. That Melissa wanted to come back home and Christopher wouldn't let her. That Melissa kept trying to leave Chris and come back home to them, and it's just simply not true. And we have tons of reasons why. And one of the reasons why that led to her initially starting to run away is the discovery of this baby. And that was the last straw. And I think it's going to be a testament to the abusive and foul relationship she had with the people in that home and her opinion of them. And that's all relevant to why she did not have a relationship that Norma Patton is going to claim on the stand that she did have.
Ms. Hylton?
Your Honor, because Ms. Wolfenbarger isn't here, some of this would be speculation on the part of anyone to say this is the reason why she left home. So we don't even have credible, I believe, evidence as to this is going to be the reason why she went home, or one of the many reasons why she went home. So now we're on a fishing expedition to ask questions that are speculative in nature, as well as not relevant in this particular instance as to whether or not Mr. Wolfenbarger killed or murdered his wife. I think we're now going to essentially try to muddy the waters in this trial to put in all of this extraneous evidence, and it's taking away from whether or not Mr. Wolfenbarger killed his wife. And so this particular evidence of a baby being killed in a home, or potentially being killed in a home, and this is the reason why she's running away, is speculation. I don't know who's going to testify to that. So when you start asking those questions, now you are bringing in issues that are confusing the jury without any clear evidence to that, Your Honor. So that is our position as to why the details of this particular incident is not relevant, Your Honor, in this case. It'll be speculative and it's not relevant.
Okay. I agree with you if the defense tries to argue or to get a witness to say, isn't that why Melissa ran away or whatever, that's argument, right? But if Mr. McDermott can establish facts that created what he's going to argue was a hostile home environment that would not lend itself either to indict the credibility of those witnesses or to demonstrate why Melissa wasn't there, I think that's fair game. But again, I would like to caution that there is a risk here of confusing the jury, of inflaming the jury with things that are extraneous, and we're all going to be very cautious about engaging in that endeavor.
Thank you, Your Honor.
Okay. Anything else?
Nothing, but I just emailed Ms. German for the Zoom link. I did intend on the use of PowerPoint, but
Okay. Ms. Johnson, if you can hear me, or Ms. German, if you could make sure that the lawyers have the Zoom link for today so they can log in. Last thing, Mr. McDermott, anything else you need the court to address pre-trial?
No, no.
Okay.
All right. All right, so they're going to get the jury in. Quick rundown on the case. We'll just look at a quick article. Don't listen for the next 30 seconds if you want to go in with a blank slate. But this is Georgia versus Christopher Wolfenbarger. It's being known as the killer's daughter murder trial because the victim's dad was a convicted serial killer. Let me pause because they're starting up in the court. Georgia man, so this is Christopher Wolfenbarger in the picture. This happened in 1998. This is him present day, and this is a picture from before 1998 of his wife, Melissa. A Georgia man is standing trial for the cold case murder of his wife, who was the daughter of a convicted serial killer. Wolfenbarger appears in court. Wolfenbarger was arrested in August of 2024 for the murder of Melissa. Her remains, including her severed head, were found in trash bags in April and June 1999. At the time, her remains were misidentified and weren't positively identified until 2003. Melissa disappeared in late 1998. At the time, Christopher claimed she left on her own accord and never returned, according to court documents obtained by Court TV. He told investigators he never reported her missing because he assumed she had just moved on with her life. Prosecutors said Melissa had filed for a temporary protective order against Christopher in July 1998, and she intended to leave him. Now, I don't know much more about this, but a TPO, I mean, usually you'd still have to go to court and show up. And if you just don't show up, that could be dropped. At a press conference announcing his arrest, authorities said Christopher was always a person of interest, but did not detail what led to his arrest decades later. Court documents state Melissa's remains were found, quote, directly across the street from where Christopher worked at the time. And it seems like we're going to find out potentially it's only her head that's found there and other body parts are found elsewhere. He was indicted. He's facing murder and felony murder. And maybe some other charges. They don't always list all these things here.
I do have all of my jurors. I did want to let you know that juror number, no, not that one, the dialysis. 43, who y'all will recall is the gentleman that that told us that he was on home dialysis. He has presented today, he is here. But he has also sent to my office a letter from a physician at Dialysis Care Center asking for that individual to be excused because he has a diagnosis of end-stage renal disease. My understanding is I think the numbers indicate that he is an alternate, but he is here. I think there was a discussion on the record when we were talking about whether or not to excuse that juror for hardship that I think I and the lawyers asked him any number of questions about whether he could make it work. And it seems like maybe he doesn't think he can, but he didn't say that clearly during the process of voir dire. What are our thoughts on what to do with that? Now, I feel like if he's here, I need to inquire, is he asking to be excused, right? Because this letter, since he didn't say that, number one. Number two is if it's a matter of accommodating him from a time perspective, right, I can say, hey, well, I'll guarantee you we'll be out of here every day at 5 o'clock or whatever I might need to do to enable him to conduct his home dialysis timely. What are your thoughts, gentlemen?
I would agree with that, yeah.
I agree.
Okay. With your permission, I'm going to have, rather than bring him out here to ask that question, I'm going to have my staff ask, are you aware we received this letter? Because this letter was faxed directly to us from the healthcare provider.
I was not aware.
I'm sorry?
No, go ahead, Sus.
And I'm going to have Ms. Sherman ask him, are you asking to be excused? So that I can then make that clear to y'all, and then y'all can make a decision about whether we wish to excuse him or not. Everybody good with that, Mr. Fossett?
Yes, as long as the defense is.
Mr. McDermott?
I'm good with that.
Okay. Ms. Sherman, come here, please.
We could skip ahead on this part a little.
Okay.
So if we excuse him, are we considering getting another alternate? Or we haven't got to that stage yet?
Well, he is an alternate, so I mean, we would just proceed with only one alternate.
That was the question.
Yes, sir.
Proceed with one or go ahead and try to find another.
That's y'all's decision. I'll do whichever you ask logistically. Seating another alternate at this point and getting them here from whatever corner of the county they reside in might mean that we're starting opening statements at 1 or 2 o'clock instead of at 11.
Oh, decisions.
I'm told that he seems quite comfortable back there. That was one of the reasons I wanted to ask if we can accommodate you to make it easier. Are you asking to be excused, or did you just want us to be aware of this medical information? So I don't know that y'all can think about what your options might be if he says he wishes to be excused, but I don't know that we have to solve that problem just now because he might say he's fine. He'll take it day by day.
Yeah, I was gonna say there could be some if this is gonna be a shorter-ish trial, and who knows. But if somebody's dealing with dialysis and they're just in like a rough state, they're dealing with a lot, their personal and physical state could make them interpret evidence more negatively. Perhaps. So there's considerations that the defense attorneys do need to make here. 2 to 3 weeks. Thanks, Dizzy. Yeah, the YSL trial spoiled us because it was like a million days. There was never not something happening. And honestly, I would imagine, I've never experienced dialysis, but you could be thinking you're good to go, and then it hits and you're like, I don't know if I could sit in these chairs. This is now that I have to actually sit here all day and think about doing this from 9 to 5 for 2 to 3 weeks. Could be real different than just, oh, I'd be fine listening to something in the comfort of my own home for 9 to 5.
I'm sorry, Mr. Cantrell, not on the record. The Zoom link that you...
All right. We'll try to judge by captions if they're saying anything, or if we can just skip ahead a little. Yeah, no captions.
He has communicated.
There we go.
So, with y'all's permission, Ms. German did inquire with juror number 43 whether or not he was asking to be excused, or whether, what the purpose of providing us with that information was. And he has communicated to her that he wanted us to be aware of the nature of it, that he reached out to his doctor, but that he's actually not asking to be excused. And so he has stayed and elected to remain. We did advise him that we would try to accommodate him to the extent necessary. And he mentioned a couple of things that we'll need to work with schedule, but nothing that I've seen that's too burdensome in terms of, ending one day at about 3:30 or something like that. So, but we're going to go from there. So 43 stays. I just wanted you to be aware that I had that information from his doctor. Anything to put on the record regarding that matter, Mr. Fawcett from the state?
Not from the state, Judge.
Mr. McDermott?
Nothing from the defense.
Okay. So are we ready to get started? State ready?
Yes, I'm going to share my screen now.
Okay. And
PowerPoint?
have the parties had a chance to make sure that there's not anything significantly objectionable that, have you shown each other? I don't want to.
I did show counsel, but
Okay.
I intended to show in the opening statement. I did not hear an objection.
Mr. McDermott?
I don't believe I got your full PowerPoint presentation, did I?
It sent to you, but
So I have not been able to look at that, right?
well,
Oh.
I showed you the photo.
Well, let me say this. Excuse me, gentlemen, I'm going to be talking to the jury for about the next 25 minutes, so I think you'll have time to look at it, and then you can let me know if there's an issue. Okay?
Efficient judge.
So as far as the content, you're not.
No, I'm not showing anything else.
So state didn't turn over the PowerPoint that they're using during
Your
openings.
share screen works. If you'll take that down, please, while I talk to the jury.
Or maybe
ready
they
for the jury?
did. Defense didn't get it. But another little, maybe not a big deal. You can look at it quickly, but when you think back to the YSL trial, and we had 2 serious objections during openings because they didn't redact information about prior convictions and an attorney's representation of co-defendants in cases that were where the underlying crimes were referenced as underlying acts for the RICO count 2 times. So, oh yeah, old habits die hard. That's exactly it, Peter. The objection, mistrial. Your Honor, I have a motion. But it seems like Fawcett is going to do the openings. So. Oh, we got verdict. Is it? All right. So as soon as I see court motion, I have it open. We'll flip over. Although, you know what? If they've got to give jury instructions, I mean, advising to the jury.
How this process will go?
It'll be instructions. We not really. We can rewatch that on 1.5. So let's go over here. Yeah, he's toast, I think. This is done. I think it's straight down the line. Yeah, this is done. Everybody stayed close. Ooh, look at his face. I need that Securus voice. The jail recordings when they hang up the call and it goes, goodbye. Yes, Oasis Cat. Very quick verdict.
All right, ladies and gentlemen, please be seated. All right, sir, are you the foreman of the jury?
Yes, sir.
It's my understanding that the jury has reached a verdict.
Yes, sir. Yes, Your Honor.
Is it a unanimous verdict?
Yes, Your Honor.
Has it been reduced to writing?
Yes, Your Honor.
Have you signed and dated it as the foreman of the jury?
Yes, Your Honor.
If you would please hand the verdict form to the bailiff.
Did not want lunch.
I ask that the deputy clerk publish the verdict.
In the Superior Court of Liberty County, State of Georgia, case number 2024 R-67, State of Georgia versus Nicholas James Kassotis. Count 1, malice murder, guilty.
Done. He's done. He's gone.
Count 2, felony murder, guilty. Count 3, aggravated assault, guilty. Count 4, concealing death of another, guilty. Count 5, possession of a knife during the commission of a felony, guilty. Count 6, possession of a tool for the commission of a crime, guilty. Count 7, possession of a tool for the commission of a crime, guilty. Count 8, possession of a tool for the commission of the crime, guilty. Count 9, possession of a tool for the commission of a crime, guilty. Count 10, possession of tools for the commission of a crime, guilty. Count 11, removal of the body parts from the scene of the death, guilty. Count 12, tampering with evidence, guilty. On this 14th day of August 2025.
Do the attorneys wish to see the verdict to make sure that it's in proper form?
No, Your Honor.
And are there any objections to the form of the verdict?
No, Your Honor.
Are there any other requests before we go into another hearing?
No request from the defense, Your Honor.
If I can just have one moment, Your Honor. Nothing concerning the jury, Your Honor.
And does either side wish to place anything on the record before I excuse the jury?
No, Your Honor, and I also don't seek to poll, just for the record.
Nothing from the defense, Your Honor.
Ladies and gentlemen of the jury, we've been here almost 2 weeks, and I wish to thank each and every one of you for your service. It is one of the highest forms of civic duty that any citizen can render to this state and this country, and we cannot resolve important cases like this without your willingness to serve. You've been diligent, you've been here every morning on time, you've been taking notes, you have done excellent work as a juror in this case, and it is sincerely appreciated, not only by me, but everybody involved in the criminal justice system. Your duty ends at this point, and I'm going to have to go into a sentencing hearing. There is one other thing that I do want to mention to you. I think you knew at the outset that this case was going to be televised, live streamed through various media outlets, and I want you to know that you have a right as a juror and as a private citizen. People may want to talk to you about this. Well, at this point, you can talk about it if you want to. That's totally within your discretion. It's my understanding that some of the media outlets may be outside. They may want to speak to you. That's solely up to you. I have no control over that. That's up to you. So when you see individuals who might be with the press or other outlets, that if you want to speak to them, that's fine. And if you don't want to speak to them, that's also fine. So there's nothing else I can tell you other than I sincerely appreciate your hard work in this case. I wish you well, and you are excused at this time. Thank you very much.
All right, we're real time, so we can't skip ahead. We're going to get into sentencing, and I mean, guys, victim impact or no? Do you think he's going to make a statement? I think he's going to want to say something to the judge.
Yes, ma'am.
And I don't think it'll help. Yep, guilty on all counts. I could update the banner. All right, so banner is updated. Oh, wait. Guilty.
Everyone, please be seated. And I want to tell all of you, thank you very much for your service. But the reason we select alternates is someone whether it's sick or not able to perform the duties of the jury, you would have filled in. But your work was also very helpful.
I feel like Doug would guide him to just be quiet, let him do the talking. I mean, there's not much mitigation to do here.
All right, ladies and gentlemen, we'll be in recess for about 10 minutes, and then we will begin the sentencing hearing.
Thank you, Your Honor.
Yeah, and again, I'm going to pull the counts back up on the screen, but malice murder and the separate charge of felony murder could both get him. He's looking at life sentences for both of those. So I don't think there's anything to mitigate here. There's not going to be something that makes him eligible for parole. They didn't raise an insanity defense. Oh, sorry, Cupcake. Well, unless you wanted to be here, then I'm glad, but sorry at the same time. Woke you out of your sleep when you heard, here we go. Yeah, Aaron. Also, Aaron, thank you. Hurricane Aaron is deciding to, it seems like, stay away from the Florida coast. So thanks, Aaron, for staying away from me. But Aaron says, I feel bad for Doug. I really hope Kassotis doesn't make a statement at sentencing, but I'm not confident he's learned to shut up yet. Me either. Oh. And I do feel for, I don't know what the true story about his family members are. It seems like that DV story could have been fabricated just as an excuse. And maybe the dad willingly participated in the reporting of this scary incident involving family members to help get the name change filed under seal. But they weren't called to the stand. We don't actually know what they were complicit in at all, if at all. So I don't know if they're just wondering what went wrong. I don't know. That part is a mystery to me, but I would imagine that we might get some victim impact statements. We see that Morgan Paddock is in the gallery. I didn't see Angela, but Angela, it seems like she had to fly in to testify, so she might just not be available. But I wonder if we'll get a statement from the friend, Morgan. Yep. And what's twisted too is, you know, this whole thing about the PCOS and how Nicholas Kassotis tells us, he gets up there and tells us he was trying to get Heather to take medication so she could get pregnant. You know, it's like, could the same fate have met Heather if they stayed together longer and she wasn't able to carry his child? Could the same fate have happened to Samantha? Yeah, and Travis B says that name change sealed it for him, that he tried to conceal his identity in relation, like, because of the murder. And that's the thing, you know, I really, and I don't love the way that the prosecutor did it. There are a lot of people that love the way the prosecutor was emotional during the closing. I don't love that style. I think her acting out the stabbing motions for the marks near the belly button, I think it was inappropriate because we didn't have, it's too far of a inference for me to find it reasonable. Because she didn't ask very many questions of the medical examiner. We got that there were 3 defects on the belly that could be consistent with a sharp object, but she didn't ask any questions consistent with a stabbing. Now, something being caused by a sharp object does not necessarily mean it was caused by a stabbing or penetration. She didn't ask any questions. It was like 10 seconds of discussion about these defects near the belly. And Doug didn't ask about it in cross because he focused on the head lacerations and discoloration that were really the breadth of the questions on direct from the prosecution. And then in closing, Lori Bale gets out there and yells, "And you're angry," and is making repeated stabbing motions while describing what's really what we heard in evidence was only defects consistent with the sharp object on the belly. We don't know if they were post or pre-mortem, but nevertheless, I think that was very compelling for the jury to get to that malice murder. Whereas people were confused about this theory of initially the state, they were on the run together. He did all of this to avoid a $1.5 million judgment that was awarded against his wife, Heather. And cool, I can kind of see how you could get there, but when you have evidence on the record that that judgment was pending for years already and nobody was harmed, now it's kind of like, I don't know if that really makes sense as the why. But the state got a cohesive why together. I don't like the animation in illustrating how they think wounds were caused. We don't have testimony from the ME, but that is what it is. I'll invite Doug up. Doug's welcome to come up here anytime. Yeah, Sabat, I agree. The shouting is just wild. The shouting is too much for me. It's just not my taste, but you know, and I think a lot of us don't love that because we just want to hear the arguments here. But there are a lot of people, I think the overwhelming amount of people that follow trials, especially the true crime genre. You know, they really are here for the victim. For them, trials are about the victim. To me, I diverge there. I think trials are about the case against the accused. And if the state can meet their burden to prove what they're charging against the accused. But there's other people that look at cases as having a different purpose. And ultimately, I want to be clear, I diverge on my characterization, but I come back together where if the process is followed correctly, the prosecution is all the T's are crossed, I's are dotted, it ultimately results in justice for the victims. So I diverge and then converge back at the same end goal, ultimately. DA Hylton wants to come up and talk to us. She's going to be like, look, I love the phrase I submit to you. So, and I think, let's do a poll. Not a poll, but a percentage. Let's do like out of 100%, the chance of a guilty verdict all the way down the line. So if you don't think it's like guilty on like 1 or 2 charges, reduce your percentage a little bit. Do you think without Nicholas Kassotis taking the stand, do you think it was like 100% chance the jury's still going to find him guilty? Or how much damage, if he didn't testify, what percentage chance do you think this full down the line verdict would be? Because I'm honestly at like a 80, 85. I think he would have been found guilty of all the concealing and hiding. So my opinion is I think we cleared the burden on all of the dismemberment and clearing and concealing and the tools that, maybe not specific all the tools, but at that point before he took the stand, it could have just been he found her unresponsive and wanted to get rid of the body. Maybe we're not sure beyond a reasonable doubt that she was actually, her cause of death was him intentionally planning to kill her. He got up there, he sealed that for me. So let's see, let's go back to the start. We've got, starting with, I think this is the first one, 100%, 40, 100, 60, 100, 100, 67, 100, 50, 50, 60. I love it. This is 96. It's so precise. 65, 70, 50, 30. Without him, yep, 85. All right, 75. I don't know if this is 445 or 45. 95.5, 100, 60, 50. Skillet breaks it down, because once we let this roll out, these answers, because I think they said 10-minute break, right? Guilty without talking, guilty with talking. He should have just ate the special fried rice in his cell alone. Yeah. He did have those chatty patty interviews. Morris is over 90. Jury was mad at him. Guilty. Well, I don't know if Steele necessarily would have gotten a different outcome. I think the best chance at a change in outcome would be if guidance was followed to not take the stand. 45. 3? Mara says it's just the police interview. Police interview did it. Anna goes 75 to 100 after the testimony. 90. Travis B. Yeah, Eve, and I think the same. Mindy's failure to get and keep the pregnancy sealed the fate. And I don't think that was that cohesive of a why until he took the stand. It was just my speculation. I was thinking about it. I was mulling it over. And I could see how the jury might say, well, I think this guy would think something like that. But reasonable doubt standard, I really think his own testimony just nail in the coffin. And O'Bailey's, and I like this see the nuance. The state didn't prove he was the one who cut the bones, for me anyway. And, you know, big questions about tool mark analysis as a general question, right? So that's why I always think a case like this is interesting, because we get to see what tool mark analysts present, how they're cross-examined, what they are capable of looking at, what they can't look at, what the state gives them to look at. You know, they're really working with, hey, this Milwaukee knife, insulation knife, is the suspect weapon. So they have that constraint while they're going into it, looking at it. We got 100, we got a 95, 100. We got 100 here. Candace says, I submit to you 100. 100. And also, even if he didn't testify at all, nothing he said made sense. Where is everyone's brains? Well, and so Joyce, I think you're welcome along. But I think we look at the case with, I try to frame a lot of my questions with predictions on what the jury is going to do. And if I'm going to ask for personal opinion, sometimes what do you specifically think? What would you do? You know, and I think picking a jury, there's a lot of value in understanding that juries can be unpredictable. So when we have most of the chat here saying they think the jury still would have come back 100%, 95, 80% or higher with guilty, I think that's people agreeing with you more than you think. Let's see. Yeah, Max, I do wonder if he didn't testify, the jury might have been out longer. I think they might have wanted to rehear his own words, right? Because just because the nature of listening to these recorded interview calls, it's hard to hear. And if that's their chance to go and hear his words again, maybe they would have asked to see those replays. So. And so Joyce, I think the way you're approaching here in the chat, and I want to welcome you here, and if you're open-minded to having a conversation, you're absolutely welcome here. But to ask a question like, does anyone realize? It's really dismissive when the majority of this chat, while we were going through that subject matter, was shocked, was asking questions, was saying, how would nobody know what the hospital was actually saying? How would nobody of the family members have an actual say or an opportunity to speak with somebody and get some questions answered? So it's, I think you might be speaking from a place of emotion and surprise. And I think the surprise is unfounded. And I think this is quite a presumptuous position to take against this chat here. Because this chat, by and large, was shocked multiple times at the stories being told about the hospital story. But I understand it's an emotional case. There's a huge sadness here. Let's see.
Council ready
Oh, we got
to
some
proceed?
movement.
Okay. Everyone please be seated. right, in case number 2024 R67, the jury having reached a verdict of guilty as to all 12 counts in the indictment, is the state ready to proceed with sentencing?
The state is ready to proceed with sentencing, Your Honor.
Is the defense ready to proceed?
The defense is ready to proceed, Your Honor.
Does the state have evidence in aggravation?
Yes, Your Honor. The state intends to call two witnesses and one statement that I will ask Ms. Ashdown, our victim witness advocate, to read. So the state would call, would the court like me to proceed?
Yes, ma'am.
At this time, the state would call Megan Mevin to the stand. Ms. Mevin will be speaking on behalf of the family of
This is
Mindy
Frank's.
Mevin, Your Honor.
This is Frank the Fourth's wife,
Do you-
Megan Mevin.
I'll let- She might be more comfortable just sitting right there. Please raise your right hand before you're seated.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I just ran up the stairs, so sorry if I'm.
Just, hold on, just catch your breath.
Okay, let's see. All right. I've kept up with the entire trial and decided to drive 3 hours this morning to be here because I couldn't let this chapter of my life end without at least saying something. Unlike you, I have cried a lot over the last few weeks. My thoughts, anxiety, and emotions have been a roller coaster. They have been all over the place while having to deal with this trial. I go through anger, sadness, frustration, grief, stress, and every feeling that you can think of. You lived with us for 15 months with providing no financial contributions. 15 months that I will never be able to get back. At times when you lived with us, I told you how your actions had affected me, and this impact statement isn't much different. Whether you take away anything from this, that is not my intention at this point. You've shown no guilt and absolutely no remorse. You haven't even shed a tear. You thrive on the illusion of power and attention. You're a pathological liar, sociopath, psychopath, murderer. You thought you were so much smarter than everyone else, but you aren't. You wanted people to believe you were a victim of abuse, while you were the one being abusive, at least mentally. You have forever changed the meaning of trust for me and our family. I can no longer trust people in the same way as I did before you continuously lied and ultimately took Mindy's life. There will always be some questions that will go unanswered, but to answer them would mean to try to understand a murderer's mindset, and that is one I will never understand. Mindy was bright, beautiful, empathetic, confident, independent. She loved music and making others feel special. She always put her family and friends first. Once my husband Frank and I had our daughter, Mindy wanted to choose a name that was different than the traditional aunt name. She decided on Lulu. She was never able to hear her sweet niece call her that. My daughter was 5 months old when y'all moved in. She will never know the fun times they experienced together. I'm thankful my daughter does not remember the 15 months you lived with us and sat right next to her at the dinner table. My daughter will never be able to experience the love her Aunt Mindy would have continued to give her. Mindy was taken too soon. No one should have to live through the violent and gruesome murder of a family member. You're a very evil man. When I learned the news of what really happened to Minnie, some of my first thoughts were that I couldn't believe that evil man lived in my house in a bedroom next to my 5-month-old daughter. You have no remorse for what you did. This loss has impacted so many beyond our family. The emotional wound you have caused will never heal. We have comfort knowing she is in heaven now, free from the trials and scars of this earth. We have overcome hatred, darkness, and evil. She is looking down on us now, being proud of how we have overcome. We are done being victims. We are taking back our lives. Since I'm a science person, I'm going to quote Isaac Newton. Every action has an equal and opposite reaction. Our family believes you deserve the maximum sentence, life without the possibility of parole, because Mindy doesn't have a parole. You deserve to sit in prison for the rest of your life and think about Mindy every single day. Thank you, Your Honor.
At this time, the state would call Morgan Paddock.
Okay, Morgan is the first friend that we heard from. The one that said they were like friends in the church, the youth group.
You can raise your right hand.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do.
There are people literally all over this world that have been impacted by Mindy's life, and I'm here to speak on behalf of them. I always say my worlds collided with Mindy. Not only was she my high school friend, but after moving to Savannah, all of my college friends became her friends too. My roommates became her roommates. My church group became her church group. This entire trial has rightly been focused on what happened to Mindy, but Mindy was so much more than what happened to her. She was a bright light, vibrant, generous, funny, caring, a defender of others, passionate, trustworthy, and so much more. If anyone in her life would have been in her position, she would be standing right here today speaking for them. Nick, you slowly and strategically tried to dampen her light, isolating her from the people she deeply loved, robbing her of time, laughter, creating memories and peace, always living in fear and isolation. She loved you and trusted you to tell her the truth, to protect her, to live out your marriage vows, and yet you were the one that she needed protection from. Her death has had and will have an eternal impact on those that loved her. There are dinner tables and holiday pictures and memories that will be absent of her. There are little girls growing up without their fairy godmother. There are friends who will always ache to dress up and go out for drinks again. Email inboxes void of her opinions on the latest happenings in politics. Friends who can't expect her to stand with them in their proudest and hardest moments. Friends who won't have her in the audience of their concerts or harassing them for their latest released music. My everyday life in Savannah is now filled with the awareness that my friend was living and suffering within walking distance of my house. And I never knew. I will never be able to drive down
That
65th
sucks.
Street, go to a Smoothie King, pick up meds at CVS, or buy tennis shoes at our local shoe store without being haunted by the fact that you were frequenting all of those places for 5 months while my friend of over 20 years was suffering in fear and isolation as I drove mere feet from her driveway. But it's not just me and her friends that will miss out. This entire world is impacted by the ending of her life too soon. There are compelling women whose stories she will never get to tell on her podcast. There are strangers who will never know the beauty of the sound of her laughter or the impact of her most fiercest eye roll. Your conviction can't bring her back. It just means that you can't do it to anyone else. But every person you heard from on the stand and the many who are watching right now from a distance will never stop keeping the truth of who she was and her memory alive. You may have taken her life, but you will never be able to take her legacy, and she would want you to know that today.
Pausing quick, there is a company called HelpText, and I'm sure there's variations and all of that, but I know a lot of people don't like the idea or don't have it's not possible to go and get counseling. But there is a very real type of grief where you're the friend that feels like you didn't do enough to help somebody. And it's a company that we used to use in the probate space when someone would lose a family member and not know how to deal with their grief, or felt like because they weren't somebody's best friend or direct family member that their grief wasn't okay to have. I think more awareness could be made for that layer of grief when you're kind of removed from somebody when they pass away, but you feel remorse that you weren't there. And there is counseling for that. HelpText is a service that we used to provide to people that were in that situation because they would curate their support for you to that type of thing. Really, it's a really strange type of grief to deal with. And Candace says grief share group. Is that like a Facebook, like a social media group?
Your Honor, the state has one final statement that I'm going to ask to be read into the record. That statement would be read by Ms. Samantha Ashdown, our victim witness advocate, on behalf of Samantha Kolyesnik.
All right.
The defense will object to the reading of that statement, as Ms. Kolyesnik, while obviously a victim of the circumstances here, is not a victim under the law that would be entitled to read the statement to the court.
Well, Judge, my position on that, as the court is aware, is that this is evidence in aggravation, not a victim impact statement.
It is. I'll overrule the objection. Thank you, sir.
Thank you, Your Honor.
Yes. There's no need to swear.
To the court and to the Honorable Judge Rose, my name is Samantha Kolesnik, and I am a victim of the defendant, Nicholas Kassotis, aka Nicholas Stark, the latter of which is the name he used while victimizing me in Pennsylvania. You were able to hear my testimony against Nicholas during this trial, and you were able to hear and see my pain and my tears firsthand. I recounted his horrible acts of deception against me. I trembled taking the stand to testify. It was the hardest thing I've ever had to do, but I did it because I feel Nicholas is a true and constant danger to everyone he meets. I feel that if given the chance, Nicholas will continue to exploit, abuse, deceive, and harm others. I testified knowing I would be filmed against my consent and that I would be humiliated in admitting I was defrauded by a man I met online, and that my privacy would be forever gone. I testified anyway because I strongly feel and believe that Nicholas is a danger to society and that he must be held accountable. Ms. Bayo, ADA for the prosecution, mentioned ripples from Nicholas's dropping stone as an analogy for an impact of his choices. I am one ripple. I have not been the same since I found out about his deception from Agent Sands, and I will never be the same again.
On the date of his arrest, when Agent Sands of the GBI told me Nicholas Stark was not his real name and that Nicholas had been lying to me, my entire world turned upside down. My sense of trust shattered. I felt humiliated, deceived, traumatized, and unsure if I would ever be able to feel joy or hope or trust again. I also felt stupid and will continuously be called stupid and gullible by some in the public eye as a result of trusting a man who was once a naval officer, a JAG, an employee of the Pentagon, a man who had every opportunity and privilege in life. Everyone trusted Nicholas, and he knew it, and he privately relished and delighted in lying to them and in abusing that trust. He is a man who delights in deception, a man who thinks he's smarter than everyone in the room he walks in. I also felt terrified beginning on the date of his arrest and thereafter, and will forever be haunted by what he would have potentially happened to me if the GBI and Detective Jack Frost's team had not tracked, found, and arrested Nicholas Stark, aka Kassotis, when they did. I fully believe that the wonderful law enforcement agencies of Georgia saved my life that day, and I will be forever grateful to them for saving me from the evil man who goes by many names, one of them being Nicholas Stark. I was diagnosed with PTSD, post-traumatic stress disorder, as a result of Nicholas Stark's cruel actions towards me. I have nightmares, flashbacks, and panic attacks. I lock my bedroom door every night. I do not feel deceived by Nicholas Stark, aka Kassotis. I feel raped by him. I was not allowed to consent to a romantic and intimate relationship with Nicholas because he lied about his entire identity to me. There was no opportunity for true consent, and he ensured that with his vast network of lies. This is called rape by fraud, but unfortunately is not recognized in Pennsylvania, so all I could do was pursue an annulment on the basis of his fraud. I am sure Nicholas Stark, since he is a lawyer after all, knew those statutory limitations when he deceived me. I do not feel Nicholas feels 1 ounce of shame or remorse for his deceptions against many people, including those he perpetrated against me. He has sat in this courtroom and has attempted to make every mockery of it with his smug expressions, his arrogant demeanor, and his lack of tears as his victims, one after the other, have talked about how he deceived them. I beg and implore and plead to the court, please give this man the maximum sentencing. And please, if at all possible, by sentencing protocol and legislation, please do not allow this man to do paid interviews or in any way profit from his crimes. Nicholas, due to his sick need for control and his sadistic desire to humiliate and defraud others, will absolutely try to profit off his crimes in prison. Please do not allow Nicholas to write books or to sign movie deals or even take paid interviews. He must not be allowed to extract any more from the victims than he already has taken so much. I also ask that he not be granted any chance for parole. A man who lies as much as Nicholas has and will always be a danger to society, especially the most trusting and vulnerable among us. Sincerely, Samantha Koliasnik.
Thank you.
Georgia does not have a
Those are
son
the
of Sam
only
type law.
evidence of, aggravation that the state intends to present. Do you wish the state's argument, or do you wish to have
I'll wait
mitigation
till I hear
first?
from the defense.
Certainly, Your Honor.
Does the defense have any evidence in mitigation?
Just like to present the defendant's mother to testify in the
You may.
So this is going to be Linda Kassotis.
One at a time.
So, two witnesses, Your Honor. Defense calls Wayne Kassotis.
You can come up here, sir.
I prefer.
Yes, Wayne.
That's fine.
Thank you.
Can we swear you in, sir?
Oh, absolutely.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely. Good morning, Your Honor.
Yes, sir.
Heard a lot of things in this courtroom this morning. Last over 2 years have been hell for all of us, including Nicholas. Although I don't agree with the verdict that was reached in this court, that the jury reached, I do respect the process. They have no idea who Nicholas was. Nicholas is a kind, gentle man that has touched thousands of lives, both as a civilian and as a military person. Nobody saw pictures of him helping underprivileged children in South America as a naval officer. Nobody saw him helping friends as he was growing up. He is truly a wonderful, kind person. And from the beginning, when this all broke, from the lies that Agent Sand told to family members, we never believed that this was possible, and we still do not believe that this is possible. We know the person sitting there, our son, as a kind and gentle person that would not do this, and there's really no evidence that showed that he did. I just want you to be considerate and look at the man who he is and who always will be. Thank you, Your Honor.
Thank you, Mr. Kassotis.
I mean, I think the judge is going to look at the man he is and will always be. And I put it in the chat, but since I didn't say it out loud, if you're just listening, so Wayne Kassotis has former law enforcement experience. He was a police chief. He seems to be retired now. But I think that is why we get but I respect the process, right? You know, he probably had to testify and help put cases on. So that was to me, very consistent with a law enforcement officer saying that, or something that a prosecutor would say in a statement after trial to the media. And here he's saying it in a victim impact, a statement asking the court for some type of sympathy for his son before sentencing. So that was interesting wording.
Thank you very much.
The defense calls the defendant's mother Linda Kassotis.
Now this is Linda.
Ma'am, you're welcome to stand here, or you can go up there.
Stand here.
Please raise your right hand.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Thank you. Your Honor, I would like to say first how incredibly sorry we are for Mindy's family that they had to go through this. We have never spoken since we heard the news of Mindy's death, but we feel incredible sympathy for them that they lost their daughter. But Nicholas was not responsible for this. We know him to be a kind and gentle person. As you know from the testimony, we had not been in touch with him for years through circumstances beyond our control, and every member of our family suffered as a result of that. People missed him so desperately. My mother said she had never gone a Christmas without seeing or hearing from him, and suddenly he was gone from our lives, and we had no idea why. He is a good and kind and gentle person. The thought that he could take someone else's life is just unbelievable, honestly. I respect the jury's work that they did, but they got this one wrong. I'm sorry. Thank you.
Thank you. Anything else, Mr. Johnson?
No, Your Honor.
All right, this time I'll hear argument from counsel.
Your Honor, may I?
You may.
Your Honor, this case is a case that the court has obviously spent the last 2 weeks present for and listening to all of the testimony. As a result, I don't plan to go over any of that. I think Morgan may have said it best when she described how Mindy and her life impacts the world. When a sentence is rendered, I think the court has always, and I think I've even heard you say, has to evaluate not just how it impacts the defendant, but the message of rehabilitation, if possible, versus punishment, if necessary. The law in the state of Georgia entitles on a murder conviction only 3 options, essentially: the death penalty, life without parole, or life with the possibility of parole. In this case, Your Honor, the defendant is additionally facing all of the additional crimes that can run consecutively. That would be the concealing death of another, which he faces up to 10 years, possession of a knife during commission of a felony, which is mandatory 5 years consecutive, although it could be, of course, probated. And then all of the counts of possession of tools for the commission of the crime that he's facing up to 5 years for each of those. And then the 2 misdemeanors are, of course, up to 12 months. That is more than what I would refer to as natural life. The state's position, Your Honor, is that the defendant should never be released from prison, that he is a danger to society, that his testimony before this court under oath was fraud, that he was dishonest, that he perjured himself, and that, of course, is the state's position. I'm sure counsel for the defense would disagree. And I think that goes to the question, however, of whether or not there is remorse or whether there is some validation to something less than life without parole. The jury has now determined that he not only killed his wife, but that he threw her out like garbage across 3 miles with the hope that no one would ever catch him. If that depravity could not be any worse conduct to deserve life without the possibility of parole, I don't know what could. But for the good work of members of law enforcement, all of the teams that worked so hard to run every detail down, we would not be here today. And so, Your Honor, it is the state's position that the defendant in this case should get the maximum sentence of life without the possibility of parole. The state will defer to the court with respect to all of the other counts, as I essentially believe that they are, you can't get more than forever. Thank you.
Thank you, Mr. Hill.
Your Honor, the jury has rendered its verdict. While obviously we don't agree with that, we understand that is your obligation to sentence him under that verdict. Mr. Kassotis is a highly educated man. He's a man that served his country honorably. You've heard a lot of testimony, not just from his parents, but from witnesses on the stand, of his kindness. I think there is an opportunity for rehabilitation in this case, especially given his past. So I would ask the court to sentence him to life with the possibility of parole. Those other counts that can be served concurrently, that the sentence have them served concurrently. I understand there's 1 count that must be consecutive. So that's the position of the defense, Your Honor.
Mr. Weinstein, your client has the right to address the court if he so chooses.
Let me verify.
Oh, he said no.
He will not be addressing the court, Your Honor.
Then have him stand for sentencing. Mr. Kassotis, a jury of 12 citizens in Liberty County, Georgia, has now determined beyond a reasonable doubt that you are guilty of the offense of murder, along with 11 other counts. This jury has spoken very clearly. It is now my duty under the law to impose a sentence that is consistent with that verdict. It is also my duty to look at the evidence and weigh the sufficiency of that evidence. And sir, The evidence in this case is supported by a mountain of compelling evidence. This case has revealed a level of depravity that truly shocks the conscience.
No parole.
To put together this elaborate scheme, this web of lies, creating this fictional character, Jim McIntyre, who does not exist. You wrote fiction, and your life was a fiction, at least the last 6 or 7 years. And then you carried out, or the evidence shows that you carried out a brutal, horrific, gruesome murder of Mindy, someone who's been described by various witnesses as beautiful, kind, loving, vibrant, smart. And all of her hopes and dreams vanished in an instant. Her life tragically cut short by you. Someone who professed to love her, to care for her. Just the ultimate betrayal. And then you desecrated her body in such a vile way, discarding her remains out in a rural area of Liberty County, hoping that they would never be discovered. This shows beyond all doubt that you have no conscience. When I described to this jury this morning the elements of the crime of malice murder, the language used in the Georgia statute is that the circumstances show an abandoned and malignant heart. That describes you. You have caused so much harm to your own family, to all of those who have been impacted by your deeds. This is truly a heinous crime. So the court has considered all the facts and circumstances of the case. And the court will now impose sentence that reflects the gruesome nature of your criminal conduct.
Done.
As to count 1, malice murder, the court hereby imposes a sentence of life without the possibility of parole. Although you've been convicted in count 2 of felony murder, that count would merge into count 1. As to count 3, the sentence of the court for aggravated assault is 20 years to serve in the state penitentiary, and it runs consecutive to count 1. Count 4, concealing the death of another, the sentence of the court is 10 years to run concurrently to count 1. Count 5, possession of a knife during the commission of a felony, it's required to be consecutive, so the court imposes a sentence of 5 years consecutive to count 1. As to count 6, possession of tools for the commission of a crime, the court imposes a sentence of 5 years to serve, and that shall run concurrently to the other counts. Court will impose the same sentence on count 7, 5 years to serve, running concurrently. As to count 8, possession of tools for the commission of a crime, again, the court will impose a sentence of 5 years to run concurrently. As to count 9, possession of tools for the commission of a crime, the court imposes a sentence of 5 years, again to serve concurrently. As to count 10, possession of tools for the commission of a crime, the court imposes a sentence of 5 years to be served concurrently. Counts 11 and 12 are both misdemeanors. They carry a maximum sentence of 12 months. The court will impose a sentence of 12 months as to each count, counts 11 and 12, and they shall run concurrently. The totality of the sentence being a sentence of life without parole plus 20 years to serve. Sir, you have a right to seek post-judgment relief from your convictions of these crimes, and you can do that by filing a motion for new trial or filing a direct appeal to the appellate court. That will have to be filed within 30 days of today's date with the clerk of Superior Court in Liberty County, Georgia. If a motion for new trial is made and the court denies it, you will then have 30 days from the filing of that order to file with the clerk a notice of appeal to the appellate level. You also have a right to file a petition for habeas corpus. And that would have to be filed within 4 years of the date that the sentence and judgment in this case is deemed to be final. If you cannot afford an attorney to pursue your appellate relief, a lawyer will be appointed for you, and I'm sure that Mr. Weinstein will discuss with you all of your appellate rights. Is there anything else that needs to be placed on the record before the defendant is remanded to custody?
Your Honor, I just want to clarify. The court indicated life without parole for count 1, 20 years to serve consecutive on count 3, and 5 years to serve consecutive on count 5. Is that correct?
Correct.
Then that would be life without parole plus 20.
That is correct.
I just want to make sure the record was
I misspoke.
Thank you, sir.
25?
It's mandatory by law.
Correct. I just wanted to clarify.
Yes, ma'am.
That's
You
the
said
only
25, right?
position at stake. Consecutive on count 5. Is that correct?
Correct.
Then that would be life without parole plus 20.
That is correct.
I just want to make sure the
25.
record was
I misspoke.
Thank you, sir.
It's mandatory by law.
Correct. I just wanted to clarify.
Yes, ma'am.
That's the only position at stake.
He is remanded to custody. Court stands adjourned.
Thank you, Your Honor.
All right, so let me correct that real quick. All right, so short and sweet, really there for sentencing. I'm still curious. I thought Georgia had a son of Sam law, which would, that's the type of, son of Sam prevents someone from profiteering off the circumstances that got them incarcerated. Like they can't do interviews for profit, things like that. They can't write books and make a profit off of it. I thought Georgia had something similar, and maybe they do, and maybe Samantha included that in her statement. She lives in Pennsylvania. Maybe they don't have that there. But yeah, there wasn't a term of sentencing specified by the judge here to prevent that profiteering. But I do think it's just barred in Georgia anyway. Okay, so let's see. Yeah, look at Justice Serve TV with the numbers here. I tried to Google and then got distracted with the stream, so big thank you here to Justice Serve TV. We love them. And there we go. Let me link in the chat. And we're going to get back over to the Fulton County case, but let's take a look at this. So this is dealing with restitution and distribution of profits to victims of crimes. And then we've got distribution of profits of crimes, contract regarding reenactment of crime, deposit of consideration in escrow, monies, actions taken to defeat purpose. So This first section, 1, every person, firm, corporation, partnership, association, or other legal entity contracting with any person or with the representative or assignee of any person who's been accused or convicted of a crime in the state with respect to the reenactment of the crime. So, I mean, that my mother-in-law, Betsy, is poisoning me, and I think I know why. That's the short story that he had received $300,000 for. Sony purchased the rights to it. Seems pretty relevant to some of the stuff here. But movie, book, magazine article, tape recording, phonograph record, radio or television presentation, or live entertainment of any kind, or with respect to the expression of the accused or convicted person's thoughts, feelings, opinions. Let's make this bigger because this is real tiny for you guys. All right. Or emotions regarding the crime shall submit a copy of the contract to the board and shall pay over to the board any monies which would otherwise, by the terms of the contract, be owing to the accused or convicted person or to his representatives. Board's got to deposit the monies in an escrow account for the benefit of and payable to any victim or the legal representative of any victims of crimes committed by the accused or convicted person. 3, payments may be made pursuant to paragraph 2 of the subsection only if the accused person is eventually convicted or enters a plea of guilty of the crime of the victim. So we've got that conviction now. Within 5 years of the date of the establishment of the escrow account, brings a civil action in a court of competent jurisdiction, and recovers a money judgment for damages against the convicted or accused person or his representatives. It shall be the duty of the victim's attorney, or the victim's representative to notify the board within 30 days of the filing of any claim under this article. So it seems like the income isn't just barred statutorily, but follow this process and any profits from these related materials will go into an escrow account to be used to pay victims or counsel for victims if they follow the process here. So let's see. And also catching this, Aaron, exactly this. Aaron, and I think Aaron's also agreeing with Neri. Those are like the same names. If we switch them, you guys could spell each other's names. Same, I didn't love the prosecutor style, but I'll take that over misconduct any day. 1,000,000%. And this is the thing, guys. I think Doug did a great job. Prosecution might not have been my cup of tea stylistically, but I think she did a great job. I think she brought the case home in closing, even though she yelled. But those are two sides of the puzzle to make sure the conviction sticks, right? I mean, I don't think we're going to have any issues on appeal that succeed on arguing ineffective assistance of counsel on Doug's part. I don't think we're going to have prosecutorial misconduct. You know, nothing's really pointed in that direction. And that's what you want for the process to stick. That's where those roads, I might diverge. I don't think trials are about victims. I think trials are about the accusations being brought against the defendant, but they converge when the process is right. So, the Sony deal, it was a little more than $300K, I think, because they mentioned payments to an agent, but it was $300K in some percentage. $300K was deposited to, I almost said Jim, to Nicholas Kassotis. It was for the purchase rights of a short story he wrote that was published on the No Sleep subreddit, got a lot of attention and praise. And I don't know what they plan to do with it, but so yeah. Now this is more about, I think, on the process. So let's just see how Georgia does it. At least once every 6 months for 5 years from the date it receives such monies. So the board shall cause to have published a legal notice in newspapers. So they got to publish, similar when someone dies, you got to publish a notice to creditors. If anyone has an interest in making a claim here, you have to publicize the notification. But general circulation in the county in which the crime was committed and in counties contiguous to such county, advising victims of the crime that escrow monies are available to satisfy money judgments pursuant to this code section. Oh man, there's a lot of people in this case, it sounds like, that might have a Oh, might have some interest here. Upon dismissal of charges or acquittal of any accused person, the board shall immediately pay over to the accused person the monies in the escrow account established on behalf of the accused person. So, if I would assume this applies if there's an overturning of the conviction, which I don't see happening. Upon a showing by any convicted person, so this is where it's not a full-on Son of Sam law. Upon a showing by any convicted person that 5 years have elapsed from the establishment of the escrow account and that no actions are pending against the convicted person pursuant to this code section. So no one makes a claim, no claim is being granted. The board shall immediately pay over any monies in the escrow account to the person or his legal representative. So that's why it's not a blanket Son of Sam. He can make the profit, but if people have a claim or there's judgments and they follow this process, they've got this 5-year window to say, hey, bring it this way. Bring it this way. Whenever it is found that a person accused of a crime is unfit to proceed to trial as a result of insanity, and we didn't get that here, guys. So I know there's been a lot of commentary like, is he missing? Is there a diagnosis? No, could he be diagnosed? It wasn't argued. It wasn't part of the trial record. And it didn't really become part of mitigation at all either. So, I mean, this is not applicable here. Any excess which remains in the escrow account or is deposited into the account after all money judgments have been satisfied. I don't know if we'll get to that amount of earnings, depending on if everyone stakes their claim, shall be paid over to the state treasury as compensation for the establishment, administration, and execution of this article. Board shall make payments from the escrow account to any person accused or convicted of the crime upon the order of a court, all right, blah, 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 blah. And it can be used for the exclusive purpose of retaining legal representation at any stage of the proceeding against the person, including the appeals process. So right now, Doug's substitution of counsel was approved by the public defender's office, so I don't think that Nick has any money coming in. But if he does, it could first go to affording counsel, paying for counsel for this appeals process. Board shall disperse payment from the escrow accounts on a pro rata basis for all claims filed according to the amount of money in the escrow account as compared to the amount of each claim. The sums are not to be dispersed until all pending claims have been settled or reduced to judgment. Any action taken by a person who is accused or convicted of a crime or who enters a plea of guilty, whether by way of execution of a power of attorney, creation of corporate entities, or otherwise. Oh, man. Creation of corporate entities. I'm sorry, I'm just thinking of how Nicholas Kassotis was acting like he didn't know what a W-4 was. And all these other businesses that merged and got renamed as Apis Limited, or otherwise, to defeat the purpose of this code section shall be null and void as against the public policy of the state. So you're not going to run a bit of gamesmanship to get around this. So this is really cool. Shout out to Justice Serve TV. I like learning stuff like this. You know, we talk a lot about Georgia. But even so, when things are state-specific like this, there's the little granularities, the nuances. And let me get their link here. Go and say hey to them. They're going to be talking about this case tonight at 6 p.m. Eastern. Link is in the chat, and they're doing so amazing with their channel. They come up so easily when you type Justice Served. Their channel is recommended by the YouTube search now, so I love to see that. And then let's see what you guys are saying. I do want to give a big thank you. I think Idiot Wind had to step out. Huge thank you to Idiot Wind. Yesterday at the very end of the stream, she submitted a super chat saying, like, I meant to say guilty. And if you guys remember, we were reading her thoughts and she used N and G. She must have meant to type G, but she typed not guilty. And we were confused while we were reading it because I was like, I think she's thinking guilty. But she sent in a super chat after the stream ended, so I wanted to say thank you for that. Just, she was clarifying she meant guilty. And then generously gifting 10 memberships before she had to dip out of here. She had some other stuff to do, but I didn't want to, like, pause during the sentencing to be like, yay, gifts! But it's super, super appreciated. And I saw people saying thank you in the chat. So if you're catching this on replay, big thank you again. We have a ton of love for you here, and are always happy when you can hang out. Also, we had some thoughts. GB out of luck said, I submit to you this verdict. We didn't get an I submit to you today. So that was awesome. Good to see you, GB. And then King Bread Army says, well, this proved that one person will never outsmart the group. Shout out to Doug. And again, guys, I'm still Team Doug. I think everyone needs good advocacy. And again, when somebody is guilty, they still have rights, right? They still have a right to an appeals process. The process exists for a reason. But if you care about a victim and don't want to deal with the heartache of an overturned conviction, you want those that are accused of the most heinous things, you want them to have their due process. So I think Doug is a great way to get there and make sure we have good advocacy. Competent is not, I don't even want to use the word competent. That's the standard. But with Doug, you get way above, way above. So big thank you here, and love that you did both, right? You know, this guy didn't listen. He got his guilty verdict, but still shout out to Doug. Guys, we're going to also be looking at, for anyone that tuned in for sentencing and verdict, we had started checking out the Christopher Wolfenbarger. I'm going to keep calling him Burger, but it's really Barger. We're going to be checking that out. We're going to see what else has happened. We got through some evidentiary arguments in the beginning of the day. They're about to, I think, bring the jury in, but they have one more thing that they're thinking about. This is a Fulton County case. Symone Hylton isn't the lead prosecutor on the case, but she's at the table. And she was arguing against the defense possibly trying to bring in criminal history of witnesses that might be called to the stand for the purpose of impeachment, impeaching their credibility. And she's worried. She's like, 10 years ago. But this is a cold case from 1998. So judge is like, well, we'll have to, if they plan to do that, we'll have to do the proper 403 analysis and see if it's relevant and probative. We'll do it. So already some Fulton County fun times going on. Quick background on the case. Again, it's a cold case. Melissa was the wife of the defendant, Christopher Wolfenbarger. She went missing. Around the same time, there was a head recovered in a trash bag near the workplace of Christopher Wolfenbarger, and over the next few days or weeks, more body parts were found in trash bags close by, but elsewhere, not exactly in the same property. They misidentified the body remains at first, and then it wasn't until 2003 that they ended up identifying that the body belonged to Melissa. Melissa is the daughter of a convicted serial killer, and I'm getting a bit of details confused, but it seems like they think the dad, the convicted serial killer, was already in custody at the time they identified her body. But I'm not sure I'm hearing both that dad was in custody at the time of death, the estimated time of death, and that maybe he wasn't in custody. So we'll have to see that as trial goes on. But strap in, because we're going back to Fulton County, you guys. We're going back to Fulton County. I think volume is ready. So let's see. There's Hylton's head.
Need to happen. I'm going to talk to you a little bit more about how this process will go and give you as much guidance as I can before we get started today. But first, counsel, is this your jury?
Yes, it is, Judge.
Yes, Your Honor.
Thank you. So, ladies and gentlemen, now that I've told you could have a seat, if you'll please rise and raise your right hand. Members of the jury, do you swear that you shall well and truly try the issue formed upon this bill of indictment between the state of Georgia and Christopher Wolfenbarger, who is charged with murder and felony murder? A true verdict give according to the evidence, so help you God. Please say yes if you agree.
Yes.
Thank you all. Please be seated. So, ladies and gentlemen,
okay, thank you, Kiana. Kiana has the timeline. So dad was not in custody at estimated time of death. He was arrested and jailed in 1983. Remember, we're dealing with a 1998 case. Got out in 84 and then was not in custody again until 2003. Oh, this is going to be interesting. I know Hylton head thinking of the Hilton Head mentions in the Kassotis trial tripped me up a little bit there, Trakisha. Shout out to Ashley. Good to see you.
Thank you all again for your patience. Sometimes things move a little bit slowly, and I promise you that we are trying to be efficient and cautious of the importance of your time and attention throughout this. So, ladies and gentlemen, we are now ready to begin the trial of this case, and I have some preliminary matters that I want to discuss with you. You'll see me reading a good bit, and that's because there are lots of places where it's good that the judge doesn't ad lib, right? And so I'm going to read some things to you to make sure that you understand what your obligations are and to provide you as much information as I can as we get started. So I've already told you about our deputies. They're an excellent resource for you in terms of asking questions about what the schedule is going to be, where and when you can go or not go. I'm going to try and give you some instruction about that as well. From this point forward, as you just came into the courtroom, you will only enter the courtroom through this door and only when accompanied by a deputy. So that means that when we need you to leave, the deputy will come and open the door for you and hold it while you go out. And when it's time for you to come in, the deputy will come in and announce your arrival. The deputies can also tell you a bit about our fairly meager offerings for lunch. I encourage you to consider bringing your lunch. We do have some options, but not a whole lot, and sometimes you'll be pressed for time. And I want to make sure that you do have an opportunity to eat and to make sure that you don't get hungry or distracted while you're serving as a juror. So I think all of you are wearing your juror stickers. If you would, make sure that you're always wearing those when you're in the courthouse. And that is for a very important reason. So from now going forward, the people in this courtroom, the witnesses in the case, the parties in the case, they're not allowed to have any contact with you outside of this courtroom while we are engaged in the trial. And so the reason that I ask you to wear those stickers is so that you can be identified as a juror should you encounter someone in the hallway. Now, if that happens, don't panic, just let us know, right? Now, what may very well happen is you may encounter a witness or a lawyer or a party while you are waiting on an elevator. If they go away from you, please don't be offended, right? They're not being rude to you. They're simply trying to satisfy the court's obligation and their legal obligation that they not have any contact with the jurors outside of this proceeding. So we will generally hold court from 9:30 to 5:30. I will tell you each day when we adjourn when you have to come back and what time you need to be back. And I will try to be very cognizant of taking breaks in the morning, taking lunch breaks, things like that, so that y'all will have a chance to have a break from what is the real, mental focus of being here in the courtroom. So, ladies and gentlemen, you have been sworn and impaneled, and you are about to try a criminal case entitled The State of Georgia versus Christopher Wolfenbarger. Before we begin the trial, I'm going to give you some preliminary instructions on the fundamental principles of criminal law. And I'm going to instruct you on the role of the judge, the role of the jury, and the lawyers, and give you an overview of trial procedure. Many of you may have never served on a jury before, and it is therefore necessary that these instructions be given so that you have a general understanding of the procedure in a criminal trial, of what will be expected of you, and how you are to conduct yourself during the trial. The defendant in this case is charged in the indictment with crimes that are violations of certain laws of the state of Georgia. Now, I want to emphasize to you that the indictment, including all of the counts in it, and the plea of not guilty, are the legal procedures by which these criminal charges are brought against the defendant. The charges and the plea of not guilty are not evidence of guilt, and you may not consider them as evidence or implication of guilt of any crime whatsoever. This defendant is presumed innocent until and unless he is proven guilty. This defendant enters upon the trial of the case with a presumption of innocence in his favor, and this presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the crime or crimes charged. Now, under our system, it is my duty as the trial judge to determine the law that applies to this case and to instruct you, the jury, on the specific rules of law that you must apply to the facts in arriving at your verdict. I'm giving you some of those instructions now, and I will give you more detailed legal instructions after the evidence has been presented and the lawyers have made their closing arguments. Now, during the trial, I may be called upon to rule on motions or objections to evidence. Nothing I say in making those rulings or at any time during the trial is evidence that I have any leaning in the case whatsoever. My only interest in this case is to see that it is fairly tried according to the laws and the Constitution of the state of Georgia and the Constitution of the United States. Now, as expected, these lawyers serve as advocates for their clients, and they are duty-bound to represent their clients to the best of their ability. The lawyers also serve as officers of the court, and as such are bound to follow applicable laws, trial procedure, and the rules of evidence during the trial. Now, if at any time the lawyers believe that any law, procedure, or rule of evidence is being violated, they're allowed to make motions regarding the conduct of the trial or objections to the admission of evidence. In making these motions or objections, the lawyers are simply seeking to fulfill their duty to their clients and to the court. Now, sometimes those motions may need to be heard outside the presence of the jury, and one of two things will happen. Sometimes you'll see us come over here, as I think you saw us do during voir dire, and we'll engage in a quiet conversation if it can be done quickly, and that's to minimize the number of times we might need you to leave the room. But sometimes those things require us to give it a little bit more time, and so we will have to excuse you to the jury room when we need to do that, and we will just thank you in advance for your patience and understanding that those matters are important when they are occurring. We will try to keep them to a minimum, and again, to be cognizant of the importance of your time. Ladies and gentlemen, trial procedure in a criminal trial is generally as follows. First, the attorneys for both sides have the opportunity to make what is called an opening statement. Now, both sides are entitled to make an opening statement, but neither side is required to make an opening statement. Remember that what the lawyers say is not evidence, but it is a preview or an outline of what they expect the evidence in the case to be. Following the opening statements, the evidence will be presented. Evidence can be presented in the form of testimony that you will hear from witnesses who will take the stand, or physical evidence that will be labeled with exhibit numbers for identification. After the presentation of all the evidence, the attorneys will have the opportunity to make what is called a closing argument. Now, at this time, the attorneys may suggest to you which laws are applicable and how they should be considered in light of the evidence, and point out to you certain parts of the evidence that they think are favorable to their position. The goal of a closing argument is to persuade you to decide the case in their favor. Following the closing arguments, I will charge you more specifically on the law that applies to the case, and I will then ask you to retire to the jury room to deliberate and reach your verdict. The jury has a very important role. It is your duty to determine the facts of the case and to apply the law to those facts. I will instruct you on the laws that apply to this case, but you must determine the facts from the evidence. Evidence, by definition, is the means by which any fact in issue is established or disproved. Evidence consists of two things, either testimony or exhibits. Testimony is the testimony you will hear under oath from those who take the witness stand. Exhibits are those documents, photographs, or physical evidence that are admitted into evidence. Ladies and gentlemen, the object of this trial is to discover truth. And during the trial, the admission of the evidence will be governed by certain rules of evidence. Those rules were drafted with one prominent purpose in mind, and that purpose is the discovery of truth. Now, consequently, the rules of evidence seek to assure that only the best and highest evidence is admitted for your consideration. During the trial, the attorneys have a right to object to the admission of evidence if they believe that its admission would violate a rule of evidence. I will admit or exclude the evidence according to those rules. If I overrule an objection, that means that you are allowed to consider the evidence that is being offered. On the other hand, if I sustain an objection, that means that you may not consider the evidence that is being offered. Now, you should consider only that testimony and only those exhibits that are admitted, and you should draw no inferences and make no assumptions about the evidence objected to if the objection was sustained. Now, sometimes you might see or hear inadmissible evidence before an objection is asserted or before the court can rule on the objection. If that occurs, I may instruct you to disregard that evidence. And if you are so instructed, it is your duty to disregard that evidence in its entirety during your deliberations.
All right, we're jumping ahead.
Before I call on the state, I do want to make sure that everyone is aware that the rule of sequestration has been invoked. And if there is anyone in the courtroom who anticipates that they will be called a witness in this matter, I ask that you please exit the courtroom and do not re-enter until you are instructed to do so or called by one of the parties as a witness. I also will just mention again, as I've asked the attorneys, you know who your witnesses are better than I do. And so if you'll just keep an eye out in case they wander into the courtroom so that we can get them out of the courtroom as quickly as possible. And with that, I'll call upon the state. Does the state wish to make an opening statement?
We do, Judge.
Okay, you may proceed.
We're getting a PowerPoint, guys. So state's going first.
Good morning. Good morning. This is the State of Georgia versus Christopher Wolfenbarger.
Liam.
It's been 27 years since 1998. And specifically, December of 1998. That was the last time that Melissa Wolfenbarger was ever heard from. At that point, in 1998, Melissa Wolfenbarger was 21 years of age. She was married.
All right, we're going to turn it up a little bit, guys. Take this moment, lower your volume a little bit. We're going to increase because he's not using a microphone. Shout out to Fulton County.
2 children, a mother, sister, and after 1998, December, neither one of them ever received a phone call, not a visit, not a card. Not after Christmas of 1998. Not after her mother's birthday in 1999 in February. So you're going to hear that Melissa, at the age of 21, she had experiences when she was a child when she would run away from home. She had experiences during her adulthood after she married this defendant, Christopher Wolfenbarger, when she would not talk to her sister for a period of time. But she would always keep in touch with her mother. Most importantly, she never let a holiday go by without calling for visit. In November of 1998, Melissa had the intent to visit her mother for Thanksgiving. And they spoke. One of the things that Melissa was really looking forward to was getting a photograph of her pawpaw, her grandfather, the father of Carl Patton, Melissa's grandfather. And that is Carl Patton, Melissa's father. And that is the husband of Norma Patton. She wanted that photo. And Norma Patton expected that at some point between Thanksgiving, even though she didn't get an opportunity to go visit her mom, that she would get that photograph. But when Christmas came around, she was concerned when she didn't hear from her. But by the time she got to February, she knew something was wrong. Melissa never would let that much time go without talking to her mom, not especially during that period of time, not on her birthday. Well, it took some time for authorities to be alerted, because you're going to hear that Melissa wasn't reported missing until January of 2000. And that was because this defendant, Christopher Wolfenbarger, you're going to hear from his own words. You're going to hear what he told the detectives, what he told his children. He never looked for her. He never reported her missing. So when Norma Patton and Tina Patton are looking for Melissa, where is she? She's not working anymore. She works at Waffle House. She's not showing up to her job. She's not looking after her children. She's not checking on her children. No word. Well, the authorities tell them that, well, Melissa is 21. She's married. She's got her own life. If she hasn't called you, then maybe she doesn't want to talk to you. Her husband has reported her missing. And you hadn't talked to her in a month. Well, not really much for us to do right now. But eventually, Melissa's mother goes to Henry County, and they started an investigation. But even though they talked to friends and family, they even talked to Kristen. All we get from him is she just left. That's it. That goes on for 3 years. She gets unidentified for 3 years. And that takes us to really when we locate the remains of Melissa Wolfenbarger. They were located on 2 different dates. April 29th and June 3rd, 1999. Now, April 29th, George McKeitry is driving on the area and heard questions about Avon Avenue. That location is the location of Action Glass Company. You're going to hear that is the location where Christopher Wolfenbarger works. Glass Company, kind of a manufacturing plant. They have industrial equipment at this location. That's where he works. Although they had no reason to think that was anything significant at the time, because in April 29th of 1999, all they knew was that there was a head in the roadway, partially fully, pretty much fully decomposed. And Mr. McKeitry, George McKeitry, is riding in that area on Avon Avenue, and he sees something that he thinks is kind of odd. So he stops and looks at it, goes and gets his daughter, and comes back, and he can see what clearly is a human head. Now, something that he would tell you he couldn't believe with his own eyes what he couldn't believe. Well, that begins the discovery and really the process of trying to identify that skull. That's those same detectives, the lead detective at that time was Dale Kelly. You're going to hear from the Fulton County medical examiners, investigators, Tina Miller. They were all out there at the location on Avon Avenue in 1999, collecting evidence, taking photographs, some of which you'll see. Ultimately, they start looking for information on who this could belong to. Then you find the extremities on June 3rd, 1999. That these extremities are found, everything but the torso, or everything but the midsection of the Alyssa Walker is located. Fingers, and you'll hear from the detectives, you'll hear from medical examiners. When the skull was found, they had a portion of the spine attached to the skull, and it appeared as though it had been severed or removed with some type of circular saw. The extremities were examined. Detectives, medical examiners, the anthropologist who worked for the Fulton County Medical Examiner's Office, they observed signs of two marks. The anthropologist describes the different lines on the bones as what happens when a saw is attempting to catch a groove and actually make a cut. You'll see the bones where there's the saw marks on the finger of the Wolfenbarger. You will see the end of the finger where it appears as though you see ridges on the bone where that saw cut. But even on June 3rd of 1999, they didn't even have these cases connected. They were found about 50, 60 feet from each other in that same area. They didn't have a basis to connect to. They were in the medical examiner's office as two separate case files. Skull found on Avon Avenue. And extremities found almost 2 months later on Avon Avenue. They expected that the cases may be connected, but they didn't have what you needed to actually combine and connect the cases and say that they were the same person. But what do you do at the beginning of a homicide investigation? The first thing that law enforcement does, especially when there's evidence of foul play, as in this case, when you find out who the victim is, who the person is, you go look at the background. And what did they find when they looked at what Melissa's life was like when she was alive in 97, 98? Who was she talking with? Did she have conflict with him? Is she married? What was her marriage like? Were there instances of abuse in the marriage? Had her husband ever been charged with anything related to that abuse, like hitting her? They looked at that information, and I'll tell you that at the time they did find the identity and were able to determine the identity of skull and extremities, Christopher Wolfenbarger was the primary suspect. I'll just tell you that. He was the person, the main person that they were looking at. He wasn't the only person, because you got to conduct a thorough and specific investigation, but they had evidence that Christopher and Melissa were involved in a tumultuous relationship, that Christopher was abusive, that he had struck her on multiple occasions. They had evidence that he had caused a black eye, that she had witnesses that observed bruises on her neck. They had evidence that at some point Melissa applied for a protective order to prevent contact with this defendant. You're also going to hear that on the day that Christopher was ordered to come to court, March 29th, ordered to come to court on July 29th, 1998, you will see that same day, Melissa appeared and requested for that case to be dismissed. Roughly 70 days after she was hit, 7 days after she went personally and applied for a protective order, 7 days after that, she goes back down to the courthouse and asks for it to be dismissed out of a prosecuting. You're going to hear from a lot of witnesses in this case. You're also going to hear from the domestic violence expert. And that domestic violence expert will be able to explain that that is not uncommon at all. The victims of domestic violence to come back and say, I want to prosecute. And you're going to hear about some of the reasons why that can happen. And that was the 21st of July, 1998. Officer Marlon Sutton responded to the residence at 824 Brookline Street in Atlanta. That was the marital residence of Christopher and Melissa Wolfenbarger, the family-owned home of the Wolfenbarger family that Christopher and Melissa were staying at the time. When Marlon Sutton arrived at that location, it was a response to a domestic violence incident. And when he arrived, he got an opportunity to view Melissa Wolfenbarger and see her in person. What he observed was someone that had bruises, someone that had been attacked, someone that was hysterical and afraid. He didn't see Christopher there that day, though. He wasn't there, he left. So she was instructed to do as she did. You don't feel safe, go and apply for protection order, which is what she did very much. You want to see those documents you last week. Day after this, she goes down and files for protection. By the time this case comes up, on March 1999, you'll see this document, particular state court documents, actually filing the formal charge of battery against this defendant, 1998. By the time it comes up to court, they can't find Melissa. Can't find it in March 1999. No way of knowing a month and a half later, Ed was found in front of his job. And I'm going to say this too. Less than a minute drive from his house in walking distance. You got this decomposed Ed, there between the night, in front of his job at Avon Avenue. And you got the location of Avon Avenue itself. So this is the Action Glass Company location right here. This is where Christopher Wolfenbarger worked. You'll see this map, and witnesses will explain. Witnesses that were at this location in April of '99 when her head was located. You'll see on the photographs there will be a sewer here, and you'll see where her head is located here. Within about 120 feet from his job. And then in June, you'll see where the extremities, the sawed-off legs of Melissa Wolfenbarger are found in this area. The detectives will tell you when they examined the location, it appeared as though they saw an animal here in a bag, right where the hair was located, from this area out up to Avon Avenue. So when they were able to make a connection, they come back with cadaver dogs, and they go back and look in this area, and that's how they find the extremities. That's how they find the June 3rd, 1999 legs, remaining parts to be found. We never found her torso, but the remaining parts to be found as well. And give you a perspective of where his job is and where Brookline Street is. This is actually Glass. This is the junkyard where the extremities were found. Here is the location of the sewer where head was found. And less than a minute drive is Brookline Street where Melissa and Christopher Wolfenbarger reside. Now, in 1999, you don't have the Atlanta Beltline. You don't have these buildings. This area is primarily wooded. But that is the location and the proximity of Christopher Wolfenbarger's job, to where his wife's head was found, where his wife's legs were found, and where they lived. This is a case about domestic violence. In addition to the evidence of the physical bruises on the person of Melissa Wolfenbarger, you're going to hear from her family. Her mother knew about the July 1998 attack. Melissa told her about it. She told her mother how Christopher was upset, wanted her to come back, and how he struck her in the face, how he grabbed her and dragged her by the hair. Nobody was arrested. Her mother was one of the persons that she told about that July incident. You're also going to hear from her sister, Tina Patton, who occasionally worked, though one time in particular in 1998, it was a 2 or 3 month period where Tina Patton, Melissa's sister, worked at a Waffle House. I believe it was Virginia Avenue Waffle House, and worked at a few Waffle Houses that year, Melissa in particular. But during that period, in the early part of 1998, Melissa and Tina Patton worked at the Waffle House. And she would tell you that there was one day that she observed, while she was working with Melissa during that period, she observed marks on the neck of Melissa, around the sides, and she knew immediately it looked, and she'll tell you this, it looked like someone had choked Melissa. And Melissa told her that, hey, let's go out. And You're going to hear from a man that Melissa would have seen right when she died. You're going to hear that Melissa planned on leaving his defendant. You're going to hear from his own mouth that they weren't on good terms when she left, when she went missing. Thomas Dixon was also working at a Waffle House when he met Melissa Wolfenbarger. And towards the end of 1998, they started seeing each other. And at one point, Melissa was staying in a lodge or hotel with Thomas Dixon. And he'll tell you that he was fully aware that she was with this defendant, Christopher Wolfenbarger, but he'll tell you that she wanted to leave. And during that week, she was staying with him. She really planned on doing that, but decided to go back to him, to Christopher in particular, to see her children. She missed her. And Thomas Dixon will tell you that the last time he saw Melissa Wolfenbarger, Christopher Wolfenbarger came up to that Waffle House. Melissa and Christopher had a talk, and Melissa got hysterical. She started crying. Thomas Dixon will tell you that he went outside to talk to Christopher and told him that he has to leave until 9 o'clock when she gets off. You're going to hear Thomas Dixon tell you that when Christopher left, he peeled out in his Volkswagen, and that was the last time he saw Melissa. He'll tell you that she never came back to work at Waffle House. She never called, she never texted. And that is the evidence to show that that's consistent with what you'll hear from her mother and sister regarding the last time anyone ever saw her. And as I said, she goes unidentified for 3 years. During this period, the medical examiner that is working in Fulton County is also working in Twiggs County, and is first attempting to determine if a headless corpse that they located in Twiggs County could potentially be connected with this skull they find in Avon over the planet. That was one thing they were looking into. There were several missing persons in and around the state of Georgia that they were attempting to get dental records for and repair. There were tooth extractions that were done during this period, but all in the attempts to find the identity of the person who that skull belonged to. There were attempts to conduct reconstruction. And what further confuses it is the anthropologist plots skull dimensions on the scale, and you get a range. And sometimes those ranges overlap. So at some point, they'll tell you that her skull looked like it had run over, damaged, and she, at some point, the anthropologist thought she considered the skull was male. All this was going on during this period from 1999, April, when they located the skull, June, when they located the extremities. All this is happening during this period, trying to find out who these remains belong to. And ultimately, Melissa doesn't get identified until 2003. And what triggered the identification ultimately is the arrest of Melissa Wolfenbarger's father. You're going to hear that Melissa Wolfenbarger's father essentially pled guilty to committing murder himself, committing multiple murders himself. And when he was arrested, it was a notorious publication, it was a notorious arrest. It garnered a lot of attention. You're going to hear that Carl Patton asked the lead detective when he was arrested, after he confessed, he asked the detective, told that his daughter was missing for 3 years, he had no needs. He asked if he could find his daughter. Well, the detective back in Fulton County Medical Examiner's office, we had this unidentified skull that they found 3 years ago. And with Carl Patton's statement, they obtained the dental records from Melissa Wolfenbarger's dentist, William Grant. Now, he had practiced in the 80s.
Well, did they refresh us? They shut him off. Well, good. We can't understand him anyway. All right, so the Law and Crime feed just refreshed itself. And they're on a break, so we'll end up getting caught up. We were towards the end here of this guy's slideshow. Well, that looks weird. Oh, did they end for the day or something? It looks like their stream isn't complete. So let's see. Because if we start at the beginning, he's in the middle of his argument. So I don't know what Law and Crime is doing.
Is Melissa's original records, x-rays, and they gave Dr. Meredith Hopkins, forensic dentist, conducted the examiner's office, conducted an examination, looked at the x-rays, looked at the fillings, looked at
All right, so yeah, they must have trimmed something out of their feed because it starts right in the middle of the prosecution's opening.
Thank you. Mr. McDermott, does the defense wish to make an opening statement?
Yes, ma'am.
Okay.
All right, so is Chad okay with just going to the defense's opening statement? I think we got more context on the case from just the general rundown and then from you guys sharing the details. But seriously, there's barely any. There's 6 minutes that's in the stream now. So let's start with the defense. That was weird.
You may proceed.
So this is McDermott or McDermott.
We can all agree that Melissa Wolfenbarger did suffer a tragic death. And you haven't yet heard the extent of which she had suffered a tragic life.
Thank you, Sunshine.
But the extent of her suffering in life and in death had nothing to do with Christopher Wolfenbarger. The state's story begins correctly. This is a case about a horrifying discovery of human remains that later became identified as Melissa Wolfenbarger's. But the evidence will show you over the next few days that the state's story has gaping holes in it. And that the state is going to ask you effectively to imagine in order to connect the dots between those gaping holes. To fill the gaps, if you will. What the state has declined to tell you in this case is far more important than what they have told you. And your job over the next few days is going to be to see those gaps, to refuse to imagine, and to demand proof of all the elements of the crime that is charged beyond a reasonable doubt. You're going to hear evidence, some of it from their own witnesses, that multiple other individuals could have had something to do with Melissa's death, starting with her own parents. You've heard mention already of the Flint River murders. Melissa's father, Carl Patton, committed a string of murders in the late 1970s. He was suspected of those murders for a long time. He was investigated, but they were not prosecuted and proved until 2003, 4 years after Melissa's disappearance and death. You'll be presented with evidence that Norma Patton, his wife, helped him directly commit at least 2 of those murders, to dispose of the bodies, to clean up the crime scenes, and to wrap up the bodies and dispose of them in ways that are somewhat similar to the way Melissa's remains were found. Carl, Melissa's father, died in prison last December. Melissa's father eventually confessed to killing 5 people. Some of those were for personal revenge. Some of those were contract killings for money. And at least 2 of those were murders of his own friends because they knew too much. All of the victims were either close friends or family members. In one case, Carl knew how to stage a crime scene. He turned what was a shooting to look like an accident of a car on train tracks.
Your Honor, I object to the defense's content of their opening statement.
An objection.
The statements made by counsel are just simply irrelevant to any issues that are presented during this trial.
As previously discussed, they're going to be relevant to third-party guilt and motives.
I'm going to overrule the objection on relevance grounds. I am, however, going to request that you, in line with our earlier discussion pre-trial, limit some of the details unless and until that evidence is presented to the jury.
I will not get into any more granular detail than I have so far.
Thank you.
Satisfactory?
Yes, sir.
Melissa's mother in 2 of those murders was a co-defendant. She confessed to planning, 2 cold-blooded murders, cleaning up the blood, bleaching the floor, etc. And the murders from which the name that comes to those murders is the Flint River murders, is because one of those bodies was dumped in the Flint River, the other in the Altmoultrie River. And the only reason Norma didn't go to prison like Carl did was because she got immunity to testify against him. And she'll be here to testify this week. The evidence will show that there is also a Patton family associate who also had very strong motives to kill Melissa. For trying to get him prosecuted for allegedly molesting her in the 90s, and also because his father later turned out, to his knowledge, was one of Carl's victims. And until he learned that, he was a family friend and hung out with the family. That man's name is Eric Martin Jackson. You'll find out later that at some point Martin learned what Melissa's father had done to his father. And he goes and buys a series of burial plots at a cemetery in 1997, a year before Melissa goes missing, or maybe a year and a half. And he buys them in the very cemetery that Melissa is buried in today, and later, because later he sold those plots to her family. And there are others I'll touch on in just a minute. We expect Norma Patton to come here and testify that she had a loving relationship with Melissa, that Melissa loved her, communicated with her, stayed in touch with her, tried to get away from Christopher's control every chance she could get, so she could come back to Norma's home and see her. But the evidence is going to show that Melissa was actually abused by her mother in her own home for many years and started running away frequently. Her mother locked her in a room all day, every day, from roughly ages 7 to 12. The evidence will show that their home was so foul and dirty that Melissa acquired a foul smell in her clothes and hair that made the other kids at school bully her and tease her. You'll hear evidence from Melissa's next-door neighbor and childhood friend that she will detail the abuse that she endured in that house. Moreover, at some point before Melissa ran away, her sister Tina had a pregnancy in that house, delivered the baby in the house secretly, and tried to dispose of it secretly in a clothes hamper in the house. 13-year-old Melissa discovered that baby's corpse. She eventually told school officials, who later called the police, and it was at that point that Melissa began running away from her home regularly. Christopher, in fact, first met Melissa because she ran away from home. And through a mutual friend, they met at that mutual friend's house. Now, Christopher and Melissa eventually got married, and they did so fairly hurriedly. They were both 17 when they got married. They had 2 children, very young, in very close succession. When Melissa was still pregnant with her second child in 1996, she went to Christopher's mother, Kathy Wolfenbarger, who will testify that Melissa asked her if she would take custody of their children temporarily. And she did. When Melissa got in some legal trouble the next year in Gwinnett County and went on probation for theft, it was after that that they began to, that's when they moved up to Brookline in July of '98. Their children lived with Christopher's mother in Stockbridge and later in Locust Grove, Georgia. When Christopher and Melissa moved up to Brookline in 1998, the children did not go with them. Now, you've heard some talk about an incident that happened in July of 1998 when Melissa took out charges against Christopher. You also heard the state tell you that Melissa came back and dropped the request for that protective order. What they didn't tell you is the very next day, Melissa calls Kathy Wolfenbarger from the Henry County Superior Court and asks her to please come down and sign the papers to make her custody of those children permanent. To make Kathy's custody of Melissa's children permanent. And Melissa permanently relinquishes her parental rights to those children.
All right, so this is opening statements. He's promising that we're going to see that right before, because remember, the theory is there's a disappearance of Melissa in this 1998 time period towards the end of the year. The state is arguing that that disappearance is because of Christopher Wolfenbarger's actions, and, you know, he killed her and knew about it and didn't report her missing because he knew he was the one that did it. But the defense is arguing, they're leaning into this idea that Christopher just thought she went to move on with her life. And there was an application for a temporary protection order taken out by Melissa. And now we're hearing that we're going to see that Melissa tried to hand over custody of her kids. And just at a quick instinct, to me, that would be consistent with someone who might be wanting to leave the state. And they say, you know what, maybe my kids would be better suited with this other member of the family. So that's an interesting detail. I mean, if they can deliver on that, that's a little something to work with.
One of the reasons Melissa originally gave for giving her children over to Kathy Wolfenbarger, and she tells this to Kathy, and she tells this also to Christopher's sister independently, was that she did not want her parents to have anything to do with her children, because they are bad people.
Bad.
After relinquishing her parental rights, Melissa quit working around that time at the Waffle House in East Point with her sister. And for some reason begins randomly working at a Waffle House clear up in Doraville. No one knows why she went up there. But according to everyone, no one had any connections up there, friends or family or anything. But she goes up there and starts working. Melissa started spending more and more time in Doraville, days at a time, working double shifts, spending the night at someone's house, and then multiple days, and days turned into weeks, she would be gone from Christopher's house. And it was at that time that she had started seeing Thomas Michael Dixon, the state mentioned a while ago. We'll have a chance to cross-examine him. In October of that year, Melissa got arrested in Gwinnett County for violating her probation, and she spent 30 days in jail until early November. The terms of her probation required her to do community service. This was outstanding from 1997, still in effect. She was to do community service. She was to take GED classes, and she was to report regularly to her probation officer, and she had not done any of that. And so they arrested her, gave her 30 days in jail, and then released her back on the same terms of probation. Within 1 month, she is already violating her probation again. Although she was not rearrested at that time. So at this point in her life, Melissa was spending as much, if not more, time in Doraville as she was at Christopher's house. She only occasionally came back to see Christopher. She had her own job. She had her own money. She had her own circle of friends. She had her own freedom. She had no obligations to her children. And so when in December of 1998, she did not come home for several weeks or months, Christopher could safely assume she had decided to live her own life on her own terms, wherever she decided to live. Moreover, if Christopher had raised a stink about it at the time, Melissa was in violation of her probation. She would have been arrested. mother, Norma, is expected to testify variously, as you've already heard, that when she didn't hear from Melissa at Christmas in 1998, that's when she knew something was wrong. Alternatively, however, she will testify that no, it was not until my birthday rolled around. That's when I knew something was wrong. She will tell multiple versions of this story. In one version of the story, well, let me back up. The evidence will show you that in multiple versions of the story, whichever version she tells, she never reports Melissa missing until 2000, January of 2000. If something was wrong in December of 98, something was wrong in February of 99 on her birthday, something is wrong a month later, a month later, a month later, her mother doesn't report it. She doesn't file a missing persons report until 2000. The human remains in this case, as you've heard, were found on Avon Avenue. It's an industrial area near the west end of Atlanta. The evidence will show that it just so happens Melissa's father, Carl Patton, was familiar with this area. He grew up in a childhood home on Main Street in College Park. It's just a few miles down the road. Further, the evidence will show that Norma and Carl actually went up to Brookline Street right after her birthday in February of 1999. They found Christopher's empty house at that time. They learned from a neighbor that Christopher had moved out sometime between Christmas and New Year's. They also learned that from that neighbor that Christopher worked at Action Glass down on Avon Avenue. So they drove down to Avon Avenue and talked to the people at Action Glass. And they learned that he had been let go there. Again, this is February 1999. Carl and Norma Patton knew where Chris worked and where he lived months before the head was found on Avon Avenue, right beside where he worked. The state is correct that Melissa's mother and sister are going to testify against Christopher. They're going to blame him. They're going to call him a domestic abuser. But there's a lot of context you don't know. Keep in mind, as we've already said, the evidence is going to show that Melissa only met Christopher when she ran away from home. The evidence is also going to show you that Norma Patton has consistently, out of her own mouth, stated that she absolutely hates Christopher. From the very first time she ever saw him, she hated him. She worked and did everything in her power possible to prevent Christopher from seeing Melissa. When he was 16, would not let them date, or tried to prevent them from dating. Tried to prevent Melissa from leaving the house. Tried to prevent them from getting married. She tried to force Melissa onto birth control so that she could not get pregnant. Melissa's older sister joined that opposition to Christopher as well. You'll hear it admitted from her own mouth that she did not like Christopher. No one in her family liked Christopher. And that she tried everything she could, perpetually, to intervene in Christopher and Melissa's marriage to get Melissa to leave Chris. The evidence is going to show that any claims of abuse or bruises on Christopher's part only began to be generated after Melissa started working with Tina at Waffle House. And the evidence of claims of abuse only come from witnesses who came under the influence of Norma and Tina. Christopher and Melissa, as I said, had two children, Chrissy and Joey. Chrissy was born in August of 1995, Joey 11 months later. Again, the state is going to present testimony from Norma and Tina, who will say that Melissa would never, under any circumstances, have abandoned her children. She would not have just left and never kept contact with her children. Impossible. But we already know that, in fact, she did legally abandon them. And the evidence will show that she also practically abandoned them. As I said earlier, when Christopher and Melissa moved up to Brookline Street, the children didn't come with them. They stayed way back in Stockbridge. The children were raised by their grandmother, believing that she was their mother. In September of 1998, when Melissa started leaving for large portions of the time with her work friends and her new lover, Thomas Dixon, she rarely returned to Brookline Street, where Christopher was. She even less hardly ever went down to Stockbridge. You will hear testimony that she rarely visited her children during this time, and that she rarely ever even called them during this time. Whatever Melissa's own personal aspirations might have been in regard to her children, the one thing we do know is the evidence will show that she rarely ever contacted them, and all but forgot about them. You'll hear testimony from Christopher and Melissa's own daughter, who's now grown up, of course. Her name's Christina. Some call her Chrissy. She will testify as a state's witness. She will say that she remembers to the day when her mother disappeared and all the pictures and belongings were removed from the house. Again, the evidence will show that she didn't live in that house. She lived in Stockbridge. The evidence will show you that at that time, Chrissy was every bit of 3 years old. Moreover, Christopher and Melissa's children didn't live in that house, as I said. Chrissy will also tell you that years later, she remembers Christopher making these offhand comments about he knows how to get away with murder, and the key is to hide the body, or to put it under the foundation of a house that's being built so they'll concrete over it and no one will ever find it. And there are various versions of that story. Christopher's son, Joey, who's also now grown up, will also testify, and he will say he was in the room when such comments were made. And that Christopher was speaking in the context of the boasts that Carl Patton used to make, who was a known killer. We'll have evidence in this trial that early in their relationship, Carl hired Christopher to help him in the roofing business. Chris spent time around Carl and heard him say these things. Even Chrissy will admit that when Christopher made such comments, it was contextual within a discussion and had nothing to do with Melissa whatsoever. Chrissy will also admit that everything she knows about the case, she learned from Norma Patton. Remember what I said at the outset. The state's going to present little points of circumstantial evidence, and they're going to ask you to use your imagination to fill in the gaps. Here are some of the gaps I want you to pay attention to. The state will not present any evidence of a cause of death. The state will not present any evidence of a murder weapon. The evidence obviously will show that there were remains that were discovered and that there were marks on the bones. But those wounds are all post-mortem. The state will present you with no evidence of how she died. The state will present no evidence of when she died or where she died. The state will present you with no evidence of where she was dismembered or when or how she was dismembered. They won't present any evidence of how she was transported to the site in the condition that she was. The state will provide claims about a saw that went missing from Christopher's work, allegedly around the time that Christopher was there. No evidence will show, even though the state claims otherwise, that he stole a saw from them, or that he was terminated for that reason. Furthermore, there's no proof that the kind of tool that actually made the marks on these bones was a saw. If so, what kind of saw? We have no evidence of what type of saw it would have been. We've got no evidence that will show that markings are distinctive of this reciprocating saw that was taken versus the circular saw he mentioned when he started his story. Furthermore, your common sense will tell you that there are about a literal million saws in the state of Georgia. Anybody can access a saw. Anyone can access a wide variety of types of saws. You'll hear from investigators from the APD. They will admit that once Melissa's remains were identified, they searched Christopher and Melissa's house on Brookline Street. They searched every inch of the home, inside, outside, every room, basement. They sprayed the entire house with a reactive agent that discovers drops of blood. Not a single drop was found. They took paint samples from every room. Why? Because when Melissa's head was examined, there were chips of paint in her hair. There were synthetic fibers in her hair. And forensic evidence will show that. The fibers were, in fact, found to be consistent with some kind of a bath mat or even a carpet. Very broad category. When Melissa's remains were the paint samples of her remains did not match any of the paint samples from Christopher's house. There was no match of any fiber from Christopher's house. A pubic hair was found on Melissa's remains. Christopher willingly submitted his pubic hair samples. They didn't match. Head hair samples were found. Christopher submitted head hair samples. The head hair samples didn't match. The medical examiners in this case made DNA analysis of the head almost impossible because one of the medical examiners or anthropologists soaked it in bleach. But the technology still won out in the end. The plastic bags in which the remains have been kept were recently re-examined using the most powerful DNA testing available in modern times, detecting trace amounts of DNA. And sure enough, one of those bags returned a profile that was viable for testing against subjects. It said there were at least 5 human contributors touching this bag. 2 of them were male. Christopher submitted his DNA. It didn't match. So the state has some huge gaps it needs to fill. And here's how we anticipate that they're going to try to fill that gap. We expect the state will also call a witness who is somewhat of an expert in the area of domestic violence or abuse. Perhaps you think, well, there's no DNA, there's no fiber evidence, there's no trace evidence in the paint chips. The really important evidence must be in the domestic abuse. But just as with the DNA and the paint chips and the fiber, etc., the expert will offer no support for the prosecution's theory in this case, and here's why. She doesn't know anything about the case. She's never interviewed Chris. She's never read a single police report. She's never even talked to the DAs about the facts of this case. Instead, she's simply going to say that she is a domestic violence expert and tell you signs and symptoms of domestic violence. We anticipate that their testimony on those matters will do nothing to prove that Christopher Wolfenbarger is a cold-blooded murderer. She doesn't know anything about him. She knows nothing. And we will ask you when trial is over to reject that level of fake expert testimony. Another thing, the state's going to offer evidence to say Christopher was the last person to to see Melissa alive. In December of 1998, you've already heard it. But other evidence is going to show that Melissa's sister, Tina, actually saw her the following spring. At that time, Christopher had already long moved out of the area. Although Carl Patton was serving 5 life sentences in prison throughout this whole period up until he died last December, that did not stop Norma Patton from firmly expecting he would be paroled at some point. And she began looking into his parole within about 12 years after his life sentence had been served, his first out of 4 or 5. And the law technically at the time allowed for someone serving a life sentence to be eligible for parole after 14 years of service in prison. The evidence is going to show you that Norma operated on the belief that the only reason Carl had not been paroled was because his son-in-law, Christopher, had not yet been arrested. She will state explicitly out of her own mouth in a police interview that she believed that as soon as Christopher would be locked up, her husband would be released to come home. And she worked tirelessly for years with the DAs, with the police, and with media campaigns to make sure that happened. Ironically, the evidence will show that the investigators spent hardly any time at all investigating these other potential suspects. No hair samples were taken from them, no DNA samples were taken from them, no pubic hair samples, no searches of their homes, no paint chip samples taken from their houses. No one took DNA samples for this reason from the sister or the accused molester in her home or the friend down the road or anyone else. The evidence will show at most that Melissa somehow died and that someone tried to dispose of parts of her body. The evidence will show that everything beyond that is speculation and imagination. The evidence, as I said, won't show you a cause of death, a weapon, an instrument of death, an incident that led to her death, who dismembered or transported or scattered her remains. There will not be proof beyond a reasonable doubt in this case. There's no DNA, there's no high-powered technology, there's no expert testimony, there's no fiber evidence, no surveillance, no snitches, no co-conspirators, no confession, no eyewitnesses. The evidence will show that the state expects you to fill in all those missing gaps with your imagination. There is no evidence of these charges in this case, and that's why we will ask you at the end of this case to return a verdict of not guilty.
Thank you. Ladies and gentlemen, it's about 12:15, and so we are going to break for lunch. And when we return, we'll begin the evidence presentation portion of the trial. So it is 12:12. We're going to call it 12:15 and break until 1:15 for you to get lunch. Jurors are excused if the deputy will please escort them out of the room.
All right, for the jury.
All right, so we're going to time travel. Watch the clock jump.
So I've had a chance.
I don't really have a solid take. I have to go back and watch the state's opening because it was really hard for me to understand. It was a little easier to understand the speech from the defense attorney. It just seemed like it was coming through a little better. And obviously they're going to point to a bunch of things that we should be looking at that are going to create reasonable doubt. But I still want to get to a solid idea of the state's storyline. So unfortunately, headphones or something. But we're going to get into the presentation of evidence. So I'm looking for certain things, but mostly I'm a blank slate going into this.
To look, Madam Court Reporter, we're going to ready to go on the record after we get Mr. Wolfenbarger. Thank you, sir.
Oh, they got to get the defendant. They were going to start without the defendant. Also, shout out to Taybiz TV. Said, let's get the likes up to at least 350. That'd be very nice. We're going to be hanging out with Taybiz later today, close to 7 p.m., 6:45 p.m. Eastern. He's going to be streaming. It's going to be I don't want to say a good time because it's serious subject matter, but always learn a lot over there, and Taybiz does a great job presenting whenever he's doing a stream. Yeah, I hate this too, Law and Lyric, when there's no investigation into other people. It creates knowledge gaps. It feels incomplete. It creates room for a what if. Yana says Jim did it.
Okay, we are back on the record after our lunch break. Mr. Wolfenbarger is present here in the courtroom. And the purpose of our gathering before the jury returns for the afternoon session was to
It's me pulling up Tayviz's link.
discuss and see about resolving, giving y'all rulings on the photographs issue. So during lunch, I had an opportunity to review the email that Mr. Fawcett forwarded to me. That was an email from Mr. McDermott regarding his objections to certain photographs. I've also had a chance to review the flash drive that was provided to me, which was a PDF of the various photographs, most of which are not objected to. I think my understanding is that the state had attempted to limit the photographs to some extent, and that Mr. McDermott was accepted that many of them that are in the PDF would be admitted, and that the ones we have still pending as objections have been identified by Mr. McDermott specifically by number. And so I'd like to just sort of take them up in turn, and understanding that the baseline here is these are gruesome photos because of the nature, the manner in which Ms. Wolfenbarger's body was disposed of, and that the manner in which the ME does its work and documents its work, that those things are necessarily gruesome and graphic. And so the question then becomes, are they relevant? And if they are relevant, are they overly prejudicial or for some other reason cumulative, et cetera? Mr. McDermott, if you want to start, I think your first one was photo number 35.
I'm trying to locate the file that has all
Sure,
we're talking about.
that's fine.
I seem to have lost the email. Oh, I remember. Now I have that in the folder. Give me just 1 minute, please.
Yes, sir.
Okay, and the number again, please?
35, which, so it seems to me, and correct me if I'm wrong, but it seems to me that at least the first few that you're objecting to, 35 through 51, 53, you might have additional objections, but it also seems as if your objection is to them in that clinical context, in the medical examiner's possession on like a white table, as opposed to, for example, Exhibit 16, which is also a photograph of the head that was recovered, but in the field as it was discovered.
Yeah, I just felt that, I don't see what that adds. It's not necessary to complete any part of the medical examiner's testimony, and I think it's just cumulative in that sense.
Okay. As we move on to 39 through 42, which again, I think it's fair to describe as sort of various photographs of Admittedly, a body part that I actually can't recognize by what it looks like.
Which one, the first one?
39 through 42, I just have them labeled generally as body parts. One of them might be a leg, but I don't know what I'm looking at because I don't have that training, so.
So again, we have pictures of body, I think that exact body part in the field. We have a picture of the black bag just like that already in the field. I don't see what it adds to the medical examiner's testimony to show the same photograph in the same way, just on a different table instead of the ground. So I just think that's cumulative and unnecessary.
Okay, so I did look through all of the photographs, and although I did note there's a relatively close-up photograph of the head. To be in the field seemed to be in plastic bags as opposed to the actual body part that was recovered from inside the plastic bag.
21.
Yeah, the 21, I agree with you, does appear to be or of plastic bags. And correct me if I'm wrong, Mr. Fawcett or Mr. Wilson, but I assume that the state's evidence is going to be that bags.
That's correct, Judge.
I don't know. I feel like, so I'm supposed to have bad weather, but I didn't know it was now, and my StreamYard's acting weird. So that's a time. I don't know. Let's see if it keeps doing that.
And what about Mr. McDermott, 44 through 47?
Same objection.
Yeah, we're not supposed to have storms for another like hour and a half, so.
And then 50. I don't even know what 50 is. Is it a
Again?
tooth?
I
Uh-oh.
believe that's, and this is from me talking to Dr. Terry, and
Yes,
she
sir.
wasn't even certain. But she thought it was like a top of the leg at the knee, and that's the cartilage between the knee joints, but maybe,
Okay.
maybe not.
Okay. This was maybe because I don't know what it is or didn't recognize it upon seeing it, probably the least offensive of the photographs that I saw.
It's gory, it's almost like, rock collecting or something.
Right. But what is the nature of your objection to that particular one?
What does that do for the medical examiner's testimony? Because we're trying to get to the nature of the charges in this case. What does that lend to, relevant to her testimony toward those charges? I don't see any necessity. So we've got just one more body part, it's random, doesn't really apply to anything. We don't even know what it is.
And she wasn't even sure. What we talking
I'm fine with removing that one, Judge.
Okay.
All right,
We'll
so
remove 50.
State said we can rule it out.
Okay. And then we move on to 51, which seems to be a collection of the various body parts. Is this after cleaning or before?
I think that was before cleaning. I think that is before, Judge.
Okay.
Oh, well, clearly some of the bones have been stripped of any flesh that was on them. So I think you're looking at some of,
Well, that's why I asked the question. Do some of those bones, did they have flesh on them when they were collected? I don't know.
I'm not aware from any description of what was collected in the field and taken from the bags that they were just bones when they came out.
Okay.
So I think these are all, or at least the ones that are just bones here, have been stripped by the medical examiner.
Well,
Look at her face.
certainly, I don't know why the top portion of the leg, I don't know why that would be, why that wouldn't be stripped, and the ones at the bottom would. But I know that some of the testimony that I expect is that there was at least one
Broken
animal that
Baker.
had gotten to the bag. There was the possibility of other animals, because the body parts were out in that wooded area for several months. And And I would say in hot conditions, which one thing the doctors will say is they can't, because of the conditions and the variables, they can't say what rate of decomposition there was. And the other point I would say to that is there's going to be some manipulation of the remains so that the medical examiner can examine and look at potential damage. For instance, I don't find anything particularly gruesome about just looking at a bone itself, especially one that's been stripped of flesh, if that's what indeed happened. But the bone and the condition.
Hold on, run that back. I mean, lawyers work in this day in and day out when they are criminal defense attorneys and take on, murder cases.
The examiner can examine and look at potential damage. For instance, I don't find anything particularly gruesome about just looking.
I don't find anything particularly gruesome about looking at something that's just a bone with the flesh scraped away. What?
And a bone itself,
Oh.
especially one that's been stripped of flesh, if that's what
Disagree.
But the bone and the condition that it is in the photographs when they're examined it allow them to see the damage to it. That's what allows them to see the appearance of assault, striking the bone. So for that reason alone, that visual image should be allowed to be displayed for the jury. It aids the testimony of the expert, and it allows for that expert to explain why they believe there are signs of assault on the bones of the spot.
Okay. And then I have 53, 54, 57, and 59, which at least to my untrained eye in the absence of evidence seem to me to be an effort to document alleged saw marks, tool marks on the bones.
Yeah, and I was trying to make an effort to include at least one example of each one of those that's independent. But where they're double pictures of the same thing, I think it's cumulative and unnecessary. That's also why I think that, we've got these close-ups where there are tool marks. That's why we don't need a whole table with the bones laid out. That you can't see any tool marks from that distance anyway. That's just cumulative and gory for no other reason. Doesn't document anything the medical examiner did except take the flesh off the bones. But, and maybe I missed one, that's fine, I'll hear about it. But as far as going through the list, I tried to include one example of each specimen that had tool marks that was unique. And I only object to the ones I thought was cumulative.
Okay.
Yeah.
Just one second, Mr. Fawcett, because I am going to let you respond. So to be clear, I didn't just limit my review to the numbers that Mr. McDermott mentioned, right? I was looking at them as trying to take them as a whole with particular attention to the ones that you had asserted, looking for things like needless accumulation that would just be gory for no reason versus particular reasons. Again, without any context, I don't know if, for example, 53, 54, 55, 56, 57, 58 are different bones with saw marks in them or different angles of the same saw marks on the same bone.
I can't tell you with definitive accuracy, but my inclination was 54, 55 were the same, just different angles.
And Mr. Fawcett, the point of my asking that question is I believe that the presence of tool marks and the demonstration of them is relevant. Nobody's going to enjoy that process, but it's relevant and needs to be presented. If it is different bones, right, saw marks on multiple bones, I don't think that's cumulative. If it is, unless you anticipate that the medical examiner is going to say that there is a specific reason for two different photographs from, say, two different angles or something like that of saw marks on the same bone, then I would ask the state to endeavor to further limit the photographs.
Yeah.
So to Mr. That's okay, sorry. So to Mr. McDermott's point, if it is three angles of the same saw marks on the same bone, then perhaps one would be sufficient unless you're going to tell me that the medical examiner has a particular reason for having taken that photograph in the manner at which it was taken in order to enable them to conduct their examination.
In light of that, Your Honor, I would propose taking out Exhibit 55, 58, and 59. I believe that would eliminate, and the intent of including 55 and 54 was that the different angles I think would aid the testimony, but I think that the expert can testify based off of the one photo. So I would propose taking out 55, 58, and 59.
Okay. So,
Your Honor, did I already object to 53?
you did?
Okay. Oh, I'll wait. So, did we talk about that one yet?
No, I wanted to start with the saw marks because it appeared to my eye that your point was that, and I thought that was correct, that there were multiple angles of the same saw marks on the same bone, and absent some particular showing of necessity of multiple angles of it, I wanted to see if we could pare that down. Now, going back to the 53, really it's the group of photographs from, say, 39 to 53, which are the various body parts.
Right. These Georgia cases are
As
crazy.
a general proposition, their existence and condition in the field is relevant and admissible, right? Those photographs that document that, as long as they're not cumulative, as long as we don't have 7 photographs of the same thing. I believe that starting with 44, it might be, well, no, I think all of them are. Starting with 35 through 53, they're all in the ME's office, right? Those are all as part of documenting. Okay.
Yes, sir. Yes, sir.
Thank you. Other than, Mr. McDermott, is your argument that, I think I heard one argument, which was that they are the photographs 35 through 53 are cumulative of photographs in the field and don't need to be shown again. Do you also assert that photographs between 35 and 53 are cumulative of one another, that there are multiple photographs?
In some cases, yes, Your Honor.
Okay. So the same request I made earlier, Mr. Fawcett, and I trust that you endeavored to already do that. But to the extent that the photographs taken in the medical examiner's office are necessary and relevant to demonstrate how the examiner examined the remains to arrive at their opinions, I think those are relevant and admissible despite their graphic nature. Thank you. But I would also want to avoid needless repetition of the same photograph.
In further, further effort to comply with the court's instruction, I would propose eliminating 39, 38, and 35. I believe that would eliminate the 2 photographs of the head. That would just be the head and the field. 39 would be I believe, looks like a knee portion to me. There would still be that photograph of that in the field, and might benefit the jury that it's not as close up as that. And
Guys, Doug's going to be on Justice Served TV at 6, so that's going to be so exciting. He had tweeted, and you guys pointed it out, he had tweeted like, oh, that was rough, I think he said. Let's see exactly what he said. But it will be good to hear from him. What a tough position to be in, and if you haven't been over on X or seen us talk about it, there's been a viral discourse where a surprisingly huge number of people seem to think that public defenders are the devil for taking cases when the defendant is accused of something especially heinous. And I think what a perfect case in the moment to see Doug Weinstein do his job well, be an advocate for his client that's accused of dismembering his wife and disposing of her remains. What a perfect time for him to be that example of somebody giving a defendant the due process they deserve. Yeah, and he said, well, that was brutal, is how he worded it. So that's going to be good. Let me grab a link for that. I'll drop it in the chat for you guys. If you're on Replay Crew, just search Justice Served TV.
then 35, which is the neck. So I
No,
think
35 is the head.
35 is the head. Okay, so then I would take out 38.
Okay.
And I think 36 and 37 are representative of, I think, both sides of that net column, so I would propose that.
Okay. Mr. McDermott?
Well, I'm fine with those deletions. I would also ask that 53 be deleted because it's repetitious of 56. And although I think there's a question to be asked fairly, on 53, you can see the kind of connective tissue at the far right side. If that was part of the examiner's testimony, that that's how, part of how the leg was removed, or something of that nature, it would be more relevant. But I would say choose between one of those two photos. I would prefer 56 because it's less gruesome.
53 and 56.
They're the same bones from different angles.
Mr. Fossett?
I'm fine with that, Judge.
Okay, so which one?
53.
I'm sorry, you'll remove 53 or you'll remove 56?
I'll take out 53.
Okay. So what I have so far is the state has agreed to remove 35, which is a second photograph of the head, even though we have a close-up of the recovered head in the field, which is remaining in evidence. That the state has agreed to withdraw 38, 39, 53, I'm sorry, 50, 53, 58, and 59. So with those agreements to remove those photographs, Mr. McDermott, other than your objection to the nature of the evidence and its graphic nature, et cetera, do you still specifically have other objections you wish to make a record of?
Unless I wrote them down and you have it?
Yes, sir.
Then no.
Okay. Well, to try and be as clear as I can, to make the record as clear as we can, Mr. McDermott moved to exclude 35, and 35 has been voluntarily withdrawn by the state. Mr. McDermott did not move to remove 38. He did move to exclude 39 through 42. The state has agreed to remove 39, but to keep 40, 41, and 42. So to the extent necessary, I'm going to deny Mr. McDermott's motion to exclude photographs number 40, 41, and 42. Mr. McDermott moved to exclude 44, 46, and 47. I'm denying that motion. As to Mr. McDermott moved to exclude photograph 50, the state has agreed to remove that one. Mr. McDermott moved to exclude 51. That motion is denied. Mr. McDermott moved to exclude 53. 53 has been voluntarily withdrawn by the state. Mr. McDermott moved to exclude 54, 57, and 59 that are various angles of saw marks. Other photographs in the packet that the state has offered, including 55, 58, and 59, are various angles of those same saw marks. And the state has agreed to withdraw 55, 58, and 59. And based on that showing, the defendant's motion to exclude 54 and 57 are denied, and the defense's motion to exclude 59 is granted because the state agreed to withdraw it. Anything else, Mr. McDermott, about the photos?
No, Your Honor.
Okay. Mr. Fossett, anything that we need to take up before we get started with the evidence?
No, Judge, if I could just have a few minutes to take out the exhibit.
I was just going to say, yeah, and I'll run through them again. You have, my notes indicate agreed to withdraw 35, 50, 53, 58, 59.
Yes.
Is that going to give me enough time for a comfort break?
Yes, although I do have all my jurors, so as soon as y'all can get back and be ready, we'll be ready.
Alrighty. We can time travel through the comfort break. Oh, that was actually really, really quick. It's only a couple minutes.
Yes, sir.
We're being told by the jail that they have lost their clippers. And I don't know.
Oh, 'cause of his hair.
About that, other than maybe
All right, chat. Let's be honest. I mean, I try not to judge too much. I judge how things are being presented. I try not to judge appearances unless I think demeanor is going to be evaluated in a positive or negative way by the jury. But I did sit here wondering, is this hairstyle gonna look a little floofy or awkward to the jurors? And now we have the defense attorney finding out that there's no clippers. So potentially this defendant wanted to do some grooming, clean his hair up, and couldn't do it because wherever he's being held in Fulton County, the clippers are broken. And I know it seems so, it's just a haircut. No, it's super significant. I think presentation is way more important than it necessarily should be, but it is. So here we go, Fulton County.
Scold them mightily. It would be very helpful. I got to do what I can.
Thank you.
Thank you.
Hey, deputies, can you do me a favor? I entered a grooming order 2 days ago for Mr. Wolfenbarger. He's still not been allowed or enabled to have a haircut. If I could ask the two of y'all to please prioritize that and communicate it to whomever you need to so that that can happen today in advance of tomorrow, I'd appreciate it. Thank you. Anything else, Mr. McDermott? Okay. We have everyone back, and I'm told that we have all of our jurors. Are we ready to get started? Wow. Yet. I don't want to rush. Mr. Kassotis for a moment.
Yes, Your Honor. I just will let the court know the first witness does require a wheelchair.
Okay.
So he may take a little bit of time to, but should I go ahead and
Is that person going to be able to get on the witness stand, or are they going to, we're just going to?
Probably on the side or the front or however you would do it.
Okay. Are we concerned at all about volume?
Can't go until he, maybe.
Okay.
Is there a portable mic that we can get a hold of?
Technically, these things, although they are affixed very well, are in fact removable if it came right down to it. I'm not worried about the jury hearing that person. I'm worried about the court reporter and the other people in the courtroom.
You mean to next to it?
Yes, sir. Like the whole base.
I mean, you yeah, he's right here. And he's going to be right here. Yeah.
Okay. That is the best way to do it.
Okay. State's ready.
Mr. McDermott, is defense ready?
Yes, ma'am.
Okay, we're ready for the jurors.
All right, we can time travel with this.
Okay.
We can boost again. Let's see how the witness microphone sounds. Dizzy, Kassotis had the gym on the sides, Nicholas on the top.
And if you'll turn around, sir, so that you'll be facing sort of this general direction towards the deputy, where the deputy's standing, if you can. Turn a little bit more so you're facing the deputy so that you won't have your back to the jury. That's good, sir. Now, are you able to raise your right hand, sir? Okay. If you would, thank you.
This is Symone, you're about to give the court today. Shall the truth, the whole truth, and nothing but the truth? Yes. You may lower your right hand, state and spell your name for the record, please.
George W. McPeakin. That is spelled after MC, after D-A-C-H-E-R-S.
Okay. Mr. McEachern, this is the judge talking. I'm behind you, so don't worry about that. If you could, just because you don't have a microphone, if you could just try to speak up when you're answering questions to make sure everyone in the courtroom can hear you. Okay, sir? Thank you. Go ahead, Mr. Wilson.
Thank you, Your Honor. And you live in Atlanta, sir?
I do, sir.
How long have you lived there?
28 years.
And did you ever live in the area of Avon Avenue, in the general area?
I do, sir.
Do you still live there?
I do, sir.
How long have you lived at your present address? Yeah, okay, thank you.
I think you said 49 years?
What did you do for a living?
I want these things for my very sad.
I apologize, we can't hear him.
I work at
Hold on a second, sir. Should I try to get the microphone?
I'd say give it a try.
I'm gonna lower this because that's not, well, Kev, so you might not see anything wrong with his hair, but the defense has the right to have, when they're in custody already, they have the right to have access to grooming and proper clothing to present an appearance in court. And that seems like it's being denied to him, even though the court ordered it, because the facility he's in is just saying, oops, too bad, so sad, our clippers are broken. So it's a right that they're entitled to, and it's a right that's being denied here. So
Tape
really,
together.
to me, it's typical Fulton County. Like, we're back in Fulton County today, finding out that things don't work, things are broken. Oops. Oh well. A little bit similar reminds me of how they would persistently wake Diamante Kendrick up at like 2 a.m. and he'd be too tired in court, and that impacts your right as a defendant to aid in your defense. So yeah, Fulton County also hates good audio. We're gonna lower it a little bit and see if he gets mic'd up, because I don't want to blare anyone's ears out with how loud everyone else is in comparison.
Yes, please. It's coming though. I can see it moving.
All right.
They're struggling. Oh my gosh. And yeah, like, this isn't a bench trial where a judge might be more inclined to put off an appearance. Although there are judges that like really, really care about how somebody presents themselves when they show up for court. Some judges will even yell at attorneys if they feel like the attorney isn't showing enough of a care and treating it like a formal setting. But especially with the jury.
See if you can get closer to the microphone that we have there for you, sir. Yes, sir. Mr. Yes, for now. Hang on. I apologize.
All right.
Here. Yes, ma'am. And then, Mr. McEachern, if you could turn a little bit more and face the jury, please, sir. And now.
Oh, so CCG working in federal court, the judge made all attorneys wear a jacket when appearing.
Yes, George W. McEachern.
Much better, sir.
Last name spelled capital MC, capital EACHERN.
Thank you, sir. Go ahead, Mr. Wilson.
Thank you, Your Honor. And do you remember in April, at the end of April of 1999, an unusual thing happening an unusual thing you found on Avon Avenue?
Yes, I went for a walk that morning to the bank, and on my way back, I came up Avon Avenue, and as
And what did you see?
I saw a head, a human head that was laying in the street. So I walked up to it, and I looked down at it, and I saw it was a head.
How did you know it was a head?
Well, through my training in martial science and pure direction, I recognize human heads.
Human head?
Yeah.
What did you do?
I took a stick and I moved it out of the street to the curb of the road.
Why'd you do that?
So it would be intact. I didn't want anybody, another vehicle to come and crack it up. So I moved it to the corner.
Could you repeat the last part where you said, I think you said crack it?
I did not want a vehicle to come and run over their head and deform it. Because I saw it belonged to somebody.
What did you use to move it?
I broke off a stick. And I took the stick and I was trying to push it over to the curb.
Did you see anything else unusual on Avon Avenue on that day? I mean, was there any other things that you can recall?
Well, I didn't know some birds, some birds flying up in the air, looked like buzzards.
Okay.
And I recognized that might have been the reason why they were there. But I told the officer after I called them that I thought there could be something else out there in the woods because the buzzards were still there.
Okay.
Yeah.
Now, after you found the skull, what did you do next?
I went home, I got my daughter, because she was in criminal justice.
Okay.
And I want her to see the head.
Okay.
Yeah.
And did your daughter come with you?
She did.
And what did you do next?
Call the police.
Okay.
Call 911.
And after you called 911, how long did it take? Do you remember how long it took the police to get there?
That recognition said right now. It wasn't long. But right now I cannot recall how long it was.
Okay.
But they
you think
did.
It was long?
No, I didn't think it was long. But
How
they,
many police? Do you remember how many police showed up?
no.
Was it just one or more than one?
I don't know. I know there were one. I do know there were one. There could have been more than one, okay?
Because you talked to the one?
Yeah, I talked to the one, yeah.
Okay. And did you go anywhere after you initially told the police out on the scene? Did you go anywhere with the police?
I do know I had to go downtown.
Okay.
But I can't recall whether it was the same day or not, or whether it was a few days later. But I do know I went down to the Atlanta Police Department.
Okay.
I think it was down there, Georgia State College, Ponce Leon, someone down in there.
You went to the headquarters?
I went to the headquarters, I think it was.
And
You-
I
you-
assume you told them what you saw?
I told them the same thing I'm telling you now. Yeah.
And do you remember if you gave any statement or had to sign a statement or anything, just saying what you did?
I'm pretty sure I had to, sir. I'm pretty sure I had to.
I'm going to show you a piece of paper. Do you recognize that?
Mm-hmm.
Is that your signature?
It's my signature.
Yeah, could you read it real quickly? Is that the statement that you gave?
Sir, I'm going to be honest with you in the court. When I gave this report, I was walking, I was younger, I could see better,
Well, can you read it now?
and right now I cannot make this out.
Okay.
They too damn around. I don't have my glasses with me.
Are they around?
I don't know, but baby have a glasses like that.
Mr. Wilson, just to clarify, are you asking the witness to read it to himself, or are you asking him to read it out loud?
Read it to himself to see
Thank
if it
you.
refreshes any recollection.
Okay. Look at the mirror. Thank you.
Do you need some assistance, sir? Apparently not.
What you want me to do with this?
Does that help you?
Yes, you may read it to myself. I have.
Yeah, read it to yourself real quick.
Okay.
Okay. They are muting it when they're reading something? Or maybe because they heard him reading out loud? That must have been the witness whispering. Oh. Oh, he's so sweet. They got this man in here.
The true, all but a few, maybe a few sentences.
Do you know?
I was driving. I wasn't driving. I was walking at the time.
I apologize. I think you
Say that
said,
again?
yeah.
I wasn't driving. I was walking at the time.
Okay. Did you,
Yeah.
does that help refresh your recollection
Yeah,
at all?
sure, it does.
Do you remember finding anything else other than a human head?
I don't.
Now, how long have you lived? You've lived in Atlanta your whole life?
No,
Where else did you live?
no.
Or how long have you lived in Atlanta?
Ever since 1960.
Ever since 1960?
Yes.
And Avon Avenue, is that located in Fulton County?
It is.
May I just have one moment, Your Honor?
Sure.
Are they going to pass on the witness?
Thank you. Mr. McDermott, questions for this witness?
Just a couple, Your Honor.
Sure.
Good afternoon.
Hello, sir. How are you?
Just a couple questions.
Okay.
You said you informed the officer on the scene that there were buzzards certainly overhead. Is that correct?
I did.
And did they go over and check anything else, to your knowledge?
I don't know. They told me they were going to, but I think what happened a few days later, somebody came by my house and told me that they had found another body part, and they were going to try to match the head with that body part. However, as far as I can remember, sir, it wasn't in Atlanta they had found that body part. I think he told me to find somewhere near Griffin, Macon, or somewhere down in the area. Somebody he told me they had found a body part. And they were trying to mess it up. And that's the last I heard of that.
Is this a walk that you took every day or frequently?
No, this was a walk that I decided I wanted to walk that morning to the bank.
Did you ever normally travel up and down Avon Avenue?
Sometimes.
Did you ever notice any dogs?
Brother, there are homes in that area. I'm sure there's dogs in that area
Or did you
also.
ever see any when you were traveling up and down Avon Avenue?
Yeah,
Do you remember? All right, thank you.
No.
That's all the question I have.
Thank you. Mr. Wilson?
No redirect, Your Honor.
Okay. Mr. McEachern, you are excused as a witness. Thank you very much, sir.
Thank you, ma'am.
All right. Let's, I don't think the volume will be all that different since they did give him a mic. But I'll lower it a little bit until we hear the next witness in case the court feed or media pool plays with the volume and blares our ears out.
Okay.
Your Honor, we would call Dale Kelly.
Okay.
Dan Kelly.
If you could move that mic back,
Yes, ma'am.
and then we're all going to try not to touch it again. Thank you.
They must be picking up a lot from the tables or something because the camera pool keeps muting. Bring out Woody.
Before you have a seat, if you'll turn and face the deputy and raise your right hand.
Do you swear or affirm the testimony you're about to give for today shall be true, the whole truth, and nothing but the truth?
Yes, sir.
You may lower your right hand and be seated. Say and spell your name for the court, please.
Careful. That chair is on wheels and there's a ledge next to you, so
Yes,
make
sir.
sure and stay closer to me than the edge, okay? Thank you, sir.
D-A-L-E, Kelly, K-E-L-L-E-Y.
And
Dale.
what do you do for a living, sir?
Retired,
What did you do before you were
law
retired?
enforcement for 42 years.
And let's go through your law enforcement career. Where did you first become a law enforcement officer?
In 1979 in the city of Atlanta.
And when you were hired, did you have to get it? Well, tell us about your hiring at the city of Atlanta.
July 2nd, 1979 was the first day I started the Atlanta Police Academy. We were there for 12 weeks, and then after you got out of that, you rode with a senior officer for 12 more weeks in field training. I became a patrol officer. I was assigned to Zone 1, which is northwest Atlanta at that time. 83, I was promoted to detective. I did vice for about 6 months. That was during Eldon Bell. He thought all new detectives needed to go undercover and then come out and get in a regular division. I went to sex crimes. I worked in sex crimes, total of 13 years, but whenever they had a sexually related homicide, I would get pulled over and help the homicide detectives work a sexually related homicide. And then in 1996, I was permanently assigned to homicide.
In were you post-certified?
Yes.
Are you still post-certified?
No, I do not keep my mandated.
Okay. And when did you leave the city of Atlanta?
I retired in 2000 from the city of Atlanta, went to the Douglas County Sheriff's Office, worked there, started in the jail, worked patrol. I went to CID. From CID, I made sergeant. I was a night shift sergeant for a patrol shift. And then I went to the fugitive unit, the warrant unit in plain clothes. And then from there, I made lieutenant and was over the transport and civil division.
Now, did you receive any specialized training in investigations?
Yes, I mean, I've been as far as California on missing persons, violent crime network training. I've been to Valencia College 3 or 4 times on advanced sex crimes, advanced homicide, crimes, and like that.
Now, during 1999 and around April, could you describe what you were in the homicide division at that time?
Yes, sir.
Tell the jury what happens when you get how does that work? Or how do you get assigned cases or what?
Well, okay. You were on a rotation system where you were up on call, and if anybody called for a homicide unit, you would answer and go wherever they asked you to go. You didn't go by yourself. Half the time the whole unit would go. You were just the lead, and they would do other jobs needed at the scene.
And when you say lead, what does that mean to you?
You were up on call, and the case was going to get assigned to you.
And when you're lead, what kind of things do you focus on?
Well, you get to the scene, you try to focus on directing the identification people to do fingerprints some places, sometimes you don't, take pictures and stuff like that. You may ask like the officer, the first responding officer, if there's a witness at the scene or something, you get the officer to take himself and the witness to the homicide office where they could give statements.
And let me draw your attention specifically to April 29th, 1999. I assume you were on call that day.
Yes.
And did you receive a call regarding a unexplained, well, I mean, what kind of call did you receive that day?
The way it works is Zone 3 Unit 2304, which meant he was a day shift unit working 304's beat, came over detective radio and called for a homicide unit. Each zone, and Atlanta still has 6 zones, they all have their own radio frequency. Detective division had their own frequency, and they would just switch their radio over to the detective frequency and call for a homicide unit.
So it was your turn?
It was my turn.
And where were you told you needed to report to?
He told me to come to the intersection of Avon and Hartford Way Southwest in Atlanta.
And what did you do?
I got in the car with the lieutenant, and investigator Tina Miller also rode with the lieutenant, Tony Biello, and we rode to that location.
And why did Investigator Miller accompany you?
Again, on a homicide, you need as many people as you can out there. We didn't know what we had other than a unit calling for us, and we could always use help.
Okay, so she went along?
Yeah.
Okay. And when you got to that location, what did you observe?
When I rode up, there was a decomposing head in the road standing upright. There's an old black plastic bag to the side, and there's an old mangy, like a stray dog with matted hair and all, kind of nasty, running around out there.
Okay. And do you recall where that skull was located?
It was on the side of the roadway, it was actually on the Avon side, because we used the address of 858 Avon Avenue.
Now, when you're investigating a crime scene, is it important to document information?
It is, yes.
And you document through reports and also pictures?
Well, I didn't take the pictures. I called for our ID section to come take the pictures, and it's up to them to document their pictures.
Okay. No, what I mean is that it's important to take pictures of
Yeah.
crime scenes,
Yeah.
right?
Yeah.
Okay. May I approach a witness, Your Honor?
Yes.
going to show you what's been marked as State's Exhibit 3 through State's Exhibit 20. Would you please look at those and tell the jury what those are?
They're pictures of the general area of where it was located, and ID had saw certain objects, they put the little plackets up at, and it's,
Could you look through those, please?
yeah.
Thank you.
Whisper, whisper.
Are those true and accurate pictures of what you observed that day?
Yes.
Your Honor, at this time I'd ask to admit States 3 through Exhibit 20, which are photos of the scene.
No objection.
Okay, Mr. Samuel, thank you. Exhibits 3 through 20 are admitted.
And I would ask to publish some of the pictures to the jury as we go through the testimony as far as
Okay.
a warning.
Thank you. That's what I was waiting for you to ask.
Yes.
So ladies and gentlemen, as we discussed during the process of jury selection, I told you that I would warn you when we were going to show you photographs that are maybe graphic in nature. So I'm giving you a heads up that some of these photographs may be graphic in nature. Thank you. State may proceed.
Thank you, Your Honor.
The Zoom doorbells.
Okay. Show you what's been marked as, or what's been admitted as State's Exhibit number 3. Could you kind of describe that picture in detail for the jury as best you can?
It's an overall shot of the area where the head was found.
Can you speak up a little bit?
Sir, I'm sorry.
If
It's
you
a
could pull that microphone towards you, I think that'll be easier as well.
It's an overall shot of the area where the head was found, and the head's actually in the photo to the left here, or my left sitting looking at it, and you see where the patrol cars had blocked off the street.
But I do see some yellow things with numbers
Yeah.
on them. What are those?
Plackets, ID team uses, they see stuff, or maybe an investigator will point out to put a placket, take a picture so that it can be described later in their reports.
Okay.
I don't know what I'm doing, Bittersweets. It is 2 back-to-back dismemberment trials. Accidentally. Yeah, those bells are someone trying to join the Zoom application for court.
And what other items were there other than the placards?
Whether
I'm sorry. What other items were there than the skull that you described earlier?
there was a black plastic bag. It appeared to have decomposition in it, hair, and fluids.
And was that significant to you as a investigator?
Yeah, later, when the cadaver dogs were called out, other body parts were found in the black plastic bag, and also had fluid in it that ended up being bleach.
Okay. So when you saw those pieces of evidence, I assume that was kind of the first thing that was kind of done at the scene?
Yes, I cannot legally touch any body out there. It's all up to the medical examiner. I can look at it, I can have photographs taken of it, I can note it, but that's entirely up to the medical examiner's office to do any collection of body or body parts.
Were they contacted? Did you guys contact them, or?
Yeah, they came out to the scene.
Okay, do you recall who came out to the scene?
Mary Beth Happel and Dr. John Parker.
Okay.
Mary Beth is an investigator for Fulton County Medical Examiner, and Dr. Parker was a medical examiner.
Okay. And what did you do? What did you do next?
Well, we started. Hard to run an investigation if you don't know who your victim is, and this one's even doubly hard. We didn't know what sex the person was.
Why is that?
The decomposition of the facial and the torso, we never found it. So you couldn't ever determine a sex at that time. The feeling is the torso contains the guts of thing, and it would smell more, and the animals out there would have eaten it quicker.
Okay. Do you recall what the conditions were like that morning?
Yeah, I noted it.
Would you have noted that in your report?
Yeah. As I rode over with Lieutenant Biello and Investigator Miller, the weather conditions to be overcast with a intermittent mist, and the temperature was in the low 60s with a brisk breeze.
He's like, yeah, I got my
So
report.
after you got there and after the medical examiner got there, what did you do next?
Nothing could do much other than make a report.
Did you talk to any? Do you remember speaking to any witnesses?
Well, there's a gentleman who had found the head. Gentleman's just in a wheelchair, but he wasn't in a wheelchair at that time. I talked with him. I sent him to the homicide office to give a statement, and the officer on the scene took him there for a statement.
Do you recall any other actions that you did out there at the scene that day?
That day, no.
So at this point, all you had was a skull and some plastic bags, pretty much.
Yeah.
Did you find anything else? And on a different day?
On a different day, yes.
Were you called back out to the scene?
Yes, went back out there with the medical examiner's office. They had gotten in some cadaver dogs from Cobb County. These people who owned the dogs were not associated with law enforcement in any way. They were just citizens who trained their dogs to become cadaver dogs and would help agencies as they needed it. And they came back out there, and that's when we started finding hands, feet, and other body parts. They were also in a black plastic bag like I described earlier, and they were always double wrapped. There was always 2 bags per body part. That trying to make sense with me there.
And I don't know, I don't know if you said, do you recall what date you went out to the scene?
The first, it was April 29th, and then this was June 3rd.
So that's approximately, what, a
month and a half later.
Month and a half later?
To get it set up.
Now, is the Is the president, you mentioned bleach earlier, is that? I'm sorry, you mentioned bleach earlier.
Yes.
Is that significant to collection of DNA?
Not for the collection, for the destroying of DNA.
Your Honor, we have not been given an expert notice with regard to this witness.
Your response?
Well, Your Honor, I think that's not, I think it's something that a police officer can, based on police officers' evidence collection, could probably could testify to as within their knowledge.
Okay. If you want to lay that foundation, I likely will allow it. Overruled for now, Mr. Samuel. Go ahead.
Okay. Did you learn about bleach?
Well, DNA, it's not the same as today. This was in the beginning stages of DNA. And
Well, the DNA
a lot
itself
of
didn't
things
change.
would interfere with DNA. When I worked sex crimes, if there's anal sodomy, the feces would ruin the DNA and you couldn't test it. Learned that bleach and
Where did you
gas,
learn
training
that?
classes I took
Okay.
that would hurt DNA. Nowadays, they probably can do it even if there's bleach on
Well,
it.
what did you learn about bleach at that time of your training?
That it would interfere with the ability to do DNA evidence with what they had to test with at that time.
Your Honor, at this time, I believe I laid the foundation based on his
Samuel?
training.
And we still never got notice of him being an expert. So if he's giving expert testimony about DNA, you're entitled to be given notice of that.
Okay. I understand your objection, but it's going to be overruled, and to the limited extent you've been asked the question, I'm going to let him answer it. Go ahead.
Thank you. I think he's already answered it.
I think he has.
Okay. What did you do, after you went out and on the, in June, what did you do next on this case?
There's nothing I could do until, again, you can't start much of an investigation until you know who the person, what sex the person is, who the person is. You have nowhere to start. So Investigator Miller, who worked adult missing persons, is assigned to homicide. She would attempt to identify the body. Medical examiner's office was trying to identify. They could hook up with other medical examiner's offices and do the thing, and hook up and see if they had any information. I retired in 2000.
Okay, well, and that was, you never got an answer by the time you retired?
No.
Okay. May I just have a moment, Your Honor?
Sure.
Nothing further, Your Honor.
Thank you. Mr. Samuel?
Ross. Talk about the bleach.
Detective Kelly, my name is. It won't happen a second time.
That's okay.
It won't happen a third time. Detective Kelly, I don't believe we've met before, even though we've been around a long time together. So a couple questions. First of all, you said something about a dog on the scene. Do you have any reason to believe that that dog had ever moved the skull at all?
I believe so. I believe the dog drug it out of the woods. And
Or you're just speculating about that?
there was a video, VHS recording.
Can you stick with the microphone?
There was a VHS recording at one time that showed the dog dragging
One time?
the bag out of the woods. Now, I don't know where it's
Dragging
at
the
now.
bag with the skull out of the woods?
Yes.
There was no detectives out there until after the skull was already there.
VHS recording. That's a security camera. It's
Where'd
so
the
old.
bag go?
Where is the evidence of that?
I'm sorry.
Has anybody ever had evidence of that? Is that in any police report anywhere?
I don't know.
Are you just kind of making it up today?
No.
I've read every report you've ever written, every report every other detective has
You haven't
written.
written all written. There are reports missing. I don't know why, but there are some reports missing. in
Have you
this
told the
file.
DAs there are reports missing?
Yeah. But I mean.
Which DA did you tell that there are reports missing?
The point. Let the record reflect.
Here just questioned me
Uh-huh.
that I had more reports in this file and they're not.
And
nowhere
where's
to
the,
be
where's
found.
the VHS?
I don't know.
Did you tell them there was a VHS recording that's missing? You told
Yes,
Mr. Wilson that? When did you tell him that?
the other day when he called me.
You told him the other day?
Sir?
You told him the other day?
Yes.
Is there a
Called
reason?
me
you-
last week. Yeah,
And what else did the recording show?
just that.
Did it show how the skull got there at all?
Just what I described.
A dog pulling it out of the woods. Where
The
from?
bag.
From what part of the woods?
Where's the bag?
Well, it's not in your report. You know that.
I'm telling you, I have reports missing out of this file. This is not my whole file.
Take your time.
It's from the wooded area where when we returned with the cadaver dogs, it was coming from that area where the other bodily parts were found in the woods.
What did the dog look like?
Like it was a stray dog, the hair was all matted and nasty looking.
Was there any dog hair found on the skull?
I don't know.
Was there any testing done of the skull to show that a dog had moved it?
I don't know how you do that because it was remember the black plastic bag? It was ripped open. The dog was toting the bag and it fell out.
And you saw a video of that?
Yes.
What did you do with
Ew.
the video?
It was put in evidence.
Oh my god.
You know, I think we need to take a break and talk to the district
Yes.
attorney's office for a moment here.
Okay. Ladies and gentlemen, I'm going to ask you to step out for just a few minutes. It's 2:21. I'll try and get you back in here as quick as we can. Thank you all.
All rise for the jury.
Oh my god, you guys, I am flabbergasted. I'm like not shocked because it's Fulton County, but this is the second witness. This is the second witness. We get this retired APD officer on the stand. He goes, yes, in my report, I notated the weather. It was a cool, brisk breeze, and he's super, like, detailed in it.
Moment, please.
And then,
Yes, sir. Thank you. Don't wander far, okay?
oh yeah, they're dismissing the witness. Then either he isn't actually telling the DA's office about this missing VHS and or the details in it, or maybe he did and the DA isn't turning it over. So either way, the state has messed
Mr.
up
Samuel,
here.
that witness has now
Second
left the
witness
room.
Well, I have a couple questions. I'd like to know, first of all, whether Mr. Wilson will either corroborate or dispute that he's been given information about video camera evidence that's lost, his reports that are lost, evidence that they knew that the dog had dragged the skull out of the woods into the road. There's no police report about it, and now it turns out his actual statements are missing, all of which apparently he told the DA's office, none of which even comes close to ever having been revealed to us, ever.
Mr. Wilson?
If I could respond to this, Judge, because I was talking directly with this witness on this issue. If the court
Okay.
will allow that.
Sure.
All right. I do have information about the comment about the dog from this witness. We were not able to locate the video. I didn't know there was a video of that description until I had that discussion with this witness. The detectives, Shepard, suspected that there was a dog or dogs in the area that may have carried the head out from the wooded area to the street where it was located. That's been his theory since the beginning of the case.
Right, but inferring that from the presence of a dog that Mr. McEachern testified to is different than we recovered some sort of surveillance video that showed it, but then we lost it.
Sure, and that was never intended to be introduced into evidence by the state. That's why it wasn't elicited during direct.
That doesn't help.
Video cassette. We had several small mini cassettes. At the beginning, before the case was indicted, those were submitted to a company in DeKalb, and they were transferred over to a thumb drive, which was submitted in discovery. And they're labeled as such, converted VHS. It's in discovery. But that's the only VHS cassette that I received from APD Annex. The multiple times we've done it, I don't have a VHS cassette.
Okay, hang on. The physical nature of the physical medium in which the state might have it or not have it, I think is less important at this point than does the state have some sort of video that would line up with what this witness is saying he observed, like some digital video recording of that image?
I don't.
Okay, and so the videos that you're saying you were aware of that were reduced by a private company to a flash drive or something and were produced in discovery, what are those?
Those are all statements, witness interviews,
Okay.
which have been turned over.
Okay.
That's the only VHS cassette that I've seen in this case. A lot of mini cassettes that have also been converted. I only had one VHS cassette.
Okay, I appreciate that. Again, I think it would be easy to identify it if it was a VHS, in your possession. But I think more importantly is, does anybody know that such a video ever existed, whether on VHS or anything else?
I didn't have a documentation of that in the Detective Calhoun's report. I didn't have documentation of that in Detective Shepard's report. And I didn't see any reports that Detective Kelly had written that elicited that information. And of course, all the reports that I have from Detective Kelly appeared to be complete.
Okay.
I had no reason to believe they weren't. But, so like I said, I never intended that this information would come in because I didn't have a way to authenticate it. Other than that detective testimony, I knew that would have been permissible to elicit it via just him testifying to it.
Okay.
I never intended for that to come out.
Mr. Samuel? I think the answer to your first question is, well, actually, to be honest, now that I'm trying to put it in words, I'm not actually sure I'm clear on what the answer is. And that was why I was trying to make the distinction between the VHS and the video.
Yeah. Let me explain to you how I see the problem. We have been working on this case, Mr. McDermott in particular, 24 hours a day, 7 days a week for Lord knows how many months at this point. He's been in communication with the DA's office. There's been a lot of open file. And yet apparently they're not telling us about evidence that's lost, about videos that are lost, about their second witness on the stand who's saying he was the chief investigator in the case and some percentage of his reports are lost. Now, either the DA's office says they were oblivious to all of that and they learned that the same time I did, or they've known it all along and didn't tell anybody. Meaning you, us, the destruction of evidence, the loss of evidence that may be important, the loss of police reports from witnesses, from a chief investigator from the original crime scene. He says his reports are missing, and nobody's telling us that the witness is just going to, blurt that out on cross-examination for the first time. And, this business about bleach is not in his report. There's references to bleach in the report, but according to the crime lab that we interviewed, it had nothing to do with bleach in the bags. It was bleach that was done by the crime lab to clean the bones.
And that's a matter for cross-examination?
Well, but he's saying, he's saying I've got bleach in the bags. There's no report anywhere that says that.
And again, that's a matter for cross-examination unless there is some report that has not been provided to you. But I'm going to ask you to put a pin in that for a moment and revisit this with Mr. Fawcett or Mr. Wilson. I'm still not sure I understand the answer to the question, which is, before Detective Kelly took the stand, did the state have an understanding that he believed there were other reports that he had made that were missing, number one, and number two, that he believed there was a video showing what he's described about a dog with a bag in its mouth pulling it into the street, which was containing some body part or other? Two questions. What are the answers to those two questions?
Yes, I was provided that information last week when I spoke with him.
Okay. And what efforts did you take to determine if such evidence did in fact ever exist and or was lost or in your possession?
Well, I went back through the file to see if there were additional reports by Detective Kelly. So the reports from Detective Kelly, I sent him portions from the file that we turned over. I went through our additional discovery. I saw additional reports that were turned over. Similar reports to the first one. They were 1 or 2 pages, so not what he's discussing. But I wasn't able to locate any additional reports by Detective Kelly, and that's been through the several times that I've gone through the discovery.
Okay. And okay, so you were aware that Detective Kelly believed that there were other reports that were not in your file?
That was last week, yes.
Okay, but I understand you only became aware of it last week, but you did become aware of it at some point.
That's correct.
And what about the second question, which is, were you aware that Detective Kelly believed there was some sort of surveillance video that had been recorded at the time that reflected what he's described?
Yeah, that's the same conversation.
Okay.
Yes.
And did you disclose, and I'm not implying here that you were obligated to, we can have that conversation in a moment. My question though is, did you disclose to the defense at any time that Detective Kelly believed that there were reports that were missing or that he believed there was a surveillance video that was missing?
I did not have that discussion. No.
Okay. Mr. Samuel, I think I've gotten the answer to those questions. Go ahead.
Well, I have the same. The first question says, why would you not disclose that to the defense? That we're going to put a witness on the stand who, in essence, is going to ambush you on cross-examination because you think, defense counsel, you have all of his reports. We know you don't. So if you cross-examine him, you're going to find out that he's going to say, oh, that's absolutely true. I have got additional reports. They just were never given to you.
What obligation does he have to disclose to you?
The prosecution has an obligation to report missing evidence, right? A VHS camera. He can't just say, it's missing, so I'm just not going to bother asking questions about it on direct examination and let the defense attorneys walk into a trap where the witness can say, oh yeah, what other videotapes are missing? Do they have a videotape of the crime being committed they haven't told us about that was lost? I mean, this is somewhat not the most important thing in the case, whether the skull was dragged out of the woods or wherever it came from. I'm just very concerned if by witness number 2, we're discovering that the prosecution knows there's missing evidence, missing surveillance cameras, missing police reports. They know that that's true, and they're not even telling us about it. It's bad enough that they're missing, which is understandable after 20 years to some extent. It's not understandable why they wouldn't tell us.
So the question then, Mr. Samuel, is what relief would you have the court give you in light of the fact that it wasn't disclosed to you? Is that not something that you can remedy on cross-examination and with this witness and argument?
I have no idea what he's going to say because I have no idea what this witness is going to say that hasn't been disclosed to us. The whole point of discovery in a criminal case is you give us your witness statements. Now it turns out he knows a lot more about this case.
I understand
Did they know?
But
the prosecution knows.
My question was, what remedy would you have me fashion to address this issue if I agree with you that this is a problem? Is it go talk to the detective and figure out what he's going to say before you have to cross-examine him in front of the jury?
I was actually going to suggest that you tell the jury, disregard the witness's statement as of now. At some point later in the trial, if they want to bring him back after disclosing to us the statements he gave to them that's missing from what they gave to us, if there's something more than the VHS, something more about the bleach, something more about whatever I haven't, stumbled upon yet. When a witness talks to them, that's a witness statement also that hasn't been turned over to us. Not just the witness statement that's lost, but what they told him, what he told them last week is a witness statement that hasn't been disclosed to us. You can't interview a witness, find out relatively important information and say, I'm not going to put it in writing, so the defense attorney's never going to learn about it.
Understand. Thank you, Mr.
I would ask that the witness you tell the jury not to pay attention to what the witness has testified to, and we'll bring them back later in the trial if appropriate,
Thank you, Mr. Samuel.
after the prosecution does what it's supposed to do.
Response from the state?
Mr. Fawcett?
Yes, I think I could understand, still wouldn't agree with it, but I could certainly understand Mr. Samuel's position if we were going to take his, I guess where he's going with it, there's some nefarious intents and bad faith on the part of the prosecution to do that. I will say I am not immune to oversight or overlooking items, but hindsight I would have. But I will say this: I had no intention on not turning that information over. I didn't think it was of any consequence. I thought at the minimum it would benefit the state. But finding that information out on the Friday or the Thursday before the trial, I did think that was somewhat of an ambush. And again, also at the same time, I would say this. I believe the defense has contacted just about every witness that we've had on the witness list since the beginning of this trial. Detective Kelly's name has been in the discovery since the discovery was turned over. There are 3 total detectives, and I know for a fact they've subpoenaed detectives from the patent investigation. And so if they had called the Detective Kelly, he would have been willing to speak with them. But to infer that there's some nefarious intent in the process of just simply preparing for trial and interviewing witnesses, I think it's a bit much. At a minimum, at a maximum, I can understand the court we're going to instruct the jury to disregard the last statement, but to instruct the jury to disregard the entirety of his visual observations and testimony about that when he arrived at the scene.
Tell the jury to disregard the witness pointing at us and throwing us under the bus, saying that either we're liars or we're sneaky and didn't turn over something we were supposed to.
I don't believe there's any
Look at this guy.
reason for the court to decide in that manner.
Okay. I have a couple of questions. Let me try that again. Has the defense spoken or attempted to speak to Detective Kelly prior to today?
We have not, Your Honor, and I'm looking for the state's witness list that was sent to us currently because I don't think we were ever given any contact information for him, and he's retired, so usually not kept by the police department.
Interesting. Whisper, whisper, whisper.
That the state provided does list Detective Kelly as Detective Dale Kelly, APD.
Okay.
So.
Ooh.
That doesn't actually answer my question. Is your answer that you haven't attempted to contact Detective Kelly because you weren't provided contact information and you weren't able to otherwise locate him because he's retired?
That wouldn't be 100% honest, no.
Okay.
If I could say, I'm not sure the blame should be on us.
I'm not implying that I'm blaming you. I'm asking what information did the defense have that they could have exercised in terms, right? I'm just trying to understand the scope of this. It'd be one thing, for example, if y'all had tried to contact the detective and he'd refused to speak with you. That's what I'm trying to figure out. So
I understand that's your question. I'm not quite sure the consequence of it. If we trust the prosecution, that when they give us the reports, we have the reports. If we have to go and consult all 18 of the witnesses on the list now, all 30 of the witnesses last week, and all 150 in the original list, and say what is missing from your police reports, this case wouldn't have been ready to be tried this year.
okay.
But
Thank you, Mr. Samuel. So I still think that the answer to the way to resolve this in the most expeditious manner is for y'all to go into that conference room with Detective Kelly and find out what he's going to say is missing from his report. Because whether or not Mr. Fawcett should have told you is a different matter than whether or not this detective can testify truthfully about what he believes happened in response to questions. Mr. Fawcett is correct that they didn't solicit that testimony. And to the extent that you believe you've not been given complete information, Mr. Fawcett has made representations about what additional information he believes there is. And you can ask Mr. Detective Kelly those questions while we wait and bring the jury back in. I don't think, I mean, it's 2:40. I feel like an initial conversation with that detective to find out what else he's going to say and how many reports he thinks are missing. That's a fair conversation for y'all to have before I decide what to do about his testimony, or to simply have him retake the stand and let's continue his cross-examination with you having the benefit of the additional information that he believes is missing. Mr. Fawcett, is that, or Mr. Wilson? I think he's technically your witness, but.
Yes. And so the court's going to go in, would the court allow a recess for them to speak with the witness?
Yes, that's exactly what I'm proposing.
I think that's the way to do it.
Okay. So, Mr. Wilson, if you will go and gather Detective Kelly, and y'all can either discuss it in the lobby or you can go into that conference room in the atrium there, or you can go in that conference room and discuss with him what items he believes are missing or that sort of thing. Thank you. We are in recess until 3 o'clock, or if y'all come back sooner than that or later, tell me.
Oh my gosh. Yeah, he was just sitting there like, his hand was like mushed like this on the side of his temple for a few minutes there. So I don't know if he was really listening all that intently. Guys, this is seriously the second witness. The first witness was just like, I'm the one who stumbled upon this head in the road and I poked it with a stick. Then we get this retired APD officer who is telling us about, showing up because there's a report of this head in the middle of the road. He's very detailed on one hand, and then suddenly he has no details about seeing a VHS with a dog carrying a plastic bag out of the woods and sprawling the head out in the middle of the road, ripping the bag open, but says he points right at the defense table as if he handed it over personally to one of the individuals, maybe Vincent Fawcett, sitting there. This is the second witness. And I think there's a problem here. So one of the things that the defense seems like they're getting at is like, look, he could just drop more bombshells up there. This is not the same as a layperson witness that just blurts something out that nobody knew about. This is an officer that was part of the investigation. So their work, everything that they're doing is part of their investigation. Anything that might be inculpatory or exculpatory should have been provided and turned over to the defense. And if they didn't have this before trial started, sure, you can still cross-examine this witness, but I don't know. There's also the issue of your strategy could have been different if you knew all of this information before trial started. And for what it's worth, I don't think that this witness, I don't think where we're at hurts the defense. I don't think this revelation hurts the defense. I think this revelation is very bad for the state, because one of the first things that the jury is seeing is either you have this person who, while he was working, he's retired today, sure, but while he was working, he was very selective in what he wanted to notate, and is just volunteering things now that might sound good, or the prosecution isn't doing their job right. But still, oh my God, why is Fulton County like this? And again, it's not just limited to Fulton County, but we went over to Liberty County for the Kassotis trial. We had a couple of objections, but we didn't really let the jury out. We got to fight real quick. We just didn't have that in that trial. We're here for like 2 witnesses and we're back at it. Yeah, where's the McDonald's videos? Oh my goodness. And the chat, for like 2 seconds, the chat was like, wow, this guy took a report. There's a report with details. How nice. Ripped the rug out right from under us. Oh my gosh. I just don't even know. I also want to say for Always Forever for Life, relayed she got to check out a TikTok live with Doug, and mentioned, we kind of could tell from the body language and the verbiage, but he did not want his client to take the stand. So that was interesting. He's also going to be guesting on With Justice Served TV today at 6 p.m. Eastern. I think their link is in the description. So just keep that in mind. Also, we have Tay-Biz at 6:45. We got the whole lineup today. We watched the Kassotis trial because it's like, cool, let's see Doug in another trial. I had no idea it would go so crazy. Let's watch this trial because it's Symone Hylton. No idea we'd be here already. I just don't know how this always plays out this way. GV, and thank you, GV says, is it bad that this feels like coming home from a vacation to a normal county? Like, we left Fulton County for one case, we came back, and here we are. And we did the Lawrence Doherty trial, and even though there was like some theatrics, really with the defense attorney, and at times the prosecution went on and on and on when they could have just kept something to 10-15 minutes. There wasn't any, like, fighting, mistrial motions, weird stuff going on. We get back to Fulton County, we're home, guys. This is where the chat gathers. Yeah, can we go? Let's go look at the way he pointed. Hold on, let's pause it so I don't... He was still on the stand. That was funny. Oh, right here, right here. Let's just watch the pressing all over again.
From what part of the woods? Well, it's not in your report, you know that.
I'm telling you, I have reports missing out of this file. This is not my whole file.
Take your time.
Is from the wooded area where when we returned with the cadaver dogs, it was coming from that area where the other bodily parts were found in the woods.
What did the dog look like?
Like it was a stray dog. The hair was all matted and nasty looking.
Was there any dog hair found on the skull?
I don't know.
Was there any testing done of the skull to show that a dog had moved it?
I don't know how you do that because remember the black plastic bag? It was ripped open. The dog was toting the bag and it fell out.
And you saw a video of that?
Yes.
What did you do with the video?
It was put in evidence.
I think we need to take a break and talk to the district attorney's office for a moment here.
Okay. Ladies and gentlemen, I'm going to ask you to step out for just a few minutes. It's 2:21. I'll try and get you back in here as quick as we can. Thank you all.
All rise for the jury.
A golden moment. All right, so we'll get caught back up in real time. The defense attorney is Donald Samuel, is the one who made the one without the ponytail that was making the arguments about this issue. And Aaron said it earlier. Something McDermott. I forget the first name. Is the defense attorney with the ponytail. Vincent Fawcett is the lead prosecutor. Mr. Wilson is the other male prosecutor, and then Symone Hylton is sitting in the middle. You guys know her from the YSL trial. Yeah, so Brittany, did you just get here? Yeah, so here we are. We're back in Fulton County. Missing reports, maybe missing VHS. Maybe the VHS didn't exist at all, and this officer's just making something up. Because it is weird that he took very detailed notes about the weather conditions, but didn't put anything in his reports about this VHS and seeing the dog come out of the woods with a plastic bag. Okay, Joel McDermott. I'm just going to leave this up here for like 5 minutes on the screen so everyone can learn it. Oh my goodness. Is it us? Like, is it like chat? We get together, we think we're just gonna watch something normal, and it just, the universe won't ever give us a normal trial to sit through and watch. And we'll say D would to not out you. But yeah, forgot this is 1998. Factual lie was hilarious earlier. Spelling out the abbreviation to make sure everybody in the chat knew what a VHS was. Like, don't make me feel old. I'm so sorry, guys. Yeah, Jim is reading the report. Yes, this is a 1998 cold case. Oh my goodness. Have they taped over it? Did it erase itself? Oh, there's is it Instagram now where you can put like pictures in comments? That would be a pretty cool feature. And I think, can you do it in Twitch or Kick or one of those other like sort of YouTube competitors? Yeah, this is Fulton, this is normal. Kim, I mean, I don't think a mistrial would be granted here, but again, no matter how we proceed, the jury just saw a police officer, granted he's not in uniform, point at the prosecution table and say, I gave evidence to you guys that we don't have. Okay, so TikTok allows it too, so Instagram and TikTok. Hey, Rona. Welcome aboard. We are in our usual form today, watching a Fulton County trial with missing reports and possibly kicking a witness off the stand. The usual for Fulton County trials. I agree. Yeah, DTN says Georgia District Attorney operates on the grace of the judges. Jordy shows up. If you say McDonald's tape 3 times, Jordy will appear. But the footage won't. Just the whole time. We got somebody, I don't know if they're coming back into the courtroom or if someone's just randomly walking in front of the camera. Oh. Well, almost Brooklyn. Not really a motion for mistrial, but this witness could get Tyrone Denist. How do you past tense Dennis? All right, here we go.
Okay.
Madam Courtwoman, are you ready?
Yes. Okay. So we took a break at 3:40 so that y'all, I'm sorry, 2:40, thank you, so that y'all could go and talk with Detective Kelly. And then after that, let me know what everybody thought in terms of what we need to do. Mr. Samuel, have you had an opportunity to talk to Detective Kelly?
I have, and he answered a couple of questions that were very helpful, and he explained what police reports he thought were missing and described them. He doesn't have anything more to say about the VHS. We're probably going to steer clear of that. We still think that ought to be excluded, that you should tell the jury to disregard that testimony because it's missing evidence. But I'm prepared to go forward. The missing reports deal with the June discovery of evidence, and he explained to me what was in his report, so I'm not walking into any dangerous territory there. And there's an issue about bleach, which is concerning, but we talked about that, and I think we both understand now the bleach issue, which you'll hear when we testify.
On cross. Okay.
A little bit of hearsay on both sides with the bleach, but I think we're in agreement that that's what we're going to do.
Okay, thank you. Mr. Fawcett, it sounds as if we've resolved this issue for purposes of having Detective Kelly come and retake the stand. It sounds as if the only general editorial I'm being requested or, ruling is to instruct the jury to disregard Detective Kelly's testimony about a VHS or some sort of video. What are your thoughts on that, sir?
I'm not objectionable to that, Judge.
Okay. So what we'll do then is we'll have Detective Kelly return to the stand. I'll have the jury brought back out. When the jury returns, I will instruct them that they are to disregard any testimony from Detective Kelly regarding a surveillance video showing a dog. And then Mr. Samuel can resume his cross-examination.
Yes, sir.
Okay?
Thank you.
Thank you. I'm ready for the jury.
Our artwork and humor from the chat while they bring in the jury. Hold on, we gotta cue this up from Aaron. Doo, doo, doo. Oh wait, does it not include? Oh, I gotta screenshot it with your text in it. Hold on, let's redo this.
Please be seated. Ladies and gentlemen of the jury, in a moment, Mr. Samuel is going to resume his examination of this witness. Before he does, I'm just going to instruct you that this detective's testimony regarding a surveillance showing a dog, that information, that I am instructing you to disregard that testimony. Do you understand? Any problem with complying with that instruction? Okay. Thank you all. Mr. Samuel, you may resume your examination.
Thank you. Detective Kelly, you mentioned on your direct examination something about bleach, and I want to clarify that as well. Am I correct that you don't have any independent knowledge that there was bleach in the bags? Is that correct?
That's correct, yes.
Okay. In fact, what you've learned was that the bleach was put on the jawbone and on the skull at the crime lab or at the medical examiner's office, correct?
Yes, it was.
Okay. So there wasn't bleach in the bags. There was decomposition of
fluid,
flesh and whatever, but there wasn't bleach that was put in the bag.
No.
Correct?
Yes, there's an understanding between me and somebody else.
Speak up a little bit for these old ears.
Yes, you're correct.
Okay. All right. All right. Now, you indicated before that you were missing some police reports, right? Or at least one. And during the break, you and I had a quick conversation, right?
Yes, sir.
And the police report that's missing is the one dealing with the second time you all went out to the scene. The first time is in April, the second time is in June. Is that correct?
Well, I was provided more reports that I did not have or was not given to me at this time. And then the one I'm referring to now is 6/3 of 99.
Right. And that one you don't have and nobody has, but you and I discussed it, so it's as good as if we had a police report, yes. Right? Okay. So in June, you go back out there. And you're in the same general vicinity or somewhere out there, is that right?
The wooded area.
Wooded area.
Yeah.
You're not on the road anymore.
No, sir.
And now we have black plastic bags, no bleach or anything, but black plastic bags that have different parts of the skeleton, frankly, okay. Right?
Of human remains, yes, sir.
Human remains, okay. And you gathered those up, and they all get sent to either the medical examiner or the crime lab, correct?
Well, no, I did not gather them.
You were present.
I was present
yes.
when it was being done. The medical examiner's office was there. They took custody of them immediately.
Right, and they've taken me either to the Fulton medical examiner or eventually the crime lab, or someone we'll be hearing from later on in this trial.
Yeah.
Okay. Now, did you actually see where the black bags were found in the wooded area? Were you watching as they were collected, even though you don't put hands on them?
Yes.
Okay. And the people who were putting hands on are?
Medical examiner.
Are they wearing gloves?
Yes.
I'm sorry. We have a problem. Double problem. My ears and your soft voice.
medical examiner and their investigator that was out there.
And they wear gloves, correct?
Yes, they wear gloving.
Right. And so on these bags, if there's DNA evidence on any of these bags, presumably it's not going to be crime lab people or detectives because you all are too careful about that, right?
They were. I was not touching anything.
Right. You don't touch them, and they're wearing gloves like you see the crime lab people on TV always doing.
Uh-oh. They have other profiles.
Now, were these bags buried?
I remember some of them were buried very shallow.
Okay. So just kind of give us an overview. You're in a wooded area. They're like buried under leaves, or did you have to use shovels to dig dirt out?
I don't recall.
Okay, fair enough. It's 25 years ago.
Yeah.
There were paths through the wooded area. Do you recall that?
Yes.
Okay. Were some of the bags just simply placed on a path?
I don't recall if they were placed simply on a path or not.
Okay, well, you wouldn't know. Placed is a verb that you wouldn't know, but were they located on the side of the path or right in the path?
I'm going to say on the side.
Okay. So anybody walking on a path would have seen the bag, presumably?
You would think, yes.
Okay. And it's now June of 1999?
Yes.
Okay. And that's the first time, as far as you know, that those bags were ever moved from the path or the side of the path?
Yes.
Was there any evidence that you remember, and I know you don't have the report, it's missing, but in your memory, do you remember seeing loose dirt as if other people, the cadaver dogs, were digging up the ground as opposed to the bags being on the surface?
I don't recall.
Very good. Okay. Those are my questions, Your Honor. Thank you.
Thank you. Mr. Wilson, redirect?
They just have one.
Sure.
I think he said he needed a moment.
Thank you, sir. You may step down. You are excused as a witness. State may call its next witness.
We call Tina Miller.
Thank you, ma'am. If you'll come up to the witness stand, and once you get here, before you have a seat, if you'll turn and face the deputy and raise your right hand.
You swear or affirm the testimony you're about to give court today shall be the truth, the whole truth, and nothing but the truth? Yes, I do. You may be seated, lower your hand. State this for your name for the court reporter, please.
Tina, Tina, Miller, Miller.
Where do you work, ma'am?
I currently work for the Gwinnett County Medical Examiner's Office
How long have you worked there for?
since 2018.
What did you do before that?
Prior to that, I worked for the Atlanta Police Department. I retired as a lieutenant in 2014.
Were you a certified law enforcement officer while you were working with the city of Atlanta?
That's correct, yes.
Could you kind of tell the jury about go quickly through your career as a law enforcement officer?
Okay. Right out of high school, I went into the United States Army where I was trained as a military police soldier. When I got out, my goal has always been to go into law enforcement. I got that basic training there in the military. When I got out of the Army, I applied to the Atlanta Police Department. I was hired in 1984, started my training with them, and retired in 2014. While at the Atlanta Police Department, I served in Zone 6 as a patrol officer. I was promoted to detective a couple of years later. I was assigned to narcotics, where I spent 5 years working undercover and buying and working drugs in the city of Atlanta. I spent 5 years working fugitive after that. Then I went to the homicide unit, where initially I worked aggravated assaults, and then went on to do adult missing persons in the homicide unit.
And could you describe the duties of an adult missing persons detective, what you did?
Yes, any adult missing in the city, 17 and older, would come to my desk. And I would follow up on the case, contact the reporting person, and do legwork in an attempt to find the individual. Typically, what I would do is go out to neighborhoods. If they had a substance abuse problem, I would go out to the neighborhoods they were known to frequent and see if I could locate them, get word on the street that their family was missing them. And I had a pretty good success rate with getting them or finding them.
And were you called in to assist on a case of a skull found in April, the end of April of 1999?
Yes, I was.
Could you please tell the jury what the circumstances of that were?
I was in working homicide and doing missing persons, and my lieutenant would have me go out on scenes where situations like that, you know, if we had a missing person or we had somebody, we didn't know who they were. And on this particular day, the call came in that Uniform had responded to a call where there was a human skull in the roadway, and went out there with him and Detective Kelly. So I rode with the lieutenant, and we went out and secured the scene and took information and worked the scene.
And where was that located?
On Avon Avenue.
And was that in the city of Atlanta?
Yes, it was.
Fulton County, Georgia?
Yes, it was.
Did you, when you first got to, what do you recall when you first got to the scene?
Obviously, Uniform had responded, and they had blocked off the roadway with crime scene tape. And I remember seeing the skull sitting upright in the roadway with a white stick in front of it, or a painted white piece of wood. And there was a black trash bag, and also various items that had probably come out of the bag or off of the skull in the roadway.
And is it, I know you didn't do it, but is it important to document the crime scene using photographs?
Absolutely. Absolutely.
I'm going to show you what's been previously marked in States Exhibit 21 and 22. I'm sorry, may I approach?
Yes.
Are you familiar with those?
Yes.
What are they?
They are crime scene photographs of extremities in a black trash bag that were found by me later when we went back out to the scene to search for additional remains.
And are those accurate, true and accurate depictions of the scene?
Yes, they are.
Your Honor, at this time, I'd ask that 21 and 22 be admitted into evidence.
Mr. McDermott?
Objection.
Okay. 21 and 22 are admitted.
Now let's go back to the 29th of April. I'm going to show you what's been previously entered as States Exhibit number 3.
Do you mean the 28th of April or 29th?
29th of April, 2000.
Is that the initial call?
Yes.
Okay.
Okay. All right. Now you can see on the, you can look on the screen. And that States Exhibit 3 is that shows, that depicts the scene at Avon Avenue?
Yes, it does.
Could you kind of point out to the jury what significant things are on the street?
Am I pointing up here?
Yes, actually, that's probably a good idea. Your Honor, may the witness have permission to leave the stand to help?
Sure, just a reminder to speak up so that the court reporter and the rest of the courtroom can hear you. Thank you, ma'am.
Here we have the skull, which is now sitting upright with the white board in front of it. Here's the black trash bag, and these are items that either came out of the bag or came off the skull, because the skull, it was believed, had been struck out in the roadway.
Did you closely observe that skull?
Yes.
And did there appear to be damage to the bone structure?
Yes.
And what damage was there?
I can't recall specifically, but I can't recall specifically. Because there were pieces.
Show you what's been marked as states 4. What does that show?
That shows, again, a different angle of the scene where it's down toward, I believe it's down toward Hartford, looking up Avon Avenue.
And what is significant in that picture as far as this investigation?
Again, you could see the skull, you can see the back black trash bag and other miscellaneous like parts that may have been skin or bone.
Let me show you what's been marked as states 5. What does that depict?
Closer photograph.
Show you state 6. Is that a different photograph of it?
Yes, this is more toward the railroad tracks, looking back to your right.
I'll show you what's been marked, or what's been entered, excuse me, in States Exhibit number 11. And what is that a picture of?
That is the black trash bag.
There's a yellow card that has, for lack of a better term, the number 2 on it. What is that?
That is a marker that was, I believe it was put out by the medical examiner's office to indicate later that they could diagram what was there by the number and reference it later as to what was there.
Okay. I'm going to show you what's been marked as States Exhibit number 15. And that is?
That's the actual skull in the roadway.
And where was that in location to? Are you familiar with the business next or very close named Action Glass?
Yes.
How far is that away from Action Glass?
Not very far. It's, if you walk back on the other, behind, like going to the right here, you would go to the intersection and the glass company is right across the street at that intersection.
And if you observed the skull, was there any decompensation or decomposition?
Yes, there was.
About that skull? How would you categorize that?
Advanced decomposition.
As the skull sat there, were you able to make any identifications at all?
Absolutely not.
Could you tell anything about that other than it was a skull?
No, not at all.
Wonder why they're muting.
Not on that particular day, no.
How long were you out at the scene?
Probably a few hours.
Okay. And did you do anything, Did you do anything else at that scene on that day?
I assisted with anything that the homicide investigators needed to be done, and I also assisted Mary Beth Hoptel in photographing by just showing her, pointing out different items in the roadway that may be related to the skull.
But she actually took pictures,
Absolutely.
not you.
No, I did not.
What else did you do that day?
I believe that was it.
Okay. Were you out there on a different, well, did you do any, what work did you do on that case starting that day?
Well, initially, the case was handled by a homicide investigator. And once the medical examiner's office collected the remains, because basically they handle remains or a decedent on the scene. And I was in communication with them and assisting the homicide detective in trying to find out who this individual was.
Was it important to find other parts of the individual?
Yes.
And had you been able to do that yet?
No, not at that time, not that day, no.
Okay. So what's the next significant day that occurs in your investigation?
The next time was probably, I think, June 3rd of 99. Initially, there was some question that particular head belonged to an individual that was not in the Atlanta area. The investigators were able to determine that head did not belong to the individual in Middle Georgia. They found all of their remains, and it was determined by dental that our skull did not go with that body. And so my supervisor suggested that I get a cadaver dog, and a cadaver dog is trained to sniff for human remains and go back out there, which we did.
Who all went out there with you that day?
The medical examiners had sent investigators out, and also the homicide unit was out there. And because the area we were going to check was railroad property, we had 2 railroad detectives as well assisting us.
And you remember what side of the street the skull was found on?
Correct.
Was that where you were searching?
We were searching, there's a wooded area which would be across from the skull, and we were searching the other side of that as well as that wooded area.
And were you able to find anything?
No.
How long were you out there searching?
Probably all morning.
And you were also using a cadaver dog?
Yes, we were.
And there was, how many people do you think there was approximately?
Maybe 8.
How long did you stay searching at that?
They stayed for several hours, and then another call came up, and when the other homicide call came up, they all left to go handle that call, and me, the dog handler, and the 2 railroad policemen stayed.
And what happened next?
We were standing there discussing, kind of what to do next or further options. And a gentleman that owned the garage on the corner came out, and he said, you might want to check the wooded area behind my shop. He said people use that as a cut through, and there's people back there doing drugs, and you might want to check that, and we did.
And what did you find?
The railroad policeman didn't go with us, but me and the dog handler entered the wooded area, and there was kind of a path, so we're kind of walking through the path, and I'm following the dog. And the dog kept going, and I noticed off to the side a black trash bag, and I picked up the trash bag, and it was rather heavy. I opened the trash bag, and an item of clothing fell out, and it looked kind of moldy and off-colored. Well, there was another bag inside that was also it was heavy. And so I pulled it open, and when I pulled it open, I saw flesh. And I pulled it open a little more, and I saw the beginnings of toes on a foot. And at that point, I realized we'd found additional human remains, and I believed that to be a female foot. I
Okay, who all was out there at that point?
Me and the dog handler.
And then what did you do next?
At this point, the dog had gone ahead of me, and the dog went around to an area kind of behind where I was and found the leg and thigh that was in that photograph.
Okay, and let me go ahead and have you take a look at States 21. And what does States 21 describe?
That is the thigh, lower leg bone that the dog hit on. Or
Was
loaded on.
that originally in a bag?
I believe so, but not when we found it,
Okay.
because there's a trash bag that was nearby.
I'm going to show you what's been marked as States 22. Could you describe it? Ed, what is that?
That is a black trash bag.
And was there anything inside of that?
Now, I can't tell from that photograph if that's the one that was next to the thigh and lower leg bone, or if that was another one.
How many trash bags did you find out at that scene?
I actually just dealt individually with the two, but other bags were recovered. Once I found realized what we had, I immediately contacted my supervisor in homicide to let them know we had additional remains and they needed to return to where I was, my location.
Now let me ask you this: How far were those bags from where the skull was initially discovered?
Not very far. The street ran in front of the little junkyard car repair place. This was directly behind it, so not even a block.
And how long did you stay on the scene for that?
Several hours, because the medical examiner's office came out. We, searched that area and found the additional bags, and then they collected them. After they documented where they were, photographed them, then they collected them.
And there's a business action glass?
Yes.
How far was action glass from the discovery of the additional evidence on the first video?
Right across the street.
So within
50 feet, if that far.
What did you do next?
On that particular day, again, the remains were collected by the medical examiner's office, and they were taken to the medical examiner's office for the examination. And I assisted the homicide guys with whatever. I had gone back and I checked again for my records, and I did not have a missing person fitting any description in that area.
So what did you do next on this case?
Again, just assisted the. You want me to fast forward?
Sure.
Okay. I was promoted out of homicide, and before then I worked with the medical examiner's office in trying to find out, did we have a white male, black male, male, female? What did we have with the skull? And the individuals at the medical examiner's office determined that the skull belonged to a white male. I didn't agree with that, but they were the experts, and so it was listed on the system as a white male. And what we did was we put the individual, we put the skull for sure, and we had to do them separately because at this point we didn't know they were the same person. I put the individual on GCIC, which is the Georgia Crime Information Network, and then there's the NCIC, which is the national database. And in a perfect world, that is set up so that when we put that information in, if there's a missing person that fits that description, as limited as we have, we would get a hit on it. And it would say, hey, look at this person. This may be who this is. That did not happen.
Okay. May I just have a moment?
Yes.
Passing along.
What else did you have to do with this case?
Again, I met regularly with Dr. Terry and talked to her about the case.
Who's Dr. Terry?
She's, at the time, she was a medical examiner working out of Fulton County. She's a forensic pathologist that was looking, at the time, we were working together looking at the unidentifieds that she had in her office and the missing persons I had in my office. And we were comparing notes, trying to get our individuals identified.
Okay, but as far as the scene and everything, that completed your work on this case?
Yes, that completed my work.
Nothing further.
Thank you. Mr. McDermott?
Your Honor, I hate to do this, but I just received, literally just now, about 70 or 80 new photos of this particular crime scene with bags, and I would ask the court to have a brief recess to be able to line some of these new photos up.
What?
Choose a few to talk to her about this.
Okay.
Cross.
Ladies and gentlemen, I'm going to ask you to step out for just a moment while we get ready to examine this witness further. It is 3:32, and I'll have you back in here as quickly as I can.
What the heck? Oh my. What the heck? She's got volume. All right, let's run that. What? He's like,
Ladies
and
Yes, that completed my work.
Nothing further.
Thank you. Mr. McDermott?
Your Honor, I hate to do this, but I've just received, literally just now, about 70 or 80 new photos of this particular crime scene with bags, and I would ask the court to have a brief recess to be able to line some of these new photos up. Choose a few to talk to her about this.
Okay.
Cross.
Ladies and gentlemen, I'm going to ask you to step out for just a moment while we get ready to examine this witness further. It is 3:32, and I'll have you back in here as quickly as I can. Thank you.
all right, for the jury. What are we doing? So we'll.
Anything?
She needed a quick
Thank you.
sip.
Please be seated. Anything you need from me while you do that?
Not really, thank you.
Okay. Then we are, say, maybe a 10-minute recess until 3:45.
15 when we go further.
Okay. 3:50 it is. Ma'am, if you will step down, you can just hang out outside, but don't wander far, okay?
Yes, ma'am.
Thank you. We are in recess until 3:50.
Yeah, and Dizzy, I'm wondering if this also relates to this witness seemingly like she's recalling this detail from like 20 years later, 25 years later. There were other bags, but I looked at those too. Like, did the state just go, oh my God, uh-oh. Oh, that's a weird, that door just tripped me out. Doesn't it look like the wall is moving? It's a door. It's a doorway. Like, what are we doing? How is this? And if you missed it earlier, if you're joining us late, we just had another guy on the stand that's like, there was a VHS tape that showed the dog running out of the woods with the plastic bag that, you know, the dog runs to the street, drops the bag in the street, plays with the bag, head comes out of bag. Oh my goodness. Ah, look at Aaron. Aaron says, so that's why Hylton didn't come back after the conference with the detective. She went to go see what else they didn't turn over from the officer's reports. Like, I don't know. I just don't even know. All right, so Kathy has a clip of what happened earlier. So let's pull that up and rewatch that. Kathy Rousseau. Yeah, I hope they don't get on Glanville time.
I'm just very concerned if by witness number 2, we're discovering that the prosecution knows there's missing evidence, missing surveillance cameras, missing police reports. They know that that's true, and they're not even telling us about it. It's bad enough that they're missing, which is understandable after 20 years to some extent. It's not understandable why they wouldn't tell us. I'm just very concerned if by witness number...
Like, and this was what? I mean, so this Tina Miller got on the stand 6 hours and 5 minutes into the stream. It's been less than 30 minutes since Tina Miller took the stand. And the witness before her is the one that this clip is talking about. We just instructed the jury on some issues. Now we gotta... And they got that in front of the jury, right? The defense said we got the 60 or 70 photos before the jury was let out. So the jury's hearing that there's a hot mess. Classic trial by ambush, still up to the shenanigans, grave concerns. Yeah, his love directing from the sidelines. Oh my gosh. We'll switch back over, make sure we don't miss anything. Miss any heads walking by the cameras. Bittersweet just says they're idiots. Yeah, that was me. That was me being silent. Yep, suddenly found 60 to 70 crime scene photos. And again, the flip side of this is if it's just sloppy work and not intentional, it's not fair for the defendant. And this is a cold case where you're dredging people out of like decades old experiences. To have them come in, and even these witnesses that aren't family members, they're like, yeah, well, this is us looking at the head and it was decomposing and probably smelled in a way that I'm remembering right now, because that's probably not something you'll forget. Put all these people through this just for your presentation to suck. And let alone have the family members come in. Imagine the family members have to come in and talk about this. And I get that here there might be some issues with, you know, maybe a family member is a third-party culprit. But that aside, anyone that's not just possibly complicit, like, they have to re-grieve this loss for a cold case where they never had closure. Adam Abate is gonna appear shortly. Oh my goodness. Just crazy. Lawn lyrics as I submit to you more evidence. Yeah, we've got a dumpster fire. Sanctions. Sanctions would be nice. And Bobby, I mean, I wouldn't be surprised if we end up eventually seeing a motion for mistrial. But again, I think this is very good. You have a cold case that's so long ago. You know, you have possible other people to point the finger at. And then you have, by witness 2 and 3, you have the district attorney's office looking like a hot mess in front of the jury. So, yeah, throw the tomatoes. Throw the tomatoes. Yeah, oh, I'm sorry about that. And do you go by Curno or Curnow? I say everything wrong. I say every name wrong. And the way this judge says, did she say voir dire? I keep thinking it's gonna impart on me and I'm gonna start saying it a different way now. Because listening to Legal Vices, he would always get very comical and exaggerate and just go, voir dire. And I picked up on it. Oh, good old Jeff. Let's see. Yeah, shocked and not surprised. Yeah, motion for dismissal, forget a mistrial. Well, if it's coming from the judge, it's not really a motion. Get Judge Summers in here from the Rush trial. I like that her name, like the bat signal picture. It's like you think of Judge Summer every time you think a judge should slam down the gavel. Curno audits. Okay, there we go. Curno. Is that really how Cornwall is said in Cornish? Curno? I would never get that. I need it phonetically the way you've got it. Oh, yes. Jeff, I think, would have loved Jim. Shanikia says get rid of the whole DA's office. Heck yeah. I don't know. I picture there's no way that there's not going to be another piece of evidence that wasn't overturned. And these attorneys are not playing around. They're speaking it into the record. And I imagine they're doing it for the record, but it could also be for the public. They know this is being streamed, that the media is in here. But for the record, they're spelling out, we just got specific thing that we got. And making it clear that this is happening. So if the state turns over something tonight, I bet they'll walk in and say, Your Honor, here's the laundry list. Let's spell it out. Exactly what they turned over while we have witnesses on the stand. CMT says Kraus already knows the DA's janky. She might throw this at them. We'll see. And good to see you, CMT. So they ended up identifying him, apparently, I don't know, but I heard that somebody, I think the chat was talking about it, and I also read it. I read about it, not read it, the forum, that an investigative podcast either got the tip and then provided it to DA, or they got a tip and pieced it together with something else and brought it to the prosecution. Or brought it to someone that it got there down the line. So that'd be pretty cool if... And I think as long as it's vetted, right? We'll have to see if it's all vetted information and what they did with it. But somebody finding out information, being able to bring it to the table is pretty cool. I wonder if High Top is having flashbacks. We've got Hilton Head and High Top going on today. And anyone asking, the defendant is in a wheelchair, but they're calling this the Thanksgiving murder trial, 1998. Seems like they're finding stuff in 1999. So just because the defendant's in a wheelchair today doesn't mean that he was in a wheelchair back in the day. I think people are wondering, like, how could he be capable of doing these things, which I'm not sure that it would be impossible, but it's a harder thing to imagine someone doing if they can't walk through woods and whatever. But please remember that this is like 27 years removed. 1998. VHS tapes. Yeah, so Mindy had a podcast. It was mentioned not just in the victim impact statements, but Morgan Paddock, her friend, when she was speaking during the victim impact, mentioned, I don't know if compelling women is part of the name, but Paddock described it as now there's compelling women that won't be able to have their stories heard because Mindy is not here to continue her podcast. And then during the trial, we also heard something about her having a podcast. Did it come from maybe Angela? Maybe it came from Morgan's testimony, but I think Angela might have mentioned something about her podcast too. But somebody during testimony, during like the evidentiary stage, did mention that she had a podcast. But I didn't find it, so. Oh, okay, wait, Dizzy found it. Of course Dizzy found it. Hold on, let's go to Dizzy. Wait, I don't see it. It was Max. Okay. Wait, I don't see it on your wall, but I don't know if you guys have been having a same trouble I've been having with X where it pulls up certain posts, but it doesn't pull up like recent posts. Like certain things will be missing. And then you'll refresh and it'll be there like an hour later. Oh, the podcast that got the tip off for Wolfenbarger. Yeah, okay, so, right, we're talking about two different things here. So we have podcasts for tip off for the Wolfenbarger case that we're watching now. And then Mindy, the victim, Nicholas Kassotis' victim, wife that he dismembered. While she was alive, she was running a podcast that seems like it was helping women tell their stories. And now she, obviously that podcast, I imagine, is no longer a thing. Zone 7. Let me get a link for that. Zone 7's kind of funny because I'm guessing it's unrelated, but the Atlanta we're hearing about, like Zone 6. Cheryl Mack McCullum. Okay. Okay, so here's an article that, are they coming back in? I have it playing, so I'll hear it. We'll jump back over. But Dizzy shared this article here. Let's run through it. So how the capture of a serial killer father led to a breakthrough in his own daughter's separate murder case. Melissa Wolfenbarger, 21, we know the backstory. But it was a mystery until now. Crime scene investigator Cheryl Mack McCullum tells Andrea Cavalier how her podcast, with help from experts, the media, and the victim's serial killer's dad, helped crack the case wide open. Oh my god, so did the dad talk to the podcast? And the podcast talk to the dad? So when working on a cold case, there's no guarantee that a murder will be solved. And even if it is, it often takes years or decades. So in the case of Atlanta mother Melissa Wolfenbarger, it took 25 years with the help of a podcast and in a bizarre twist, her serial killer father. Yeah, that's interesting twist. The 21-year-old was last heard from by her family on Thanksgiving of 1998. Her dismembered remains were found 5 months later in close proximity to her husband's place of work. It was 2003 before the remains were identified as Melissa, only after her father, Carl Patton, was arrested for a string of unrelated killings from the 1970s, known as the Flint River Murders. His arrest is what finally identified the remains, Melissa's mother, Norma Patton, told The Independent. If he had never been arrested, we might have never known. Melissa's death was not at the hands of her father, who'd been cleared in her murder, but what happened to her and the identity of her killer has remained a mystery for decades. Her case only began to gain some traction in 2017. It's so far in the future, but so far, it's like still so many years before today, but so far forward from the time of this. So 2017, when crime scene investigator Cheryl McCullum got her hands on it when Melissa's mother came to her for help. You can't give up, you just keep going, talk to anyone who will listen, because you don't know who that person might be to help. That's what Cheryl did for us. She opened the door and helped us walk through it. So this is all coming from Mom. So Melissa's mom, Norma, is very appreciative of this. And they are filing back into the courtroom. So let's speed through this. Melissa's case was the first to be featured on Zone 7 when it launched in February of 2023. In a stunning turn of events, over a year later, in April 2024, a listener who heard the episode reached out to McCullum and shared a crucial bit of information. I had a gut feeling, McCullum said, recalling the moment she received the tip. She told The Independent that the person had witnessed behavior between the couple, but she could not give further details. McCullum sent the information to the lead detective, and after more than 2 decades and no answers, the case picked up steam and shot through the next few months at lightning speed. 3 months later, in August 2024, Melissa's husband, Christopher, was arrested and indicted by a grand jury for her murder. I was just tickled pink. We waited so long for this, Norma told The Independent. It's been a long, hard road, but it finally happened. So then they go into the case. We're going to get back over to court, but I'm going to drop a link to the article that Dizzy shared.
Okay.
Yeah, tickled
Madam
pink.
Court Reporter, you ready? Yes. Okay. We are back on the record after our brief break for Mr. McDermott to review photographs that were provided by the state apparently recently. Mr. McDermott, if you could tell me, are you ready to proceed with the jury?
Ready to proceed.
State ready?
State's ready, Your Honor.
Okay, we're ready for the jury.
Ready.
I believe I'm looking into the system. If I'm not, I'll take the lumps.
So,
You want me to?
All right, for the jury.
Do you know how to share your screen, Ms. McDermott? You know what to do?
I believe I saw him. I believe I saw him in the hallway as I was coming in.
Who are we missing?
Can we get our witness back, please? Come on back up to the stand, ma'am. As you're returning to the stand, just since we took a break, I'll just remind you that when you began testifying, you were sworn in and that you continue to be under oath. You understand?
Yes, sir.
Thank you. Please have a seat. Mr. McDermott, you may begin your examination.
Ms. Miller, first of all, there's a T.R. Miller in several of the reports. Is that you also?
Yes, that's me.
Okay, thank you. You were called out, were you called out with the group on June 3rd? And that was when the parts were first discovered?
Yes.
Okay. And there was a second group that went out on the 4th. Were you also part of that group?
We're talking about June?
Yes. Yes, ma'am.
I think that was just one day that we were out there,
That you went out?
that we went out.
Okay. So I just want to be clear, you only remember going out one day?
There was the day where we found the remains, and we may have gone back another time and did a grid search.
Okay. That would have been like weeks later or several days later?
I can't recall. I can't
That's
recall.
You mentioned a search that was done in conjunction with the railroad police?
That's correct.
That would have been across the street from Action Glass and the other businesses, right?
That's correct.
And nothing was recovered from that search?
No, it wasn't. The dog, one of the employees from the medical examiner's office was concerned about a black bag that was over there that the dog kind of looked at, urinated on, and kept walking, and turns out there was a dead dog in the bag. So the dog was justified in passing it by.
Was that an active rail line at the time?
I believe it was.
So I want to show you a couple of more of the photos that were taken from the day the remains were found. If I want to show that to her, I want to share my screen now.
If you need her to identify it
struggle.
before you, in order to lay a foundation to have it admitted, you really need to show her in physical form if you are able.
Don't have that.
It
Potentially
is,
criminal.
perhaps you could show it to her on your
On my computer.
screen.
Yeah, I'll do that.
It is possible to only broadcast to one screen, but it's exceedingly difficult. Yes, sir, granted.
I want to show her all four that I have.
Go ahead.
I think we should convince Sean to cover more Fulton County madness.
Yes.
I'm going to drop Potentially Criminal's link in the chat. You go sub up. Come hang out. He, several times has said that we should just bulldoze the Fulton County courthouse. Just bulldoze it down.
Yes. Yes. Yes.
So for the record, I've shown you 5 photographs.
Yes.
And those familiar to you?
Yes.
And are they fair and accurate representations of what you observed the day that you were on the scene
Yes.
on June 3rd?
Yes.
Okay. Permission to publish, Your Honor?
I'm going to let you
All right,
publish them, but can you give me a designation for our record?
These would be defense 1 through 5.
Okay.
And move those to evidence, please.
Defense exhibits 1 through 5. Mr. Wilson, any objection?
No objection, Your Honor.
Okay, exhibits 1 through 5 from the defense are admitted and you may publish.
Thank you. I hope this works.
The struggle bus. Every court needs a Kokomo. And we'll do late starts so we can skip all this stuff for the next few days as we watch this.
Whoops.
For real, Kokomo went to law school and Fulton County Tech has fallen apart ever since.
My apologies to the court.
I'm gonna pull up Factual Lies I Submit to You song if this continues. No, if Doug just did an interview, I didn't see it. I've been on here.
Perfect. An update is being installed.
Isn't technology great?
And Factual Lie just linked to a Dougie short.
And on top of that, I understand you have a plane to catch.
I do, sir.
Oh my gosh. Yeah, she said she works in Gwinnett County now, so, I mean... Is it that far? Maybe she has other plans.
Let's see if I can go about this a different way.
This is defense, you guys. We're on cross. But they did just get 60 to 70 pictures turned over right before we did this. Like minutes ago.
Finally. And can you describe what's going on in this picture?
That appears to be the area where the thigh and long leg bone, lower leg bone was.
Okay. And does that appear to be in a, what you described earlier as a kind of a walking path or a cut through?
That's actually, the walking path is further over to like the upper part of the screen. This was a lower area closer to the street.
Okay. So that was close to the street or closer to the street?
Closer to the street.
Okay. All right.
Just end court for the day. Get rid of this witness. No cross for you. Like,
And is this the same item
Yes, it is.
from a different perspective?
Yes, it is.
All right.
For record purposes, was that D1 and D2?
Yes, ma'am.
Thank you.
Now displaying D3. And can you explain what we're looking at here?
It looks like one of the black trash bags.
And is that in kind of a clearing or a little path? A little
It looks
path?
like it may be off the path.
Okay. Is it visible from the path?
I don't recall. I don't know where the photographer was standing in relation, if he was on the path or she was on the path.
Okay.
I'm not sure. I mean, I'm sure they had to have been prepared or should have been prepared to show at least some pictures, but 60 to 70 were also newly turned over to them. But I imagine they had at least some
And what are we
pictures they
looking at
wanted to
here?
discuss with her beforehand.
Defense 4.
Another trash bag.
And can you remember or recall the general location of this as to where you were looking?
No, not without looking at a diagram.
Okay. And final one, defense 5. What are we looking at here?
Again, that looks like trash bags, and if I'm seeing this correctly, that looks like the thigh and lower leg bone over to where the number 2 is.
Okay. And again, the same difficulty with the location?
No, it's going to be, if that's the leg bone, that's going to be on that further side.
Okay. Further side meaning from Avon Avenue back further behind the business?
If you come in off Hartford,
Okay.
this would be to the right more so than where the foot was that I recovered.
Okay,
This
I
would
see.
be off to the right. It appeared at the time that perhaps an animal had tore open that bag, and it was off to a right, more toward the street.
This one, this bag here?
Correct. Again, if I'm seeing that correctly, and that is the thigh, there was a bag nearby that thigh.
Is it fair to say that this is not stuffed back in the brush?
No, this was, the thigh and the lower leg was pulled out from the brush.
Well, did you see it pulled out?
No, it was found,
Right there?
right, it was found not in a bag anymore.
Okay.
With
But
a
in that
bag nearby.
location?
Yes.
Okay. And as it is in that location, it's not shoved up in the brush or anything?
No, it appeared to have been pulled out of the brush. It was more in a clearing area.
Thank you. You said one of your jobs was to point out items that may have been associated with the skull in the road. This is, of course, going back to April 29th. Is that correct?
That's correct.
And did you find any other items?
Just the pieces that appeared to have either come out of the bag or off the skull.
And some of those were far down the road, correct?
They were a little further down, not too far, but further down.
And is that what you were referring to when you said it looked like it had been possibly hit by a vehicle?
That's correct.
Okay. No further questions, Your Honor.
Thank you. Mr. Wilson?
Oh my gosh.
Thank you. Very briefly. That's fine. Thank you. May I approach?
Yes.
Thank you.
Okay.
And I've shown you a picture of exhibit number 2. Do you recognize that, what that is?
Yes, I do.
What was that?
That's the area, and it's an overview of the area where the skull and the additional remains were found.
And is that an accurate description of how the streets and how that part of the town looked?
Yes, yes.
Okay. Your Honor, at this time I'd ask that states number 2 be admitted into evidence.
Any objection?
No objection.
Exhibit 2 is admitted.
I'd go ahead and publish that.
Go ahead.
Thank you. Okay. Can you step off of the stand and point to where the skull was?
Okay. Your Honor.
Or actually, first, before you do
Yes.
that, can you just describe what that is for the jury?
It's an overview of that neighborhood. It's a little different now than it did back then, obviously. The skull would have been found in this area, right here, right in here. This was at the time, I don't know if it was a junkyard or a mechanic shop. There was a gentleman that either owned that or worked there that was the one that referred us back here. And this is Hartford Avenue. This is the glass company, and the train tracks were back here on the other side of this grassy area, or not grassy, but the vegetation.
And when you described that you were searching on the 6th, or in June. Okay. What area did you first focus on?
When we went out there with the cadaver dog, it was this area. We went further down and started at the end where the tree started and came down. And once the additional call came out where everybody kind of left because we had not found anything, we were standing at this intersection, the dog handler and the 2 railroad policemen, when the gentleman came out and he told us about coming back here. I believe this may be a more modern picture because there were no houses. The houses were down here at that time.
And that's where you found the remains.
Correct.
You can have a seat. Thank you.
The court feed. No wonder she asked to fast forward earlier. She has this flight to catch. Now they're whispering and cutting us out. Guys, we will continue to watch this trial. I'm invested, but we're definitely going to do late starts and skip some of this stuff because this is crazy. And we started this late too because we were splitting this stream with the Kassotis instructions and verdict.
I'm showing you what's been marked as State 64. Is that familiar to you?
Yes, it is.
And, could you describe it?
They're black trash bags that are in the wooded area.
And I'm also going to show you what's been marked as State 65. Okay, is it familiar to you?
Yes, it is.
And what is it?
It's another black trash bag in the wooded area.
And are those fair and accurate representations of how you found things?
Yes, yes, they are.
Your Honor, at this time, I'd ask states 64 and 65 be entered in or admitted into evidence.
Mr. McDermott?
No objection.
64 and 65 are admitted.
Thank you. I'd like permission to publish these.
Go ahead.
Thank you. Okay, as you can see on there, where was this found?
It was in that wooded area.
Was that off the path, or when you answered earlier questions about being on path or off the path? Do you recall where these were found?
This was off the path.
Do you recall what were in those bags?
No, I don't.
But those were relevant?
No, there were remains in the bags that were collected by the medical examiner's office.
But that's how they were found.
Correct.
Show you states 65. Okay. And what is that
That's
picture describe?
another bag that was in that area, and I'm not sure if that's the bag that had the foot in it, because I really can't tell. If I got up and looked closer, maybe. I can't tell, but there were remains in the bag.
Would you like to take a closer look at it?
Yeah, I'm not going to be able to
Okay.
tell.
And where was that bag?
Again, in the wooded area.
The same general area?
Yes.
Nothing further.
Any questions on those questions, Mr. McDermott?
No, Your Honor.
Thank you, ma'am. You may step down.
Thank you, Judge.
Get your flight. Catch your flight.
State may call its next witness.
Your Honor, the state calls Tina Pett.
Yeah, this is going to be so much better watching on like 1.5, even 2 times speed. Because this is killing me. It's killing me softly. I think in both the Kassotis trial and when we watched the Doherty trial, witnesses were up and at 'em. Aside from the prosecution, like, hey, we need a delay because we want to put Tracy Sands on the stand last.
Before you have a seat, if you'll turn and face the deputy and raise your right hand, he'll swear you in.
What's going to happen with this witness?
When you do, just be careful of that ledge because your chair's on wheels.
Yeah, I see that.
Get yourself situated, move up to the microphone. and
Thank
if you'll
you.
State and spell your name for my record, please.
Okay, it's Tina Mae Patton, Patton.
Oh, we have a patent.
Yes. Ms. Patton, good afternoon.
Hey,
All right. Can you tell the court what part of the county, where are you from?
I'm from Henry County.
All right. And are you familiar with the name Melissa Wolfenbarger?
Yes, sir.
All right. How do you know Melissa Wolfenbarger?
She's my sister.
Okay. Do you have any other siblings?
No, just her.
All right. And is that your biological sister?
Yes.
Can you talk about where you and your sister Melissa Wolfenbarger grew up?
Well, part of my life, we were in Ellenwood, Forest Park area. And then the other part, most of the time when Melissa was in school, we were in Stockbridge or McDonough, Locust Grove.
Okay. How many years did you live in the same household with Melissa?
Until I was 18 when I left.
Okay. And are you the same age as Melissa, or you guys different ages?
No, she's younger. There's
Okay.
7 years in between me and Melissa.
All right. And who lived with you and Melissa in your residence growing up?
It was me, Melissa, my dad, well, our dad, and our mom. And for a little while, our granddad on my dad's side, Papa.
Okay. And what is your mother's name?
Norma.
And what's her last name?
Patton.
And what is your father's name?
Carl Patton.
Okay. And were your mother and father together throughout your childhood?
Yes, sir.
Okay. And what type of relationship did you have with your sister growing up?
Well, there were 7 years between us. So we were doing different things at different ages. I mean, there were 7 years between us. So when I was 7 and was out playing and stuff, she was a baby. So we wasn't that close. I mean, we lived in the same house and we played outside and stuff, but we wasn't like 1 year between us that kind of close.
Okay. And do you live with anyone now?
Just my husband.
Okay. Now, you said that you lived in the same household with Melissa until about 18. Is that correct?
I was 18 when I left.
And what did you do? What did you do, and where did you go when you left the residence?
Well, when at 18 when I left, I was in Stockbridge probably for about a year with my dad's Aunt Marie with her daughter, Elaine. I lived with her for a little while. And then after that, I ended up in Las Vegas, actually, Nevada, and had my son out there.
All right. And when do you make your way back to the Georgia area?
When my daughter was, let's see, she was born in 90, so probably about February of 91, we came back to Atlanta. Well, I came back to Atlanta with both my kids.
All right. So it's February 91. You left at 18. Roughly how many years has passes between those two events?
3 years.
All right. During that period, did you keep in contact with your family members?
Yeah. Melissa came to Tucson, Arizona and lived with me for a little while.
Okay. All right.
Before I had Kimberly.
All right. That would have been during that 3 year period?
Mm-hmm.
So from, say, 18, 19 to mid-20s? All right. And so when you came back, did you live by yourself or live with someone else?
No, I went back to mom and dad's house.
All right.
And Melissa was still at home.
All right. And so you're about, say, mid-20s during that period?
2021.
All right. How long did you stay at the residence with Melissa and your mother and father?
I stayed there pretty much until probably late 94, probably when I left again.
Okay.
But I'm thinking about 95 because 95 was when I got married to my first husband, David. And that was in early 95 though.
Okay. How long? It's okay. All right.
So it was probably about October or so of 94, I guess,
all right.
when I left.
Were you employed and working anywhere during that
I
period?
wasn't working. I was pregnant at that time.
Okay. And at some point, did you start working?
When I went back home.
And where did you start working?
At Waffle House.
All right.
Again.
All right. How many years did you work at Waffle House?
Off and on for about 20.
Okay. And during that period, while you've been employed at Waffle House up until the time that she disappeared, did you keep in contact with Melissa Wolfenbarger?
Not. I was kind of mad at my parents. Well, more mad at my mom. I was upset with my mom. So I really didn't call home much, but all of a sudden one day somebody comes up to me at Waffle House and says, "Guess who you're going to be training tonight?" And I'm like, "Who?" They said, "Your sister." And I'm like, "What?" And she was married then. She was already married to Chris.
Okay. And what year was that, if you can recall?
97.
Okay.
Yeah, 97.
So that was roughly the year before she disappeared? All right. So what type of work would Melissa do at Waffle House?
Well, she worked third shift with me. She was a server.
Okay. You recall how long she worked at that location? And what location was that, if I didn't ask you that?
It was close to the airport, Virginia Avenue, next to where Spondivus is. So the corner of Virginia Avenue and Bobby Brown.
All right. So roughly about 3 months, do you recall the time period?
Probably about 6 months because she had gotten her vacation pay. And Waffle House, you get a vacation check every 6 months.
Okay.
Shout out to Waffle House.
Are you familiar with Christopher Wolfenbarger?
Yes.
How do you know Christopher
Please.
Wolfenbarger?
He was married to my sister.
Look at her.
Do you
oh,
recall
she's
at what
oh.
point in your life you met Christopher?
Yep. It was 95 when I got married.
All right.
The day I got married actually was the first time I ever met him.
And were the defendant and your sister in a relationship at that time when you met him? Okay. And do you recall how long they were in a relationship when you first met him?
No. Because, well, it wasn't. It had been a while, I guess. Because when she came to work with me at the Waffle House, they were already married.
All right. How many?
It was 95 when I first met him, January.
95. And do you recall how much time passed between you first meeting him to when they got married?
Probably about not too long. I think it was only a month or two.
Okay.
A little confused by the
Did-
timeline.
Your sister and the defendant have any children?
Yes, they had two.
Do you recall their names?
Christina and Joey.
All right. Did you get an opportunity to spend time with them as they were growing up?
No, because I was working all the time.
All right. Prior to the defendant and your sister getting married, how much time would you say you had a chance to spend around him?
None.
Okay.
None.
After they got married, how much time would you say you had an opportunity to spend around the defendant and or your sister?
I spent more time with her than I did him.
Okay.
The only time I ever saw him was when he would come up there to the Waffle House to drop her off or pick her up.
All right. If you saw him in court today, do you think you could recognize him?
Oh, I know his face very well.
Okay. If you could point to
He's
Christopher Wolfenbarger.
Right there, black hair and the gray suit.
Okay, thank you.
If you would, ma'am, sorry, but for my court reporter, if you'll, you're fine so far, you don't need to repeat
Okay.
anything, but if you'll let the lawyers finish their questions all the
Oh,
way.
sorry.
Before you start to answer, thank you.
Got it.
Go ahead.
Okay. Your testimony was that Christopher Wolfenbarger would visit the Waffle House, Virginia Avenue near Spondivus.
Yes, sir.
How many times do you recall him doing that?
All the time. Every time she had to work.
And what would you see him doing during that period?
Most of the time, just watching what she was doing.
And are you familiar with the name Troy McClendon?
Yes.
Who is Troy McClendon?
Troy was my boyfriend at the time when I worked at that Waffle House with Melissa.
All right. And did you ever see Troy at the Waffle House?
Every day. He worked the same shift that me and Melissa worked, third
Okay.
shift.
Can you tell the jury if Troy ever was ever at the Waffle House at the same time that Christopher Wolfenbarger was at the Waffle House?
Oh, yeah.
Okay. And do you recall a confrontation between Troy McClendon and Christopher Wolfenbarger?
Yes, I do.
Now, without repeating anything that you that anyone else said during that encounter, can you tell us what you observed happen?
Melissa was running late this time. She was running late getting there, and I was standing in the back by the office door, just looking out front, watching what was going on, because it wasn't time for me to go out front yet. The manager was counting the money for us to take out, and Melissa came in. She came through the swinging door at the back where I was, and I looked at her, and she had tears in her eyes. And her nose was red, her eyes were red, because that's always how she got when she was crying. We all do when we're crying. And everybody in my family anyway. And I noticed that she had like red marks around her throat. And I said, Melissa, what's wrong with you? What's going on? Wait a minute. Is that a handprint around your throat? And she just looked at me and her eyes filled with tears. And I said, did Chris do that to you? And she just looked at me. She didn't really say nothing. And then I just turned and was going to go out the door. I was going to go say something to Chris.
Okay. Did you?
She wouldn't let me. She stopped me. She said, you'll make it worse.
Can you tell the jury what happened after that?
I went out front. Troy evidently heard me in the back room saying something to Melissa. So he was coming towards the swinging door when I was going out it. He said, what's going on? I said, he hit my sister again.
What happened after that?
Troy went over there and confronted him and hit him. And he just looked out the window.
I'm sorry?
Chris just looked out the window.
Okay. How long did that continue?
Not long, because one of the other employees came and grabbed Troy and pulled him away and got Chris out the door.
Okay. Now, what period of time, if we're trying to orient, you started,
Blow pan to the
I think
defendant.
you said during that 6-month period during 1998.
Sorry.
Okay. So if we're looking at that beginning of 1998 period, can you tell the jury as best you can, when did that happen?
That was more towards the end of 97.
Okay. Now, is that the only confrontation with Christopher Wolfenbarger that you can tell this jury about?
And that's the only one with Troy.
Okay. Did you end up having another confrontation with Christopher Wolfenbarger?
I did.
All right. Can you tell the jury how that happened?
Melissa had come and stayed with me for probably about a week. It was supposed to have been longer than that. So we would sit up at night talking about stuff, and then all of a sudden she decided she wanted to go home because the kids. So I took her home, and she was getting out of the car, and I was getting out with her, and I was going to hug her to tell her goodbye. And he came out of the house, Chris, and was coming down the steps, and he called me a bad name. He called me a B. And I started going up the steps. He said, if you put your hands on my sister again, I will beat your butt. And she grabbed my arm and said, Tina Mae, shush. You're going to make it worse. She always said I would make it worse.
Okay. Did anything happen after that?
No. No.
Okay.
She quit after that.
With Waffle House.
And around what time period was that?
That was within a month after the confrontation with Troy. So about a month.
Okay. Okay. Now, I want to turn your attention back to at the time that you were working at Waffle House with your sister. Can you tell the jury if anything you can recall about what the defendant told you that what might have been a cause for concern with you, especially considering the disappearance of your sister?
As far as what she said?
Did you have any conversations with the defendant, or did you overhear the defendant make any statements about anything in particular that was of concern for you?
Yeah, We were sitting, having breakfast one morning, me, Melissa, Chris, Troy, and there's another waitress sitting there, Diane. She was a friend of mine. She'd been working with me for a while, and we were all sitting there eating breakfast, just having a conversation, talking about whatever. And then all of a sudden, Chris pops off with, well, I know how to get rid of a body if I need to. And me, Diane, and Troy looked at each other like, what? Because we were just talking nonsense about silly little stuff or about the news of the day or whatever, just cutting up laughing. And then all of a sudden, this comment comes out of his mouth.
Okay. And your testimony is you don't recall the context or what happened or what was said before that.
Well, that was the thing. It wasn't like we were talking about being mean to somebody or killing people or nothing. We were just sitting there cutting up about little silly stuff, and then all of a sudden this comment comes out. And we're all like shocked because it's like, where did this comment come from? Why would he say something like that?
Okay. At any point did you ask the defendant about that statement?
Oh, no.
Okay. Do you recall if anybody else asked him about it and if there was a response from him regarding that?
No, nobody said nothing. Everybody was just
I would have asked in
surprised,
the moment.
shocked.
Okay. Now, if Melissa stopped working, you said after that 6-month period at Waffle House, did you see her again after that?
In March, for
Okay.
my birthday.
All right. And what year of March was that?
98.
Okay. All right. So, and would that have been the same time that she would have ended her tenure at the Virginia Highland Waffle House?
I didn't know that she was working at that one because when I saw her that night, she told me she was working at Doraville.
Oh, okay. All right. But was that after she had left the location she was working with you? I'm trying to make
Yeah.
sure. Okay.
Yeah.
All right.
He said Virginia Highland.
Gotcha.
We were on Virginia Avenue.
One moment, Judge.
Yeah, so is Troy alive?
Let me turn your attention back to that. You were talking about a period of time when Melissa and the defendant were, when you came back, they were in a relationship, but it was before they were married. And you have to give a verbal answer. So was that it? That was a yes?
Yes.
Okay.
Sorry.
No problem. Do you recall when Melissa left the residence?
That I don't.
Okay.
That I don't. I don't know when she actually left from home. I know in 95, when I got married in January, she was still at home, but they were dating at that time.
All right. Now, have you, let me ask you this. When was the first time that you had a concern about the whereabouts of your sister, Melissa?
When my dad walked into the Waffle House in February of 99 and asked me where my sister was.
Okay. Why was that a concern for you?
Because Mom, it was right after Mom's birthday. Mom's birthday is February 24th. If my sister didn't go see my mom, call my mom, or send her a card for my birthday, then something was wrong. Because Melissa always called Mom or got in touch with Mom or something on her birthday. Always. She never forgot Mom's birthday. I did. but she always remembered Mom's birthday.
Okay. And so this is February of 99. After he comes into the restaurant, what do you do after that?
Nothing. I just was like, I was surprised. I remember I called my grandmother and asked her why Dad was looking for Melissa. Because at the time he came in, it was lunchtime, so I was kind of busy. So I couldn't really sit down and talk to him and have a long conversation about what was going on. He just came in and said, "Where's your sister?" And I was like, "I don't know, why?" He said, "Well, I went to go look for her and I can't find her nowhere. Nobody knows where she is." I said, "Well, Dad, she doesn't work."
Just a moment, ma'am. Mr. Bossett.
I can move on with the additional questions.
And just as a reminder, ma'am, we generally, unless we're asking you to not necessarily tell us what other people told you, unless we specifically ask you about that, okay?
Okay.
Thank you. Go ahead, Mr. Bossett.
At any point, do you make any efforts to locate Melissa?
Well, I knew that they were looking, so I myself didn't.
And when you say they, who are you referring to?
Mom and Dad.
All right. And specifically, did you make any attempts to reach out to law enforcement or anything of that nature?
I did, but it wasn't until 2015.
Okay. And how did you go about that process of reaching out to law enforcement in 2015?
Well, the thing is, in 2015, you know, there was a lot of the ID discovery shows. I kind of got addicted to them, and we already knew by then that Melissa had passed. So I kind of got angry, and that's when I really started trying to reach out to them and push.
Okay, so these are shows where crimes are being solved?
Uh-huh.
Okay. All right, so you started trying to reach out. Who you started trying to reach out to?
City of Atlanta, or anybody that would listen. Nobody wanted to really talk.
All right. And are you aware of any investigator was working on that case at that time?
It was Calhoun at that time.
All right. How did you come to find out about the particular officer involved?
Actually, Calhoun, we had already talked to him before that. It was, I think, 2003, I think it was, when we talked to him.
Okay. And 2003, was there anything else of significance that happened in 2003?
That was when we found out that she was dead.
Okay. Well, anything prior to that?
That was the same time that my dad was arrested.
All right. And what was he arrested for?
Murder.
All right. And so, does your dad's arrest for murder, does that happen before or after you find out that Melissa was the identity of the remains?
Actually, it was the same time
Okay.
that I was notified.
I see. Okay. But do you recall that as being the same year?
Yeah.
2003?
Same year, same day.
All right. And from that 2015 period up to, I guess, the point that we are now, did you make any additional attempts to contact law
Oh,
enforcement?
yeah. I
and
tried.
Who did you contact and how many times did you try to do that?
Every time, well, 2015 was when I decided I was going to get the folder, the file on Melissa.
I'm sorry, what was that?
I was trying to get the file on Melissa.
Okay.
On the case. I had problems getting it. I filed the Open Records Act probably 3 times. And they kept sending me emails back saying, no, they couldn't find the file. There wasn't a file.
Okay. And how many times did you attempt to do that?
That was 3 times then.
And what age? You said Atlanta Police Department you were to? Mm-hmm. Okay. All right.
Yes. Sorry.
All right. Did you do anything else besides that? Try to get the open records request?
Yes. After the 3rd time, I had come down here the 3rd time in person and filed it. I'd already talked to somebody with Henry County Sheriff's Department that came to the restaurant where I ate at. And he said, well, if there's a file. Okay.
You can't say what someone else said.
Yeah. He just gave me a suggestion about what to do about the file.
All right.
I'm going to object to relevance, Your Honor.
I'm going to allow it. Overruled. Go ahead.
Okay. Did you reach out to anyone that wasn't with law enforcement?
Yes.
And
Well, no, she's really with law enforcement.
okay, all right. And did you continue to do that throughout that period of 2015?
Anybody who would listen to the story I told.
Did you conduct any interviews with any reporters or anything related to this story?
Of course.
Okay. And what was the point or purpose of you doing that?
Getting Melissa's story told.
And why were you trying to do that?
Because we wanted answers about her murder. We wanted an arrest.
Okay. Now, did you and Melissa have any conflict as you were growing up?
Of course. I mean, we were sisters.
Okay.
There's always some kind of conflict.
All right.
Nothing life-changing.
And the two instances where you were testifying as to the encounter that you had with the defendant at Waffle House and then at the residence, is that the only encounter that you had with this defendant?
Yeah.
All right. That's all I have, Judge.
Thank you. Mr. McDermott?
Oh, we're getting crossed today. I was thinking the same. I was going to say I'm going to have to start on time tomorrow if we get cross starting tomorrow. Lots of questions right now.
You've spoken to the press and media a lot of times, haven't you?
Of course.
Uh-oh.
One of the things you've said is you've described how you and Melissa are kind of polar opposites.
Yes, we were.
She was a quiet, shy, reserved.
Yes.
And you are not quiet, shy,
Right.
reserved.
No, not at all. I'm
You
pretty
describe yourself
outspoken.
a little bit more rebellious
Yes.
when you were younger. Did you describe a period earlier that you had left for a couple years and didn't talk to your mom?
Yes.
And you previously told detectives that you couldn't talk to your mother. You just didn't get along with her.
I didn't get along with her for quite a while.
Okay. You described yourself as a daddy's girl.
I was.
And Melissa as a mama's girl.
Yeah.
Okay.
Exactly.
Now, let's just talk about this briefly. You've been in a little bit of trouble yourself too, haven't you?
Yes.
You were most recently convicted for possession of methamphetamines, is that correct? And that was in 2021?
Yes.
And did you have a similar charge in 2022 or 2020?
Yes.
Okay. Did you have previous drug charges before that?
No.
Okay. Do you remember telling Detective Calhoun that Christopher worked for your dad at one time?
He did.
Would that have been a very
short time?
It was a very short time, but it was very early in their relationship, wasn't it? What did you say, like 95 or so?
No, probably before that.
Okay. And what did Christopher do for you?
Well, my dad was a roofer.
Okay.
He had a roofing company, so.
He spent a good bit of time up on the roof then, didn't he?
Yeah.
And Christopher would have been there with him.
Yeah.
And so Christopher would have spent a good bit of time with your dad at that time.
Probably.
For however long it lasted.
Yeah.
Okay.
But a lot of times, Dad would go to other job sites and stuff too.
Now, you just described that you didn't know to be worried about Melissa until your dad came into the Waffle House where you worked.
Yes, sir.
And you said that was in February of '99.
Yes.
And that would have been right after your mother's birthday, is that correct?
Right.
And did your mom and dad come up there together?
No, it was just Dad.
Just your dad. And that's when he asked you about where's your sister?
Mm-hmm.
And
Yes, sir.
she didn't call it Christmas.
Right.
And she didn't call for your mom's birthday.
Right.
And that's when you said, wait a minute, something's wrong.
Right.
And What did you do after that?
I waited to see if mom and dad would find her because that's what they were going to do. They were going to look for her. I was working night shift. It was hard for me to look for her.
And it was hard for you to look for her. And how long was it before you actually did start to look for her?
I couldn't look for him by the time 2003 came around and we found out she was dead. It wasn't until later that I started trying to do something.
I see. Do you remember saying to Detective Calhoun that after Carl came up to look for you at your old Waffle House, you went up to Brookline?
No.
That
was way before that I went to Brookline.
If I showed you a transcript of your interview with Mr. Calhoun, would that refresh your recollection?
Probably.
Shout out to Tabiz TV dropping 10 gifted subs in the chat. Big love to Tabiz.
Yes.
Tabizzle, I like that.
My cause is a small friend.
Very small.
I think it's
Maybe. But I have glasses on, so it's okay.
All right, now witness 4, we're getting impeachment. We're getting some refreshment.
Oh, yeah. Okay.
So does that refresh your recollection?
Yeah, it does.
So you did go up to Brookline after your dad came?
Yeah, because Dad wasn't exactly sure. He had a different address for him than where they actually were. I think the address he had for him was Washington Avenue, I think. It wasn't Brookline.
Do you remember also telling Detective Calhoun that when all this stuff first happened, I went up to the West End to Brookline and knocked on the door?
Before what happened?
Those were your words. You talked to an aunt or a cousin there?
Aunt or a cousin? No, I never talked to an aunt or a cousin.
If I showed you a transcript, would that refresh your recollection?
The transcript. Oh.
Where?
It's a long time ago, but you're so sure sometimes.
No, I presume I don't have to keep asking.
You do not. Thank you.
I don't remember that. No, I don't remember that.
That doesn't refresh you?
No, I don't remember that.
You deny saying that?
I don't remember saying that.
You deny?
I don't remember. I know that I don't remember ever knocking on a door and a cousin or something like that answering the door.
You remember that house?
I know I went to Brookline after I saw my dad.
Do you remember the house that Christopher and Melissa lived in was a duplex?
Yeah.
And that their relatives lived in the second?
There was a uncle or something that was deaf that lived on one side of Chris and Melissa.
So do you not deny
blind.
making this statement that you talked to somebody at the house?
I don't remember talking to anybody at the house, but I know I went to Brookline, but I don't remember saying to Calhoun that I talked to somebody.
Okay, I just need you to focus on my question. I know you don't remember now, but I'm asking, do you deny saying it?
Hang on, there's an objection, so just one moment.
The witness has answered the question. He's demanding an acceptance or denial. She simply stated she doesn't recall. So I don't think she's at a position where she's ready to say, I deny it, because she doesn't remember. She doesn't remember.
I'll move
She's
on.
answered the question.
I'll move on.
Mr. McDermott,
I'll move on.
go ahead.
Do you remember Detective Calhoun asking you about your father, and could he have had anything to do with Melissa?
Yes, I do.
And do you remember saying, no, he's mellowed out as he got older?
I don't think that was exactly what I said, but I know I told him that there was no way it had anything to do with my dad and that my dad would not do that. Actually, I took offense to it.
Do you remember also telling Calhoun immediately after that you and your sister and your mother were the most important things in his life?
In whose life? My dad's?
Yes.
Yeah.
And do you remember saying that he would kill anybody for you?
For us, yes.
If anybody was messing with you, they were gone?
Yeah.
That was all it was. And do you remember telling Calhoun it didn't matter who it was?
That's true.
Does that sound like a man who had mellowed out?
Your Honor, objection. The question initially was speculative in nature, or was asking a speculative question. I think he's coming back to what she thinks her father could or couldn't have done, and I'm objecting to the form of the question.
I'm going to sustain the objection to the form of the question, and you can rephrase it, sir.
I'll move on, Your Honor. You have stated that through the period that you knew Melissa at the Waffle House and whatnot, that you worked hard to get Melissa away from Christopher.
Yes, I did.
And you said that you didn't like him?
No.
And that nobody in your family liked him?
No, we didn't.
Do you remember saying that to Detective Calhoun?
Yes, I do.
Do you remember telling him, do you remember saying on a podcast that Mom and Dad don't even know how much I tried to get Melissa away from Chris behind closed doors?
Yes, I do.
And you did all that while you were working at Waffle House. And you persuaded her to come live with you for 2 weeks, right?
Right.
And you said just a while ago on direct testimony that you claimed that she left your house because she wanted to go see her kids.
She wanted to go back home to her kids after a week.
After a week. And that's when you took her.
Must have been 2 weeks.
And you took her back up to Brookline.
Yeah.
And are you aware that her kids didn't live with her at Brookline?
They were always there when I went. Anytime I saw her at Brookline, they were there.
You were aware that at that time she didn't have custody of those children?
No, I wasn't aware of that.
Do you remember? Do you remember Detective Calhoun telling you that she didn't have custody of her children at that time?
Hang on, yeah, thank you. Mr. McDermott, response?
It's not being offered for the truth of the matter asserted. It's being offered to her recollection that it was said to her and what her reaction was.
I'm going to overrule the objection. Go ahead.
You remember telling Detective Calhoun that she wouldn't just up and disappear on her kids like that.
I do remember saying that.
And he told you she didn't have custody of them.
I don't remember that exactly. But I know he said something to me about the kids.
If I showed you a transcript of that discussion, would it refresh your recollection?
Yeah. Where? Okay. But I didn't know that.
And this interview was in 2003, correct?
Yes.
So you've known since 2003 that she didn't have custody of her children, correct?
That's what I was told.
So.
And I learned.
Your testimony here today still is that you took her back to Brookline so she could see her children.
That's what she told me she wanted to go back to Brookline for, was because of her kids.
Because of her kids. Okay, thank you. You said that Melissa was actually close to Troy, your boyfriend.
No.
Do you remember telling Detective Calhoun that that was one of the few people she was close to?
No, I don't remember saying that. If I showed you a transcript of that, would it refresh your recollection? Yeah. Where?
I was gonna say, just go through the transcript.
Okay.
Does that refresh your recollection?
Not really.
Do you remember telling Detective Calhoun that she was also close to your husband David at the time?
I kind of, a little bit remember that. Something about David.
Is that David Burns?
Yeah.
And where is he today?
Hopefully in jail.
And why was he sent to jail?
For molesting my daughter.
What is going on with this family?
Do you remember, obviously I've asked you several times if you remember talking to Detective Calhoun in 2003.
Mm-hmm.
Do you remember in that interview that he asked you when was the last time you saw Melissa?
Yeah.
Yeah. And do you remember telling him, similar to the story you told here a while ago, that it was in March on your birthday?
It was March, the same week of my birthday.
The same week of your birthday. And you remember that clearly because?
Because it was my birthday and she brought me a cake.
And she brought you a birthday cookie.
Yep.
And you worked at the Waffle House by the airport, and the WWE wrestlers came in on that night.
Yeah. I remember that.
And you and Melissa were both WWE fans.
Yeah.
And you said that she just missed them that night.
Yeah.
Okay. You remember telling Detective Calhoun that that was in March of 1999?
I don't remember saying 99, but I was probably confused about the year because it was 98. 99 was when she was found.
But you agree with me that she was not found until April 29th?
Yeah.
All right, guys. We're going to do a little pause for a surprise here. Very excited. Hello, Doug.
Hey, Kat, how are you? Maybe I should turn this sideways with that. Oh, that's better.
Oh my gosh, you're
That's
so much
better.
better at this than Fulton County and the defense team in this case that we're watching right now.
Don Samuels is an amazing lawyer. Who's the other attorney there?
McDermott?
For the, I don't know
McDermott?
him. For the defense?
I can pull up, maybe you can see it a little bit. He's at the stand right now with the ponytail.
I can't tell if that's someone I know or not. Anyway, Don is
Joel McDermott.
fantastic. Oh yeah, I don't know him. I don't
All
know
right,
him.
so we'll have to see. Next time you'll see him, you'll be like, oh.
Oh yeah, I saw you on the TV.
It's wonderful to see you outside getting some fresh air. The chat is showing a ton of love.
Yeah, thank you guys.
We know you're
I
going to be
can't see
hanging
the
out with
chat at the
Justice
moment.
Served.
Oh yeah, 6. I told them. Yeah, I mean, I came on all these things after I won YSL, right? So I'd kind of be a coward to not show my face after I lost a humongously lost the case.
Aside from, and you're well aware of the Twitter discourse on
Oh, am I
public defenders,
freezing?
and no, you're fine actually. I can hear your voice. Your picture's freezing. Say something. Oh, maybe you are freezing.
Hold on, now I'm. Yeah. Hello, hello. Can you hear me now?
Yeah, I can hear you. You just
Okay,
froze
I'm
a
sorry
little
about
bit.
that. Okay, yeah, we're all good now. I went off Wi-Fi because I think it was causing me trouble. I'm sorry. Go ahead.
As
The
it does.
discourse about public defenders on Twitter.
I think you had, like, this case, this timing is beautiful to show you did great work advocating for your client, and we're in the midst of this viral conversation about how attorneys shouldn't be representing people that are accused of horrific things, and just a head shaker.
Oh my God, it's a head shaker on so many levels. Like, if they did not have an attorney representing them, you couldn't try the case. I mean, for one thing. For another thing, okay, let's play devil's advocate. Say someone did a terrible thing and they had a really bad attorney and they didn't have the best prosecutor. What you'd end up with is a case, let's say they get convicted. You'd have a case riddled with errors that would get overturned on appeal. So if you've got a couple of attorneys in there that know what they're doing and you really think someone went and did this terrible thing and how can you represent them? At least, hopefully, you'll have a case tried pretty cleanly. So that if there is, and I'm going to use a Brian Steeleism, God forbid, if there is, God forbid, a verdict against that individual, maybe it'll hold
stick.
up on appeal for the state. So, I mean,
Yeah, I agree.
I
You
don't
want
get
the
the
good
whole
attorneying.
thing. Yeah, you want the good attorney. You want the good attorney.
We might have to do a panel rant again, get a bunch of people on, because the discourse has continued over a couple days, and I think the timing of your representation of Kassotis going to trial is right in the middle of that discourse. But I do have one YSL question.
Sure.
And we never got to do an interview. Max got busy or wanted to avoid you. What happened with that 40...
He's intimidated by my intellect, so I understand.
Definitely.
Yeah.
What happened with that 40-second Detective Thorpe appearance on the stand?
Oh, God.
When he gets back up on the stand.
I don't even remember what you're talking about. Give me more context and maybe it'll trigger my mind.
All right. So there were arguments about Thorpe coming back to the stand. He had already testified. The state wanted to bring him back up. There were some arguments before he gets up there. And then all of a sudden he's there. The state asks 2 questions of him and they say he's done. And Thorpe looks confused. And you said it was an underrated, one of the biggest victories behind the scenes.
Oh, crap. Next time you give me a heads up and I'll try to figure out what it's about. And
we'll
go
get
back
a tweet
and
from you.
I think you know what I need? If you can find a clip from Thugger Daily or a YouTube clip or something so that I can
just
look
want to
back
see
on
his
it.
face stumped.
Or as a witness, I would say, do you have anything that could refresh my memory? Because that's what I need. Because I don't remember that.
I'll do a quick search, but while I look for it, I mean, I'd like, and again, if you can't answer whatever, just let us know.
I will.
How did you feel about the state deferring openings in the Kassotis case?
I have to admit that I was half expecting it. So half expecting it, meaning I was prepared that she might do that. She's a pretty straightforward prosecutor and didn't play a lot of games with me, but she's going to try to get advantages in court. So it was fine. I was prepared to go. Obviously, I would like to go last. I don't want to go first. But in Georgia, the prosecution has a lot of advantages they don't have in other places. So, for example, this prosecutor in this case is from New York City. In New York City, the defense gets to go last in closing. So I would have loved to have gone last in closing. There are things I didn't address because I wasn't sure exactly what she would say in closing. And I didn't want to, I don't know what the right word is. I didn't want to address something that could be advantageous for her that I wasn't sure she was going to address herself.
So I actually, since we're on that subject, I think she very clearly went through the issues with the shovel and the deer hunting kit, maybe not in response to your motion for a directed verdict, but the judge's commentary that he had some concerns about the sufficiency of the evidence behind those 2 counts. And I think she adapted on her feet to make sure she hammered that in closing.
She's a very good lawyer and a very good prosecutor, and she did adapt. And then the other thing that she did that I wasn't sure if she would do it or not, which is, honestly, I don't think there's any really decent motive behind Kassotis's alleged murder. I'm gonna keep saying alleged murder of his wife. None of the motives that were presented in opening did I think were compelling. And then, how do I put this? There was more she could have done with the third wife, Sam, that she didn't do. So I thought that because she didn't do that, she may not necessarily go with the theory that Mr. Kassotis murdered his wife in an act of rage, finding out she wasn't pregnant, because there wasn't any testimony that he found out she was faking her pregnancy. But anyway, she did end up going there. So I didn't address that in my closing because I was not sure if it would come up in her closing, because it was not a theory that had been even hinted at during the course of the trial. So I wish I could have gone last.
She barely made a mention of it in opening. I had to re-listen to it last night to realize that she made a mention of the 3. And I looked at the ME too. The ME talked about it for 10 seconds, refers to it as defects consistent with something sharp. There's nothing in evidence suggesting that the ME determined they were stab wounds or punctures of any sort. But then in
Right.
closing, she drove the point home that it was an angry to the belly.
Yeah. The
And
jury
you did
jumped a
not
little
have a
bit
chance
on
to get
that.
back up there.
Yeah, I couldn't respond. I mean, I hate not being able to respond. And the way she did that, the jurors reacted with some degree of shock. I know y'all couldn't see them, but
I jumped
they
on
jumped
stream.
too. The jurors jumped as well.
Did you get to speak with the jurors after? Did you get a sense, like, were they willing to speak with the attorneys at all?
I think they would have been, but the judge did not do what I've seen in the past. He didn't hold them behind and say, hey, you know, the practice of law is a practice and we have to learn and get better. So if you don't mind, if you're interested, would you stay behind in the jury room so the attorneys could speak with you? I thought he was going to do that. He kind of indicated to me he was going to do it, but he never did that. So I chased one down out in the parking lot after they did an interview. There was only one left. I really did. They were doing an interview with Court TV. So I was able to speak to that juror afterward.
Oh, cool. I'll have to go check out, guys. So you did an interview with Court TV, and you think a juror is doing one with Court TV?
No, a juror did one with Court TV.
Already?
I would say roughly 1 o'clock today. I'm bad with time, roughly 1, and then I did one immediately after. I haven't seen that juror's interview with Court TV, but I spoke to that juror after his interview with Court TV.
Oh, and pertinent, we have a question from the chat. Did you see the chat when you stated, because we had questions about the Airbnb owner and the repairs. So pertinent is wondering if you looked at the chat and saw anything.
I did not have the chat on at that point in time. Sometimes I would have the chat on, sometimes I would not. In this trial, your chat was the least cruel to my client. So I would tend to keep yours up because I didn't want my client's feelings to be hurt too much by reading what people were saying about him.
Yeah, I appreciate, one of the things I like about the chat, and I think the chat is independent of me, although I appreciate they hang out with me. I'll watch the conversations between people in this chat where someone will mold and adapt what they're thinking because they're taking in information and perspectives from one another. And I've never felt, during YSL, a lot of the opinions were the same because everyone thought the state was a mess. So we had 150 days to get to that conclusion. But here I'm always really excited to see the chat react to things because some people were guilty out the gate and then were like, wait, they didn't request follow-ups on some of this testing? And then other people were like innocent out the gate, and then something really compelling came from a witness that just stuck with them. And it's just a cool way to see what a potential juror might think of things in the moment, in a knee-jerk reaction.
Yeah, I mean, as you know, and I've said it other times, I'll sometimes watch chats to try to get some kind of feel for how certain testimony is coming across. It's always hard because people in chats are generally true crime watchers. They have different perspectives, I think, than maybe I'm sure they do, than the average juror, but it's the only kind of feedback I can get.
I think the prosecutor,
so I will watch
I
those
wouldn't be
chats
surprised.
at times.
I wouldn't be surprised if the prosecution team is looking at social media feedback, because in closing, I felt like they almost spoke to a true crime audience. And I just, from what I had seen, looking at other opinions, trying to make sure I'm exploring and not stuck with inside my own bubble, is, justice for Mindy. This case is about Mindy. And whereas I personally don't look at cases as being about the victim, I think the convergence of justice for the victim comes from the right process being afforded to the person who's accused and standing trial. Whereas I think...
Yeah. I'm sorry, I don't want to cut you off. Go ahead.
That's okay. No, that's really it.
I mean, I don't disagree with the state. And I tried to say that this case was about Mindy and who, did her in. I hate to say unalive, it's so odd sounding. But who did that to Mindy? It's not about whether or not there's a Jim McIntyre, but it's hard to run away from Jim McIntyre when Jim McIntyre is such a heavy presence. And of course, I don't want to have to put the jury in a position, almost like a Karen Reed-like situation. I don't want to present an alternative theory to a jury. I just want to poke holes in the state. I really do. But I'm afraid the jurors may have been in a position where you either believe there's a Jim McIntyre running around or you believe Nicholas Kassotis did this. And it's hard to believe in Jim McIntyre.
I was going to say that. And We've gone over this a little bit, but to speak your piece, so I'm not speaking for you. The chat wants to know about your thoughts on Nick going on the stand.
Oh, I'm not going to
Or
give
you
my
can speak
thoughts.
generally.
In general, no defense attorney wants their clients to take the stand except in very limited circumstances. And ultimately, it's up to there are very few decisions that, this might surprise some people. There are very few decisions that a client gets to make during the course of a trial. They get to decide whether to plead guilty or not. They get to decide whether to take the stand. There's not many others. So if a client decides to take the stand, that's their constitutional right. And I don't have any control over that one way or the other. I'm not going to get into what I advised Nick Kassotis to do.
There you go. So guys, we got to judge from what we saw play out in court. There we go. I do have just from what you just said, the strategy, attorneys should be in charge of strategy. Obviously, you treat your client as if they're almost part of your strategy team, right? We saw that with Diamante Kendrick, you're side by side. We saw you interacting with Nicholas Kassotis, which is very humanizing. So I love when attorneys do that. But for something like the decision in general to take an affirmative defense of any kind, how much of a say, because that involves essentially an acknowledgement of guilt. I mean, I did the thing, but I'm not culpable because of this other reason. So does a defendant have more say in a call to take an affirmative defense or not?
I would say no. Legally, I would say no. Practically, of course, you're going to let them weigh in on that. But yes, that's the situation. So they can have some say, but ultimately, I'm the one that gets to decide on trial strategy.
Okay, that's actually, thank you for, I didn't know and I always wondered, so thank you for that. Erin got some context. Let's see if this refreshes your recollection.
Okay, let me see.
Erin, also an attorney, by the way. So when we say she's refreshing your recollection, she's not at the trial level. She's in the post-conviction space. Total gem. But she says Thorpe took the stand again on day 156. That was November 5th. So it's just you and Max.
Okay.
Testified he's assigned to Christian McMiller and Darius Ford's investigation, when and where it occurred, and that it is still unsolved. No cross.
Had we been to the bench before that to argue? Yes. I think so. Okay, first of all, what I'm about to tell you is probably completely wrong. But if I'm remembering correctly, there were aspects of the Christian McMiller, Darius Ford investigation that may have involved some of our clients. And perhaps we were able to keep the details out so that when he took the stand, he was incredibly limited on what he could say, if I recall. But I don't know what happened yesterday, let alone November 5th. But I think it was something like that. There was going to be potentially going to be other testimony coming in that Max and I thought was not appropriate to come in and would not have been helpful to our case. And I believe we were able to have the judge rule that it could not come in and that Thorpe could only take the stand and speak that very limited amount. And that's why we didn't have cross or anything else.
He looked so stunned when they told him that was it.
Well, I'm sure they prepped him to go into a lot more detail about it. So, oh my God, that's really, I guess I flushed most of that case from my memory.
I don't think we blame you. I mean, we've recently been doing a rewind. We've been busy covering the Kassotis trial, and we did a self-defense case right before that. But we were doing a YSL reunion, and it's interesting. We all gathered together to watch things, but then all of us are picking up things that we didn't pay attention to before, like Michael Sprinkle subpoenaing a witness to the grand jury without an indictment, which was just like, we never heard about that. I mean, we heard about it, but didn't click. It didn't click to us until we rewatched it.
Mike Sprinkle is a very bright guy, by the way. Very, very bright guy, because Squirrel Brain Thorpe, as I guess as Woody called him, he really botched the entire investigation of the unaliving of Donovan Thomas. He really did. And Sprinkle came the closest to at least putting forth a coherent theory. Thorpe's theory was based solely around a witness who Sprinkle very quickly determined wasn't even at the scene.
Yep.
And Thorpe was like all in on this. So at least Sprinkle's theory was plausible, whereas Thorpe's was just flat out wrong.
Oh man. Yeah, that was the whole time. There's a little more context from Aaron as well. So
Okay, I obviously
I think good for
remember
the
very
chat.
little of it.
And
Don't,
then any
lesson learned, don't ask me about old stuff.
it's not that old, Doug.
It's old for me.
But
I have a
I
limited
use
memory in my 61-year-old brain.
I use a metaphor of, everyone's familiar with retail. You're going shopping at the grocery store. The store is front faced. It looks beautiful. It's fully stocked. Well, if you were to try to put another can on that shelf, you're going to end up pushing a can off further down the line. And that's the way the brain works with memories. Too much going on, trying to put in something else is going to fall off the shelf.
It's a FIFO stack in computer science terms. Okay.
Oh, we got a nerd moment. Certified nerd here from Doug Weinstein.
There you go.
Trials
coming up?
Yeah.
Criminal trials. Yeah, I do. I don't, because criminal defense is this way, I don't know my definitive trial schedule. Sometime in the next few months, I have an assault case coming up. I don't know what you can say on YouTube and what gets bleeped out. Can I speak
Go
freely?
ahead. Go ahead with anything. Yep.
Okay. There's a sexual assault case coming up in South Georgia. Nothing particularly sexy or interesting about it. I have...
That's very a lawyer characterization of a case.
I mean, just, it's a straightforward case. I don't think anything that... Like the Kassotis case, I knew would be very interesting to an audience for months. And I would tell people like briefly about it and no one had even heard of it. But I've got like a sexual assault case. I've got a molestation case coming up, trial coming up, a few things like that. Nothing that I could see being televised or that is in a Fulton County courtroom that's televised on a regular basis.
Well, there we go. And I would imagine the sexual assault case probably won't be streamed anyway. So
no, that won't be streamed. It's in a tiny little town.
Oh, so two reasons. Yeah. Typically, that nature, special victims will end up being more cautious with the media access. I do have a slightly different question, changing subjects. Did you object before opening about the presentation of the Home Depot screenshots? Like there was like screenshots of the Home Depot receipt and overlaid over the surveillance footage of Nicholas Kassotis.
Those can come in as demonstratives. So when they were admitted into evidence, I objected to them coming in as evidence. So they were only admitted as demonstratives and they did not go back. Yeah, they did not go back to the jury. Cool. So there's a number of exhibits you'll see. You'll hear if you paid attention to those tiny little side comments where I would say, no objection as a demonstrative, and then it would come in as a demonstrative.
Cool, good to know. I think that's very sharp. Coming from the civil background, being aware of these things. Do you feel like, your civil practice, and I've learned so much from you when you guest with I'm Not a Lawyer But Mel, and you talked about intellectual property and how that's all geared to protect the consumer's right and impression of who they're purchasing from, what they're purchasing from.
Yeah.
All of that background in the civil space. We get into this trial and there's a lot of records, financial records, the medical records, research that I would typically associate with civil litigation. But then we don't see any records produced. Do you have any thoughts on...
Okay, so Leah, we can talk about that. This was kind of a very dot the I's, cross the T's in the weeds thing. But what happens a lot of times is that there's certain business records that want to be produced during the course of a trial. And in YSL, they just did this the sluggish and most awkward way possible, but they put witnesses on the stand. Yes, this is actually a record that we keep, blah, blah. So instead, what the state did in this case in order to expedite things is they would get certified business records. so that you didn't have to have a witness get on the stand and go through all the authentication portions. So basically they were pre-authenticated. So she was just able to dump them in. And then instead of belaboring all of it in front of the jury, she would just draw off the pertinent portions of those records.
Yeah, it was
How
very
many
efficient,
people
I
just
think, as a
dropped off your
trial.
YouTube because of that boring part about evidence? But yeah, we do
Oh,
that
I
in
don't
civil
know.
a lot. We do that in civil a lot. We do that in civil a lot. So that's a very
Are there
civilly
any
thing.
like civil or criminal cases that, have tuned you in? It doesn't need to be like, obviously, if it's coming across your feed because it's super popular. It can be a nerdy thing that's catching your attention.
I'm not really a crime watcher. I watched, well, this is over. I mean, the last thing I paid attention to was the Diddy trial, which of course was hard to pay attention to because it was, if you wanted to follow it, you had to follow it on X, but that's what I did. And I mostly followed that because of Brian and Nicole being involved, and also because of my belief that it was a bullshit RICO charge, that they had overcharged it. So I kind of followed it for that reason. I don't have anything on my radar at the moment. I've really been distracted by this trial that I just finished. And I have, I'm in the middle of a nasty arbitration between business partners on the civil side that I'm going to have to
Oh,
immediately pivot to tomorrow morning.
no, that does never sound fun.
Yeah,
Litigation, well, being a party to litigation, never fun, never
no,
fun.
no.
Oh, I think one other thing, there's an approach where you could point to a third party culprit, and if you're really going to hammer in, you've got to be ready to present a lot. And here you kind of had Jim, but you leaned more into the lack of investigation paired with what the state presenting being circumstantial evidence. And I mean, we're dealing with GBI, these lack of follow-up requests. We had more than one witness. I remember the toxicologist. She mentioned, well, I asked for that, but they never responded to my
Yeah,
request. Another
yeah.
witness, same thing. And then, in my opinion, Tracy Sands, when he was asked about this and the follow-ups, he passed the buck and said, well, they never followed up. But to me, it was his job. I took it as it was his job to follow up.
It's his team. He's directing all of this. But I think the jury could see him passing the buck too. I don't know what that got me to. But when you lose a trial, and now I've now lost two, I guess. But when you lose a trial, and this is going to happen to me for days. I think about the things that I could have done differently, or the errors that I made. I wish I would have hammered home. I don't know if it would have made a difference. I wish I would have hammered home.
Oh, I think we lost you right after you said you wish you would hammer home.
What were
Still
you
don't
about to
hear
say?
you. There you go.
Can you hear me
We
now?
lost you right
Yeah,
as
I'm
you said
sorry.
hammered home.
No, I'm sorry, because I didn't put the iPhone on focus. I wish that I would have hammered home a little more on the fingernail clippings in the closing. They got these fingernail clippings from Mindy. They said that Emmy said she had defensive wounds. So
Did
here
they
she
do
is with
any
defensive.
testing? I know they didn't find
No,
DNA, but did they test them at all?
zero testing on the fingernail clippings. And
Chat, remember we talked about that.
and I brought it up in cross, but I didn't use it in my closing. So that was a mistake. I should have hit on that some more when I was going through all the stuff they didn't do. And that's a big one. I mean, defensive wounds, and you're not looking at the fingernail clippings.
That's what you hear in trial watchers. Look for that. We hear that in every single trial I've watched. We got the fingernail clippings. We looked under them and saw evidence of this or not, or we tested it. And big TV thing that you expect that actually does play out in real life.
Yeah,
And
and they just ignored the clippings.
And that was so weird to me because he mentioned that when describing we couldn't see the photos, but when describing the photos, he said that they had the tech bags over the hands, and tech bags, he explained that we used the paper because when you use plastic, and interestingly, we're watching a trial where the parts are found in plastic bags, it encourages decomposition and messes with the integrity of the evidence. So we have this testimony from the medical examiner in the Kassotis trial. They prepared the hands for the testing that you would expect to be done. They preserved it. They did the proper steps, but then didn't do any testing.
And they even took the clippings. It's not like they neglected to take the fingernail clippings. They took her fingernail clippings, but then they did. I mean, I'm dying to know what the result would be if they did DNA testing on the fingernail clippings.
Yeah, and we'll never know.
Obviously, I thought rationally, logically, there was reasonable doubt. And so, did I not hammer home how high a burden that was enough? Did I?
Your
don't know.
closing argument was great. I think, like, in unison, the chat, even aside from their own opinion, the people that thought guilty, guilty, guilty were still like, that's great closing. And the people that felt like reasonable doubt, they're like, yes, he's doing great. So there's, and in hindsight, you couldn't rebut. So
no, unfortunately, I couldn't, Kat. Well, I'm gonna have to drop off, Kat.
Yes, we're going to go check
6
you out
o'clock
at
thing.
JSTV. We're going to check you out. Thanks so much for jumping on.
Thanks for having me on, Kat. And I love your feeds during the trial. I'll even watch you on some other trials at times. I'm not
He
gonna say
loves you,
which
chat.
ones. And I love the chat. I love your chat. So, and I love all the support I get. It makes me feel good. So I appreciate that.
Yeah, boost his ego, chat.
There you go. Okay, thank you very much. Thanks,
yes, see
everybody.
you. We'll go watch you at 6.
Okay, it sounds good. Bye.
Muted. Thank you. Look at the chat in unison. Look how quick you guys are. If these mutes were an objection. Thank you, chat. So we're going to, I think, if court ended at 5 o'clock here, we should be able to get through the rest of day 1 of Christopher Wolfenbarger and get over to check out Justice Served TV at 6 o'clock. We'll be hanging out with Tabiz TV at 6:45 on the Mickey Steins case. But yeah, thank you guys so much. I really mean it every time I say I think you guys as a chat, as a whole, you guys are not a monolith. I love the conversations that you have and that you have with me. It's seriously, seriously something that teaches me a ton, brings me joy to hang out with you guys. Yeah, waffle burger. We're not changing to waffle burger. Maybe we'll do waffle burger. But I really, really just, words can't express how much I love you guys. So it's awesome to see Doug up here. Like, look how valuable the chat is. Doug loves this chat too. So I appreciate the vouch from Doug Weinstein. We're going to get back to this case as a planning. I think we're going to start do late starts to continue watching this case so we can skip the hour-plus lunch breaks and these weird slow gaps that they're having. Yeah, too many dismemberment trials going on in Georgia. Who knows? Who knows? Who knows why we're doing this? And I'm going to set up the redirect. So volume should be good. We were in the middle of cross-examination of Taya Mae Patton, who is the sister of Melissa, the deceased. If you're just tuning in now, this is a cold case trial. The death, Melissa went missing around Thanksgiving of 1998. And state has messed up, didn't turn stuff over. Defense is fumbling with the tech. It's a typical Fulton case. I think you'll like it.
But do you remember having that conversation with him that your mother had told you it can't be 99, it had to be 98?
I think that was later on when me and Mom were talking, because at that time I don't think me and Mom were really talking that much.
If I showed you a transcript, would it refresh your memory?
Yeah.
So there's about 9 minutes left here, or maybe a little more.
I do remember her telling me that one time.
And that was before the interview with Texas.
Yeah, there's about 20 minutes left.
No, I think that was not before the interview. I think that was later on. I think she said something to me about it.
If this is a transcript of the interview with Calhoun, and you're telling him about your mom talking to you before that interview.
Mom wasn't with me that day. I went to see Calhoun by myself.
And when you're talking to Calhoun, you said, I talked to my mom yesterday. Isn't that what you just read?
Yeah, that's what I just read, but I think that was a different time.
Do you think?
Different time that I talked to Calhoun. That wasn't the first time that I talked to Calhoun.
But now I'm confused. You gave multiple interviews to Detective Calhoun?
I talked to Calhoun several times.
And this was in 2003, correct?
Right.
Okay. So, as of this interview, you were telling him that you were certain that it was March of 1999, but that you had talked to your mom the day before and she was trying to get you to change your mind. Is that what you just read?
That's what I read, but I don't remember that.
Okay.
I don't.
You were concerned about Melissa when your father came into the Waffle House in East Point in
All right, hold
February
on,
of
that just
1999.
jumped.
You concerned?
That's what I read, but I don't remember that.
Okay.
I don't.
You concerned about Melissa
All right,
when your
long
father
crime
came
jump.
into the Waffle House in East Point in February of 1999.
Mm-hmm.
Is that a yes?
Yes. Thank you. Sorry.
So you were working there in that time frame.
At a different Waffle House, I was. I was at a different Waffle House when Dad came to see me.
You just testified.
At Waffle House. But it wasn't the same Waffle House we worked at.
Okay, I'm going to go back and ask you again for the record. Do you remember stating on a podcast, I didn't get concerned until I was at work one morning at Waffle House in East Point, and here comes my dad walking in the door,
Yeah.
talking about where's your sister?
Yeah.
And that was in February of 1999.
Right?
Okay.
What's the question?
Well, I thought you just told me that you were working in a different Waffle House.
I
when this
was.
happened.
It was the one in East Point, but that wasn't what you said earlier.
So you were working at the Waffle House in East Point.
I don't know
this
why the
time.
feed's doing this.
Okay, that's
Washington Road.
That was my question. And is that where Melissa came to see you?
No.
What Waffle House was that in?
Virginia Avenue.
Okay. And where's the Waffle House in East Point at?
Washington Road.
Washington Road. The one by Spun Divots.
No, that is Virginia Avenue.
Okay.
It's also East Point. There's two East Point
East Point
applications.
Waffle House. I see.
Locations.
When you saw Melissa leave that night, the last time you saw her, was she by herself or with somebody?
She was by herself.
And how did she leave?
She just left in a car.
In a car? Do you remember telling Detective Calhoun she was in a white Ford pickup?
It's possible. They only had two vehicles that I ever saw.
And she was driving the vehicle?
She was driving it.
Do you know who owned that vehicle?
Probably Chris.
Do you remember telling Detective Calhoun that that car was in her name?
There was another car that I think I said was in her name. But that's what she told me.
If I showed you a transcript of that discussion, would you refresh your memory?
There's been a lot of refreshing. Holy moly. But you guys can't hear?
I said, I think.
Well, obviously some of you guys can.
Did you tell Calhoun at that time that you think it's in Chris's name? Or did you tell him that you think it's in Melissa's name?
Well, it says there that I thought it was in Melissa's. So that's probably what I said, but there was another car that was supposed to have been in Melissa's name.
Now, you just told us about an altercation that allegedly occurred between Troy McClendon
Thank you.
and Mr. Wolfenbarger. And you told it a little different than you did the first time. Or at least as you told Detective Calhoun. And I'd like to walk through some of those details.
Okay.
When you testified a while ago, you said that she came back, they came into Waffle House together, is that correct?
Mm-hmm.
Melissa and Chris?
Is that a yes? Yes. Thank
And Melissa walked to the back with you. And she was in tears.
Yes.
And you noted these handprint marks on her neck.
Right.
And you said to her, did Chris do that to you?
Yeah.
And she didn't say anything.
Right.
And you said you went to go do something and she stopped you?
Yeah.
What were you going to go do?
I was going to confront Chris.
Okay. Do you remember telling Detective Calhoun a different version of that story where you asked her, what's wrong with your neck? And she said, Chris tried to choke me.
Probably. I don't remember exactly. That was a long time ago.
But you're testifying under oath here today that she didn't say anything back.
I'm sure when I was walking away, she was trying to stop me, which she would have said something.
But she didn't say anything back when you asked about the neck.
She cried. She didn't have to say anything.
But you told Calhoun that she did respond to you. Correct?
I guess. I mean.
And you said that as you were starting to come out the back, Troy McClendon was coming through the swinging doors to the back.
Yeah.
Yeah. And when you talked to Calhoun, you said you were coming outside and Troy was just coming in the front door.
No. That wasn't what I meant. There's one swinging door between the front and the back. You have to go through.
So you're referring to the front as just the restaurant part?
Right.
Okay. And you remember telling Calhoun that when they came in, Chris sat down at the high top?
No, he sat down in a booth.
If I showed you a transcript, would that refresh your recollection?
Mm-hmm.
Is that a yes?
Yes. Oh, okay. That was when they were coming in the door. When they had come in.
So when they came in, Chris sat down at the high top, correct?
Yes, sir.
And for those without Waffle House lingo, the high top is kind of the bar with the tall stools.
Yes.
I don't need to explain that to an Atlanta jury, I'm sure. But then you said when you came out, you talked to Troy. And then Troy went to confront Chris.
Right.
And then he went over and Chris was in a booth by the window.
Right, because he had moved.
And Melissa was in the seat beside him, correct?
No, Melissa was still in the back. Melissa wasn't out front yet.
If I showed you a transcript, would that refresh your recollection?
Heck yeah. Going all day. Be 9 hours, I think, when we go over to Justice Served and then tape his TV.
Other side of the booth. Okay, yeah.
On the outside of the booth, is that correct?
The other, I probably said the outside,
Other side of the
but
booth.
she was on the opposite side of the table from Chris.
How did she transport from the back suddenly to the table?
Because she went out the back door to go out front. She went the opposite way of where I went. I went straight to the front. She went, there's another door behind the office that goes to the restrooms.
Okay.
So she would have went out that door and went out front trying to beat me to the front. But Troy had stopped me.
And he had to reach across Melissa to slap Chris, is that correct?
He reached across the table to slap Chris.
But he had to reach across Melissa.
I don't remember Melissa sitting on that side. I think it was the other side.
Okay. So you've told different versions of this story, different details as time's
It
gone
was
on.
a
haven't you?
long time ago.
Yeah. You've also told us this story that Christopher just one day blurted out at Waffle House, he knows how to kill somebody and get away with it.
He did.
And you said you had no idea where that phrase came from.
No.
But didn't you just tell us that Christopher used to work and spend the day on the roofs with your father?
And?
And your father was convicted of murders he committed back in 1970s?
So? My dad never said anything like that.
How do you know? Were you on the roof with Chris?
My dad would never say anything like that.
I'm asking you, were you on the roof with Chris?
No, I wasn't.
I'm objecting. I believe this is argumentative. Ms. Witness.
Overruled. Move on, please.
So, just one more time. You were never on the roof with Chris?
No.
You weren't there when he spent time with your father?
No.
And you don't know what your father might have boasted about?
My dad never boasted about what he did.
Not around you, correct?
They never talked about what he did.
You can only talk about what you know, correct?
I know my dad never talked about what they did.
All right. Excuse me, no further questions.
Thank you. Anything else for this witness, Mr. Fossett?
All right, I think they're wrapping it down.
Ms. Patton, When you confronted Chris at the residence, you were testifying previously to dropping Melissa off at the residence. What residence was that?
Brookline.
Okay. And that was still during the 1998 period?
Mm-hmm.
All right. And that,
Yes.
Yes.
Thank you. That's okay.
all right. And if we're talking about the year she was found, the year her skull and remains were found, you recall that as being 1999?
Yes, it was.
All right.
99.
Now, if you could, to the best of your recollection, think back to that period of time when you were working with your sister, and I get the Waffle Houses confused myself, and that's the Virginia Avenue Waffle House, is that right?
Right.
Okay. What year was that?
It was 97 when she worked with me.
All right. And was that the beginning of 97?
It was the end of 97.
Do you recall if it was December, November, October?
Well, it was the end of December. It was the end of the year, but it was March when she came to see me at 98, and she had already left that Waffle House.
All right. And your testimony was that she left right after she got the 6-month vacation check?
Right.
So if she started at the end of 97, would 6 months have taken us to the end of 98?
No, I think it was, how can I explain it? If she started in like September, then would have been September, October, November, December. There would have been 4 months right there. By the time my birthday got there in March, she had already left that Waffle House because she was at the one on, what was it? Doryville. She told me she was at Doryville.
So she would have left, I guess started early enough in 97 to hit 6 months before your birthday in March.
Right.
Okay. Now, you were just testifying as to the events that occurred at Waffle House.
Right.
You just testified about the booth, about the high chair. Have you seen, you would show the transcript before the defense attorney showed you a copy of your statement, the multiple statements.
Right.
Had you seen those transcripts prior to today's date?
No.
You hadn't studied those transcripts?
No.
And we're talking about events that occurred in 1998?
Right.
And are you still testifying to the best of your recollection?
Yes.
All right, that's all I have, Judge.
Mr. McDermott?
No further questions.
Okay. Thank you, ma'am. You may sit down. Is the witness excused? May the witness be excused?
No objection. No objection.
Okay, go ahead, ma'am.
All right, that's it for today, I think, day one.
Counsel, can you all approach for a minute?
Hylton looks like she's speaking here. Let's see if they leave the mics on. So they approached.
For the day. I have 5:15, and so we're going to adjourn for the day. I have a couple of pieces of instruction for you and requests. Let me start by telling you that I need you to be back here tomorrow morning at 9:30. And you'll just follow the same procedure that you followed previously. Now you probably have a little bit more insight about going to the callbacks, and we'll let you into the jury room. So that's 9:30 tomorrow morning. A couple of things that are important. One is we can't proceed unless all of you are here together. So that means whether it's I'm releasing you for the evening or if I'm releasing you to lunch or a break, if you'll try really hard to come back at the designated time, especially if arriving in the morning, because we can't start until everybody's all here together. If you are running late, if something happens, if you missed the shuttle the first go round, that sort of thing, just let us know. Contact my office, send us a quick text or an email, and that way we'll know that you're on your way and that we can accommodate that. Last few things I want to let you know, especially now that you have heard some evidence in the case. I want to remind you that your obligation in this case is to make this decision only based on the evidence that you hear in this courtroom. And so that means that it would not be proper for you to drive by any locations, to go do any of your own research, to look anything up, to do anything like that. It also would not be proper for you to discuss this case with anyone or to allow anyone to discuss it with you or around you, and that includes amongst yourselves until I tell you to actually deliberate the case. Now, lastly, I don't know if there will be media about this case, but I know some of you, maybe more than others, have said you watch local news and that sort of thing. I'm going to ask you to please avoid media. Don't go look anything up about this on social media, and please avoid local media or national media if you can, just in case there is something about this case. Now, should you happen to accidentally encounter something, first of all, stop immediately. And then second of all, let me know that that happened. And probably it will be nothing, but we need to know about anything that you might have seen so that we can decide if any action needs to be taken. Finally, I appreciate your patience and attention to this process, and I will send you home for the evening and see you tomorrow morning at 9:30 a.m. Thank you. Notes and things like that in the jury room when you...
Let's see if Hylton says anything. I also dropped a link to Amy E in the chat. She has a video of someone running away from cops in handcuffs.
Thank you all. You may be seated.
Sounds like a mess.
Anything from the parties that you need me to take up before we adjourn for the day?
Two very short things.
Yes, sir.
One, we were given a rap sheet on a witness, maybe the first witness tomorrow.
It would not be the first witness.
At some point tomorrow. This is the first time I've ever gotten a rap sheet on her. Our entire knowledge of this witness is one sentence in a report that's 183 pages long. So I don't know much about her. I have actually two requests. One, is there any additional information through interviews or whatever? Or is that one sentence all we're going to hear from her?
Regarding who is this person? I think that'd be helpful.
It's a former neighbor who's going to say she heard them fighting. The opening statement seemed to have gone a lot further than that, which means there's some other interviews or statements going on.
Ms. Hylton?
Yes, and I can put.
Can you tell me the name of that witness so our record's clear?
In the discovery, I believe she's named Dorothy Jones.
Okay.
However, her name is actually Dorothy Cooley.
Cooley?
Cooley, Cooley.
Okay.
She resided on Brookline. She was a neighbor of Mr. Wolfenbarger. It appeared, and I apologize, I thought most of this information was in the discovery, so I'm going to apologize for not giving you all of this. So we found her yesterday, Your Honor, interestingly enough, at her job. I did take a moment to speak with her. What we believe her testimony will be is that she lived on Brookline, was a next door neighbor, knew Mr. Wolfenbarger for about 10 years. She would say, and this is not going to come out, but in full disclosure, that they would sit on the porch every day and smoke marijuana. But he was younger than her. She was a little bit older. She was familiar with his Uncle Rick, who also lived at that home as well.
Morty.
That over the course of some time, eventually she started seeing a woman come by the house. She may have saw a baby with this woman once or twice. That she would hear yelling coming from their home. That one time she may have heard like things breaking multiple times, and that she did see on one occasion a black eye. She was the woman was wearing glasses and had a black eye. So that's what she would testify to. I don't think she knew her name. She can describe her. She's familiar with what she looks like. I did show her a picture of Ms. Wolfenbarger to see if this is the same person that we're all talking about. She said she recognized her as a woman that she has seen with Chris. I think she has to work tomorrow, so she'll be here by sometime after 10, so I can make her available so that you can talk to her. But that is the synopsis of, I believe, the information she would provide.
The second thing is, because I was just given a rap sheet, I can't give them notice, pre-trial notice, that some of these convictions are old, but she's got a lot. I'm trying to make my way through the cycles, but there are some felonies that are more than 10 years old, so I'm giving them notice now. I do plan to use those to cross-examine her.
Ms. Hylton?
You're right, I think that's fine. That she's giving notice. Thank you.
Thank you. It seems like we're going to accept that as notice for now. Mr. Samuel, anything else?
I just remember the 1 o'clock thing tomorrow, or the 1:30 hearing tomorrow.
Yes, the 1:30 hearing.
Again, I'm not trying to take priority. If I can just, if maybe we could do lunch sometime around then.
Yeah, I don't know how long, Judge Emerson is usually pretty efficient.
He's going to be very efficient.
But my intention was to target breaking for lunch around 1:15, so that way the jury would be, occupied. You could go downstairs and do whatever you need to do and then be back. And then thank you for reminding me of that, because that might assist the state in having their witnesses ready to go as we proceed through.
I very much appreciate that.
Okay. Anything from the state?
Nothing from the state, Your Honor.
Okay. The only thing I will ask, and this is just a preference, different judges are different ways, but if you can stand up and say, objection, hearsay, objection, argumentative, objection, calls for conclusion, objection, he's badgering a witness, let's keep it to a minimum, right? If we need to have a more fulsome discussion, then I'll probably invite you up here. I'm not going to say you can't make your record that you've made the objection and what the general grounds are. And if the answer is going to be a withdrawn or something, we can do all that. But let's keep our speaking objections. I don't think anybody's trying to get away with anything so far in terms of objections and responses, but let's keep our speaking objections and responses to a minimum. Okay? Anything else? Okay. We are adjourned. It is 5:22. I'll see you guys tomorrow at 9:30.
All right, so that's the end of that. Do you guys remember with YSL, we used to, let me hide these banners and everything and move myself. Do you guys remember with the YSL trial? We would have the feed end, and they'd put up this live view little thing, and we'd have to go and check and make sure, and we'd have to stay on the feed to make sure they didn't come back to argue about something else. And it would happen seemingly like once every 4 days. They would come back, and some craziness would just end up happening. Oh my goodness. Yeah, so I agree. This case looks promising as far as entertainment goes. That was three things that the defense is finding out about today. Sometimes as it's happening on the stand with the Detective Dale. Oh, guys, Fulton County will never change. We have a bunch of stuff, guys. We have 9 minutes before Doug is over on Justice Served TV. I'm going to drop that link one more time, but this will redirect us over there. I'm really excited, you guys. If you haven't checked out Justice Served TV, they're always covering trials. if you go over there and you've never heard of Linda before, I think you'll recognize her when you see her. She used to be on Law and Crime. She tried a ton of high-profile cases, including Aaron Hernandez. Michael is brilliant. I don't think he gets enough credit for running the show, running the tech stuff, but he keeps the show moving. Like emceeing the show, really crams a ton of information into these hour or so shows that they do. So I love it over there. Doug's going to be hanging out. Happily Angry Lawyer, since he's in the chat, he's been talking about wanting to do coverage of the Girardi stuff. So let me get that link again. He finally did some content breaking down the craziness, the shocking scandal and outrage, the untold story of the Girardi Keese bankruptcy. And remember, he's representing Munktunk. He's got a lot of stuff going on, doing post-conviction research in the criminal space. But his background is like the civil, deep dive, record keeping, fights over money, litigation. Oh, and Michael is from Extra Extra. There we go. That's why. That would explain exactly why he's got his skill set. So, Hal Girardi. And guys, if you want to find Happily Angry Lawyer, I still have difficulties searching for him on YouTube. Put Munktunk in the search and he'll come up. But we'll get you, we got to get you to the point where YouTube's recommending you when we type Happily. That'd be crazy. But Happily Angry, you should come up. And then 6:45, we've got Taybiz TV. And then I also saw a case. Dizzy, we're going to be hanging out with Dizzy all day. From here over to Justice Serve TV. Thank you, Dizzy, by the way, for hanging out and giving us so much background on this, what do we call Wolfenbarger? We're going with Wolfenbarger case. But I also just saw this other trial that I have not heard of until today. It's another Fulton County case, and it's a self-defense case, so it's going to be good. We'll stream snipe for a second. Flesh of the Gods is covering it. So that's covered. That's right now. This is a familiar face. So if you can't get enough of Fulton County, make sure you go over to Flesh of the Gods. I believe it's day 1, so. There we go. There we go, you guys. Plenty of content. We're going to start late tomorrow. I don't know, maybe like a noon start and speed up. So sometimes when we've done that for YSL days, we were caught up by like 4 o'clock and we're watching in one speed again. So look for that thumbnail. See you maybe around noon tomorrow for day 2 of Wolfenbarger. You guys have a good one. See you over at JSTV. Bye.